there is our presenters, staff, and students. The Faculty of Law, Northwest University, is honored and privileged to host the colloquium. And I really want to thank Advocate Sikandar Kola, as he is the champion in this regard. And thank you, Sikandar, for making this possible. I know that you are so passionate about ADR. And I also had the opportunity to go through the program, and I'm really impressed with the caliber of presenters that we have on the program. And I'm really hoping and wish that we are going to have robust and fruitful discussions during the course of the day that would result in something tangible that would actually change the course of the law in this field. And all the best for all of you. I wish I could be part of the presentations today, but unfortunately, I have to leave for graduations right now. In the next 30 minutes, the ceremony commences. But I wish you all the best. You are welcome in our faculty, and please feel free, enjoy the discussions today. Thank you very much.
Thank you very much, Dr. Morei. We really appreciate your kind words and for opening our colloquium. If I may, I'd like to invite Professor Mitzi Wiese to address us. Thank you. Thanks, Dr. Morei.
Hi, good morning, everyone. There's a little bit of an echo. Is it fine? Okay. Good morning, everyone. Yes, before we begin, I'd like to take a moment to express our gratitude for your presence here today. That is our participants here in the room and also everyone on the line. Your participation in this colloquium is greatly appreciated, and your contributions will undoubtedly enrich our discussions. The Faculty of Law Research Unit is themed Law, Justice and Sustainability. There are a number of research projects or then sub-themes in the research unit, namely justice in practice, vulnerable societies, environmental change, finance, trade and innovation. And we also proudly host the NRF Chair in Cities Law and Environmental Sustainability. Alternative dispute resolution methods are essential in all of these projects or their sub-themes. The importance of alternative dispute resolution lies in its ability to offer a more efficient, cost-effective and flexible means of resolving disputes while promoting cooperation and preserving relationships. It is a valuable tool in the legal landscape, suitable for a wide range of cases and industries. We are thrilled to have such a diverse and distinguished group of individuals gathered here today to explore and exchange ideas on alternative dispute resolution. This colloquium aims to foster intellectual exchange, stimulate new ideas, and promote collaboration among experts and enthusiasts in the field of alternative dispute resolution. We know that not all our LLB graduates will get articles of clerkship. As a result, Advocate Kola initially initiated this colloquium to provide our students with more information about this area of practice and the vast opportunities available. Over the years, the presenters have ranged from clinical psychologists to legal practitioners, the Department of Justice, and academics. Over the last 3 years, this colloquium has grown from strength to strength. Yes, this year we were yet very satisfied with the number of registrations that we received from across the globe. It includes representatives from the Law Reform Commission, representatives from the Department of Justice and Constitutional Development, judges, magistrates, legal practitioners, mediation practitioners, the Social Justice Foundation, and other NGOs, as well as academics and students from various universities in South Africa. During this colloquium, we will be privileged to hear from esteemed speakers, engage in interactive discussions, and network with peers who share their passion for alternative dispute resolution. We want to acknowledge everyone for being part of the 2023 colloquium. From the research unit side, I want to express my gratitude and congratulate Advocate Sikandar Kola for this wonderful initiative. Sikandar, your passion for ADR and this colloquium is enlightening. Thank you for all of your hard work for bringing everything together. And then, in the absence, I would also like to thank Ms. Reed Venter and Ms. Rita Morei for their hard work to make this colloquium successful. So, everyone, this colloquium is designed to be an interactive and engaging experience. You're encouraged to ask questions, share your insights, and actively participate in the discussions. Feel free to connect with your fellow attendees during breaks and networking sessions. You never know where those connections might lead. I hope you're all going to enjoy this day. Yes, and once again, welcome everyone. Thank you.
Thank you very much, Mitzi. Ladies and gentlemen, without wasting any time, let's introduce our first speaker, Ettian Raubenheimer, colleague from IT. I'm going to can you Ettian, can you just scroll down one page and page up again?
I don't have control of the presentation.
Just a second. Right. Can you just check now, Ettian? Awesome. Thank you, Ettian. If I may, could you please introduce yourself, and then the floor is yours. Thank you very much.
Thank you, Mr. Chair, and thank you for the opportunity to address this colloquium. Let me jump in right immediately. The purpose of my presentation today is to look at, to take a high-level view of how do we go about in regulating mediation. For mediation to be successful, it requires a set of principles and techniques. One of the important aspects that we need to consider in the regulation of mediation is the diversity consistency dilemma, which refers to the tensions between two very important motivating factors, namely diversity in practice through flexibility and innovation, and the establishment of consistent and reliable measures of quality in mediation practice through regulation. The starting point is definitional consistency, which entails the risk of excluding certain mediation practices in search of uniformity. Rule consistency may stifle growth of mediation, inhibit opportunities for innovative development, and resulting in an overly legalized path that arbitration has traversed. Diversity entails a multiplicity of interests relating to consumers, practitioners, service providers, and governments. Consumers, for instance, demand a flexible and responsive process that accommodates their needs and offers quality and accountability in its delivery. The novelty of mediation has the effect that many consumers are uninformed about the process, its qualities, and are unable to judge mediator qualifications and performance. Consumers are furthermore suffering from a lack of information in respect of the diversity of mediation practice, such as facilitative, evaluative, transformative, negotiation-based, and advisory models. Consumers furthermore need assurance about the process, its efficiency, mediator accountability, and enforceability. Accountability requires some degree of transparency and disclosure in the mediation process, combined with appropriate practice and approval standards. There are, however, a number of competing concerns for protecting the integrity of the process through strong confidentiality. And then they got other services and we are just passing them. It seems as if I'm not the only person that's speaking. It's going to go there to inspection.
It doesn't need for me to hear.
No.
Okay.
Just
Is it
Yes, I think.
okay, we're just going to put that blanks and everything up there. Okay. Can somebody just maybe mute the other speakers, please? And also,
yeah, I'm busy just trying to do that. Give me a second.
can I proceed? There are, however, a number of competing concerns for protecting the integrity of the process, such as a strong confidentiality provision, which can reduce mediator accountability. Accountability raises the issue of the obligations of dispute resolution service providers to inform clients about the nature of the dispute resolution process they are entering and the qualification and skills of mediators. When we talk about regulation, we tend to associate it with statutory intervention of some sorts. This association runs the risk of creating a regulatory landscape that is based on simplistic and mechanistic models of economic rationalism, legalism, and government control. Modern regulatory frameworks have moved away from the traditional distinctions between public and private and between regulated and deregulated, and consists of different layers featuring a range of regulatory instruments and stakeholders engaged in dialogue, deliberation, and discussion. This is where a regulatory policy becomes important. Such policy deals with principles, a strategy, or a course of action which provides the outlines of a plan. The plan deals with methods, processes, and principles. the overarching focus is to achieve the goals. One can, for instance, here think of a goal such as relieving the caseload of the courts or reducing the time taken to resolve disputes. Market regulation does not presuppose the absence of law or deregulation. It entails the reduction, removal, or absence of only one type of regulation, such as, for instance, legislation. In such an environment, the laws of supply and demand have a regulatory effect. Other forms of regulation may also be present and may provide a valuable, sustainable, and flexible alternative. The other forms of regulation that I'm referring to would include well-established business or professional practices, industry or professional codes of conduct, and complaints and disciplinary mechanisms. The resultant question is thus not whether mediation should be regulated, but how should mediation appropriately be regulated in the light of the different approaches to regulation, which brings us to two landscapes to be considered, namely the regulatory landscape as well as the mediation landscape. The regulatory landscape presents us with the choice of statutory intervention as a form of public regulation and market regulation as a form of private regulation. There is a third option, namely a hybrid model, which I will discuss later. The mediation landscape deals primarily with the entry points or access points to mediation. In this regard, there's an interplay between private marketplace input and public government input. If we look at the centralized access point, we are referring to court-related mediation, which indicates a trend towards centralized approach to mediation where the court serves as the central access point for mediation services. The primary considerations in this regard is whether providing mediation services is to be considered as, in the first place, an integral part of the justice system and therefore a function of the court, which we refer to as the justice model, or an emerging private sector marketplace for resolving disputes with the courts outsourcing mediation cases, which we refer to as the marketplace model. The justice model, in the justice model, the court refers parties to mediation. The mediation usually occurs in a court building and it is conducted by court-based mediation practitioners. The mediators are drawn from the judiciary, other court personnel, panels of mediators attached to or accredited by the court or community mediation organization. The mediators are chosen and appointed by the court, and the cost of the mediation are treated as cost of the justice system. Examples of such a model we find primarily in civil law jurisdictions such as Germany, Scandinavia, and Slovenia. There are also certain common law jurisdictions that uses this model, such as Singapore. Court-related mediation, the marketplace model, is a private form of court-related mediation. The court in this instance, the court outsources mediation services. The mediators are not employed by the court and are members of a panel of court-approved mediation service providers who set their own fees payable by the disputants. This model favors a straightforward system where the user pays and consequently has a choice of mediator from a panel, but is also free to agree on a mediation service provider who is not on the panel. We find this model predominantly in Australia, Canada, China, Hong Kong, and the United Kingdom and the United States. If we look at the second possibility, and that's decentralized access to mediation, we find that these models move away from the court and away from centralized mediation. The first possibility here is community mediation. The community mediation model is a combination of a high degree of regulation or government support with a decentralized approach. Mediation is widely accessible through community-based mediation organizations and other community organizations, such as shelters for refugees and women, legal centers that are government-sponsored, legal aid, and even the police. Mediators include volunteers, employees of community mediation organizations, and freelance mediations working on contract. In these circumstances, disputants do not necessarily pay for service, and where mediation services are volunteered, the government carries the cost. Although there's a great variety in community mediation practice, most practice models follow an interest-based or transformative approach. The next possibility is private mediation. This model is a combination of decentralized and private and deregulated approach. In this area, private sector organizations and freelance mediators offer fee-for-service mediation. Mediators present a wide variety of professions with a corresponding range of qualifications that depend on organizational and industry requirements and standards. Then we deal with the hybrid models that I referred to previously. As mediation practice develops and becomes more sophisticated and becomes more mature in the market, hybrid models borrow from the previous models that I referred to. Industry-focused mediation schemes can develop with the support of the government, such as industry bodies servicing specific industry. They refer disputes to private mediation institutions. The parties, however, remain free to mediate outside the scheme if they so wish. The intention of such schemes is to boost the use of private mediation. Whereas such schemes may be private in the legal format, they usually have the support of the government, at least at their commencement. In addition, the industry schemes are usually more centralized than decentralized in the sense that an industry body refers to one private mediation organization. Other hybrid models involves a central government authority, which is not a court, that refers disputes to an industry body equipped to conduct mediations. This hybrid model is similar to the marketplace model of court-referred mediation, except that the referrals come from a non-court entity. Do we need a dispute resolution policy? Such a policy refers to a plan and a guiding set of principles to introduce and then roll negotiations or court proceedings are the best way forward. For others, alternative approaches are better suited. Modern dispute resolution policies refer to a set of different dispute resolution mechanisms with varying characteristics to fulfill the differing interests of the citizens in dispute resolution. The availability of sophisticated dispute resolution increases economic prosperity and justice. Economic efficiency will rise when the parties can choose a mechanism that solves their dispute for the lowest cost and creates the most favorable benefits. Do we need a mediation policy? There's empirical research that shows that citizens consistently employ dispute resolution policies or dispute resolution mechanisms that are not best suited for them. Mechanisms do not reflect their real interest. For example, parties might turn to court to solve their disputes, even though both parties prefer to control the outcome and prefer to keep the dispute private. Why does this happen? Traditional practices or advisors favor trials, inadvertently push parties toward court, even though mediation would better suit their interests. Sometimes the regulatory framework favors the specific dispute resolution mechanism. For example, sometimes the way costs are regulated lures parties into regulation, even in litigation, even in situations in which mediation would be cheaper for both parties and the state. In addition, existing regulation of mediation may not be optimal. Even if the parties manage to steer their dispute in the right direction, the outcome might be inefficient or unjust. A good mediation policy helps to avoid these problems relating to choice and equality. A good mediation policy adheres to the following basic principles. The decision-making lies with the parties and not with the mediator. The mediator is neutral. The mediator offers the parties expertise in communication and negotiation support. Mediation is conducted confidentially. And mediation reaches beyond the strict letter of the law to include non-legal interests such as financial, relational, and other priorities of the parties. Distinguishing mediation from other dispute resolution modes. If we follow the functional approach, which is less focused on the technical and doctrinal elements of a particular legal system, we find the following. What matters are the effects and events that follow from legal rules, because the parties are the principal stakeholders of a dispute resolution policy. They should also be the focus of a functional understanding of dispute resolution mechanisms. In other words, in explaining the mediation process and distinguish it from other processes, we need to look at the dispute resolution process from the perspective of the parties and how they experience the mediation, and other processes from a practical point of view. Against this background, dispute resolution mechanisms can be characterized using the following features. Initiation control. Is each party's consent needed to initiate the dispute resolution mechanism? Procedure control. Do the parties determine the procedure? And result content control. Do the parties determine the content of the result of the dispute resolution? These elements furthermore lead to additional aspects, namely result effect control. Do the parties' consent needed? Is the parties' consent needed for the result to be binding? Neutral choice control is, do the parties choose the neutral? And information control, do the parties control the disclosure of information? In other words, is the process private? The regulatory criteria and policy principles. The first one is party autonomy, which places parties at the center of the dispute resolution through mediation. The parties are responsible for their disputes as well as for being in a position to resolve it. The mediator and other third parties assist the parties in solving their disputes. The next very important principle is equality, which requires treating similar situations the same. Party autonomy and equality may conflict, which result in with the result being that policy decisions have to be made that will balance the interests affected. The principle of efficiency aims to maximize the satisfaction of the interests of all involved at the least possible cost. Because citizens expect that their affiliation to a society increases the realization of their interests, Efficiency is an important element of justice, hence the cost-benefit relationship is relevant in policy making. Consequently, the design of dispute resolution mechanism may reflect that certain mechanisms are exceptionally well suited for certain types of disputes. If we look at the scope of the regulation, the regulatory framework can be either general. In other words, you have general mediation laws that extend to all mediation or mediators in a given jurisdiction. Then we have sector-specific regulation, which refers to laws dedicated to mediation in a specific industry or court or mediation program or area of law or other defined context. Then we have an integrated approach, where we have integrated mediation laws that focuses on a particular sector. However, they are not standalone laws. The integrated laws are incorporated into general regulatory instruments dealing with a particular topic. For example, when a court-referred mediation is covered by the applicable civil procedure court statute or rules. The regulatory form deals with the very important initial principle that I refer to, the diversity, consistency, tension. Regulation should be understood as inclusive. It includes hard law, such as legislation, ordinances, case law, and practice directions. It also deals with soft law, such as code of conduct for mediators, institutional mediation rules, and other industry standards, referred to collectively as codification or institutionalization. Then we deal with mediation pledges and clauses. In addition, regulation by private contract and the market laws of supply and demand play an important role in shaping the regulatory landscape for mediation. Generally, soft regulation is more flexible and responsive to changing circumstances than is the case with hard forms of regulation such as legislation. In the early stages of contemporary mediation development, it is useful to consider flexible and responsive forms of regulation along with traditional hard regulatory forms. Soft forms also involve a greater range. In this regard, I can just refer to, for instance, a mediation pledge, which is a statement in which the signatories promise a principled approach to conflict resolution with a stronger focus on mediation. It can be part of a general pledge or a systematic approach to dispute resolution with a focus on alternative dispute resolution. Regulatory content. For content, different aspects of mediation is regulated, falling into the following categories: triggering mechanisms, process and procedure standards, and rights and obligations. When we talk about triggering mechanisms, we are dealing with how is the demand for mediation initiated. Triggering mechanisms include court referrals to mediation, which can be voluntary, mandatory, or in terms of other incentives, mediation information sessions, which incidentally has been used very, very effectively in, for instance, Italy. Mediation clauses, legal requirements to mediate before litigating, corporate mediation pledges, and mediation awareness programs. I just want to take a bit of a detour here, and that is this whole issue of legal requirements to mediate before litigating. In Singapore, they did research on when is the best time to refer a matter to mediation. And the interesting conclusion that they came to was that the best time to refer a matter to mediation is after close of pleadings and when discovery has been completed. This was followed in, for instance, New Jersey, where they stated that you can start your litigation process, but you cannot get into court unless you will not get a court date unless you've you can certify that you've tried mediation and mediation was not successful. Only then can you have access to the court. Due to the newness or the novelty of mediation, people are subject to status quo bias. In other words, they resist change and they prefer the familiar. Therefore, they are reluctant to embrace mediation without incentives or triggers being present. In most common law jurisdictions, a range of incentives, from mediation information sessions to mandatory court mediation referrals, is available to convince disputants to engage in mediation. Australia, Hong Kong, China, and the United Kingdom, there are provisions encouraging parties to reasonably engage in mediation before trial with the penalty costs, even if they fail to do so, even if they are successful eventually. The principle of voluntariness in mediation applies to the agreement of a solution, but not necessarily to the choice to attend the mediation. In civil law countries, they often adhere to the notion that voluntariness in mediation extends to the choice to attend mediation or not. Therefore, there are fewer requirements to attend a mediation, and mediation triggers are generally described as soft, such as awareness programs that I've already referred to in Italy, for instance, also in Austria and Germany, and court referrals only with consent in France. The next aspect is process and procedure. How is the mediation process conducted? In other words, what procedures are used for the internal mediation process, appointment of mediators, payment, and administrative measures. Procedural regulation manages aspects excuse me, of mediation, such as commencement, termination protocols, and the selection and appointment of mediators. And this can be contained in various instruments, such as legislation. An example is the German Mediation Act, ordinances, the Hong Kong Mediation Ordinances, framework regulation like the European Directive on Civil and Commercial Mediation, court practices or court precedents that is found in, for instance, Australia, Canada, and the United Kingdom, and non-legislative standards such as the Australian National Mediator Approval and Practice Standards. And then there's also private contracts. Mediator accreditation here becomes a very important aspect, which could either be voluntary or compulsory. Nothing legally prevents anyone who does not have accreditation from offering mediation services where it is voluntary. Where it is compulsory, the different models is partially compulsory and partially non-compulsory. And the answer lies in an element of self-regulation. After the establishment of the Hong Kong Mediation Accreditation Association in 2023, this body became the premier mediation accreditation body in Hong Kong without any legislative influence. In Hong Kong, for instance, the value of professional accreditation is recognized by the majority of stakeholders, and it has been very efficient. The next aspect is standards. How are mediation practitioner standards and quality assurance measures regulated? The regulation of mediation practitioner standards is referred to as professionalization. It shifts mediation away from being activity requiring life skills to one requiring training, assessment, and certification. The professionalization of mediation tells us who is competent and accountable. Here we look at legislative solutions to professional certification. These are usually expensive and require government organization and financing. Industry regulation is supported by the industry itself with expertise, finance, and other matters. Current best practices focus on developing responsive regulatory solutions for professionalization issues. And then we deal with the rights and obligations. Participants have rights and obligations during mediation and after mediation. Participants includes mediators, parties, and lawyers. Rights and obligations may be regulated in legislation, common law principles, court rules, code of conduct, and private contractual arrangements. The rights and obligations are typically the focus of mediation legislation. General law principles and pronouncements. The duties of mediators are, for instance, impartiality, providing disclosure, conducting the process and giving advice, termination of the mediation, reporting, and rights and duties in relation to the enforceability of mediation clauses and settlements. Duties related to confidentiality and mediation and the admissibility of evidence. The rights and duties of the disputing parties, depending on the legal system, could be to the duty to engage in mediation if it is reasonable to do so, the duty to participate in mediation in good faith, the right to commence court proceedings after a mediation failed, the right to enforce the mediation settlement agreement. That concludes my presentation, Chair.
Presentation, I must say. I have a lot to contribute to the conversation, but I'm going to open the floor for any questions at this stage. Just bear with me and my technological challenges here. Ladies and gentlemen, are there any questions or comments? Thank you very much, Ettian. I'm sorry, I think my mic was switched off there. Can you hear me now? Ettian, thank you very much. Are there any questions, ladies and gentlemen? I have a lot to say on the subject, but there's been a lot of developments through the years, and I believe that we're still far from getting anywhere closer to making alternative dispute resolution work in South Africa. The Law Reform Commission has been working on this project since 1997. Yeah, but that's another chat for another day. I'd probably take the whole day of today's colloquium just responding. But there are some questions. If I can, just bear with me. Mr. Pampiri, thank you for joining us. You have the floor.
Thank you so much, Advocate.
Go ahead, Mr. Pampiri.
Advocate, good morning. Advocate
Good
Ettian.
morning. Good morning.
Yes. Thank you for the insightful presentation and the other models or approaches from other jurisdictions. How far are we as South Africa? Because you touched on policy, you touched on legislation. How practical is a South African case? Of course, we'll know that we still have some way with mediation, but the Singapore case, Australia, UK, what would be the best approach in terms of formalizing? You will know with Rule 43 that formalizing mediation is still a long way. But what would be the better step or first step? Thank you.
Yeah, that's a bit of a difficult question. The fact of the matter is that we are currently very far from it. It would seem as if we are very far from the creation of a regulatory framework. It would seem as if the international direction is towards a hybrid model. Mediation, one should always remember that mediation is a voluntary process and it is based on party autonomy. If one looks at what happened in Italy, and it is probably one of the most interesting case studies to go and do what happened in Italy when and they've gone through the whole continuum. They've had mandatory mediation, then it was struck down by the Constitutional Court, then they had voluntary mediation, and then they went back to mandatory mediation and so forth. I think there's a lot of lessons to be learned from the Italian example. We can also go and look at what happened in Romania, as well as in Singapore. The difficulty that we have is that there's very, very little clinical data available from anywhere in Africa. I think the further important aspect that we have to take into consideration is that we are primarily a common law country. Yes, we've got a hybrid legal system, but we are primarily a common law country. To import civil law examples into our mediation regulatory system, I'm not convinced that that would be the way to go. By saying that, I'm not saying that we should discard that. I think there's certain lessons that we can learn. For instance, with regards to the regulation of mediators, I think there's a lot that we can learn from the example in Austria and also from Italy. What they realized in Italy was, and also in Austria, is one of the primary inhibiting factors for parties to refer matters to mediation was the lack of training of mediators. In Italy, for instance, they initially had mediator training for 40 hours. They realized that that is totally insufficient, and they've increased that to 200 hours now. They did exactly the same in Austria to civil law countries. I think that is a very important aspect. In my interaction with the judiciary, be it either the judges or the magistracy, they seem to hold the view that they're not very eager to refer matters to mediation because of the poor standard of training of mediators. And some magistrates will just flatly tell you there's no way that I'm going to refer anything to mediation because the mediators don't know what they do. I hope that answers your question.
Are we good there, Mr. Pampiri? Thank you very much, Advocate Raubenheimer. Thanks, Mr. Pampiri. Appreciate your question.
Last question, please.
Okay, a quick one, Mr. Pampiri.
Oh, sorry. The role of department, DOJ in this case, we're talking about 40-hour training, which is pretty much standard. And we have specialized mediation, whether it's labor, civil mediation, construction. Part of my dream is to have a community advice office, and you mentioned community mediation. How committed, or do you feel that DOJ and associate stakeholders are in for it in terms of formalizing, having grants for these legal centers or women legal centers? How far is the DOJ or government in this case committed to the cause? Thanks.
I really can't answer that question. I haven't had any interaction with the Department of Justice. Maybe there's somebody from the Department of Justice that can assist us here, but I'm not the right person to answer that question, unfortunately.
Okay, thank you, Advocate.
Thank you very much, Mr. Pampiri. Thank you, Ettian. I have another question. Mr. Pampiri, we can always engage on this topic, and you know my feelings about the DOJ and where we stand at present.
I know very well, yes.
But we'll continue with this conversation another time. Ettian, there's another question from Advocate Nsaluba. Ma'am, you can unmute yourself and you have the floor.
Thank you very much, and thank you to the organizers and to Advocate Raubenheimer. Thank you for the presentation. Mine relates, Advocate, to the practice note that we have to comply with regarding mediation. It's two questions. If then you're saying at the level of judiciary there's less appetite in promoting mediation, besides training, what could be the other reason? Could it be the familiarity with the existing process? Secondly, you know the existence of various mediation formats, both from public and private. What is your view in terms of streamlining mediation into transformative mediation, using the community knowledge of mediation? Because if you go to traditional leadership in the communities, mediation has been a form that has been used over years. If then we borrow from that knowledge base, how do you see us moving mediation to actually to the center, not to as compared to where it is now, and not focus on arbitration, and ensure that mediation is at the center? And what will that do to the clauses of contracts as they prevail? Because we always have that clause, but most of the time we arbitrate, we don't mediate. Thank you, Ettian.
Yes, your reference to the judiciary is, I think that is probably applicable to all legal practitioners, and that is that you will recall I referred specifically to a bias that we all have because of our training, and because we've been doing this for many years. There's very few training institutions where mediation or even ADR is taught, that even in the admission examination for attorneys and advocates, mediation is scantily addressed. So I think there's a possibility for training. The International Finance Corporation did a pilot project in the Balkan states a couple of years ago, and that it was a comprehensive strategy that they followed. One of the very important things that they did is they devised a questionnaire which they distributed amongst the judiciary, and using that questionnaire would render mediation indicators. And when a judge, for instance, completed the questionnaire and the indicators indicated that there were sufficient mediation indicators, the judge could then refer the matter to mediation. Now, obviously, that would entail the possibility of legislative change in South Africa, because judges currently are apprehensive in doing that because of the oath that they take, and the fact that they are there to adjudicate and not to mediate. So I think there's potential there, and we have the example of the Balkan states where it worked wonderfully, apart from the fact that it increased the degree of reference to mediation. And I think it's necessary for us to understand that if the judiciary or if the adjudicators, whether it be judges or magistrates or even arbitrators, start referring matters to mediation, that will start creating a confidence in the process. Now, in the Balkan states, that resulted in huge amounts of matters being referred to mediation. But apart from that, it also increased the mediation success rate. Now, in this regard, we need to understand that mediation is not necessarily successful when the parties settle. That is one success factor that is applicable. But mediation can also be successful if the parties enter into agreements that shortens the process. So we need to take an integrated look at dispute resolution. In South Africa currently, we don't have a very integrated look at dispute resolution. Now, what we need to understand is dispute resolution has become immensely complex. And that's why at the beginning of my speech, I referred to this dichotomy that we have. And we need to look at dispute resolution from a different perspective. There is no one size fits all. That with regards to your first question. Your second question deals with the whole issue of community mediation. I think my cursory view of this is that there's an immense amount of power in community dispute resolution. And in this regard, it's interesting to go and have a look at what happened in China. Mediation has been part of Chinese culture for centuries. And they had mediation committees and community mediation centers for centuries. The interesting thing is when China went through their cultural revolution, these mediation centers were captured by the communist regime, and mediation nearly died out in China. The current Chinese government has revitalized it, and it's immensely successful because they tapped into that resource, which is an inherent community resource. And based on that and the experience in Africa of mediation, I would want to think that mediation has a huge potential on a community level. There's certain aspects that cannot go for community mediation, but it has a place, and I think it has a very important place and a role to play.
Thank you very much for that, Ettian, and thank you very much for your question, man. We really appreciate your presentation, and as you can see, ladies and gentlemen, this has been a struggle. It, like they say, the wheels of justice move very slow. It's going to take us a while to get this up and running, but we are creating the conversation, and I think the legislation is there, the rules have been implemented in our courts, the lower courts and the higher courts, and yeah, we almost there, but the challenge persists. Ettian, thank you so much for your presentation. We really appreciate it. Would like to invite our next presenter, Advocate Bodasing. Sandra, you have the floor. We'd like you to introduce yourself first, and we apologize, we're running a little late. I'm going to give you some, bear with me, I'm going to give you sharing rights then. Shara?
Yes. Hello.
You have given rights. You may go ahead, ma'am. Thank you very much.
Thank you. I don't feel that I have I'm not able to move it yet. Anyway, while you are busy with that, I can just begin with some introductory remarks. So greetings, everybody from Durban. My name is Ishara Bodasing, and following on Advocate Raubenheimer's observations, I would just like to take this opportunity at the outset to share with you some information on two bodies on which I sit. The first is the ADRPSA, which is the Association for Dispute Resolution Practitioners of South Africa. And the main, it's a newly established body, and its main purpose is to position itself as an industry association for purposes of serving, supporting, and representing the dispute resolution industry in South Africa. Its main objectives are to promote the quality and standards of dispute resolution practice in South Africa, and to also recognize education and training which qualifies a person for professional registration. We also aim to perform such functions as a professional body as is required to do so under the NQF National Qualifications Framework. And we also plan to register as a professional body with SAQA. And basically it was to exercise authority in respect of all matters affecting the standard of professional conduct of persons in dispute resolution practice who have been registered with the ADRPSA. The other body that I sit on, which is the only provincial body in the country, it is the KZN Society of Mediators. And here we have formed a voluntary association with membership of the society being open to all mediators who operate in KwaZulu-Natal and who subscribe to certain accreditation standards. And here too, the objectives are to create a centralized platform for and of mediators to advance and promote mediation, ethical standards and integrity. And so just to inform you, based on Advocate Raubenheimer's observations, that there are some bodies that are afoot to address some of the concerns he has raised. You let me know, Sikandar, when I can start moving into the presentation. Or you can keep it, I will just ask you when to change the slides. Maybe we can just continue. So you can maybe go to the first slide of the presentation. The next slide, please. Thank you. So to begin, on the 9th of March, 2020, South Africa strode into the world of High Court aligned civil mediation as Rule 41A came into effect. This was quite a laudable shift, even though you have heard that in many other jurisdictions, such a provision already exists in their rules. For example, in the United Kingdom, the Court of Appeal has mediation panels associated with their functioning. So just to ensure before I carry on that we all understand what is mediation. So mediation is a facilitated negotiation which is conducted by an accredited, neutral, and impartial mediator with a view to achieving settlement. And this is as opposed to an adjudicative process where an arbitrator or a judge makes a decision for the parties. So in my practice, I have sometimes had to deal with the difficulty that it is not just the clients, but also their legal representatives themselves who don't fully comprehend the distinctions among mediation, arbitration, adjudication, and litigation. So we all know what litigation means. And I just want to make some comments on this from the perspective of our topic. Litigation takes a long time to bring a matter to finality. And this protracted delay is usually accompanied by an exorbitant bill. In the case of MB versus NB, a 2010 case, also known as the Brownlee case, the South Gauteng High Court held that litigation is very expensive and that the parties should have explored cheaper means of resolving their dispute. So the court strongly recommended that the parties should have used mediation as a means to resolve their dispute in order to save costs to their estates. And for the first time, a judge, in this case it was Judge Brassi, imposed a costs sanction as a direct consequence of failure to mediate. And interestingly enough, the sanction in this case was imposed not on the parties, but on their lawyers. So arbitration, it's a quasi-judicial method for resolving disputes outside the court. It's usually heard pursuant to a written agreement between the parties of a dispute. You have an independent and impartial third party, the arbitrator, who is chosen directly by the parties and who hears both sides of the dispute and makes an award, which the parties undertake to accept as final and binding. Now, in mediation, a third party is involved who acts as a facilitator. So in a typical mediation, there is almost always a win-win situation. So mediation is an ADR mechanism. ADR in my vocabulary stands for appropriate dispute resolution. It is non-adjudicative and it's conducted by an impartial third party who assists the disputants to reach a mutual agreement. So mediation is not a new process in South Africa. For example, many employment disputes have actually been mediated since the 80s, and particularly through the CCMA since the mid-90s. And we also have in place rules for court annexed mediation in the magistrates court. Next slide, please. Thank you. So mediation has become an option in many fora, as you've heard from Advocate Raubenheimer. But in South Africa, the introduction of Rule 41A has given impetus for a sea change from civil litigation to mediation. And lawyers themselves are well placed generally because a litigator who has been in the litigation game for some time will be able to assist their client and the mediator, in fact, on what the likely outcome will be, mainly based on what their experiences have been of matters that don't settle. So what does Rule 41A address? So with the advent of Rule 41A, not only are legal practitioners obliged to canvass the idea of mediation with their clients at the inception of the litigation process, if not earlier, Rule 41A now invites judges and Rule 37 case management judges to do the same as litigation proceedings progress. So any consideration of mediation must always be given against the backdrop of what is in the best interests of your client insofar as the resolution of their matter is concerned. However, for lawyers, mediation is not always a simple choice. There are many practical reasons, not only as regards lawyers asking when and how they will get their fees. So it's challenging to decide when and how to raise mediation with clients, particularly in urgent matters. What is the best timing for mediation in the context of a particular dispute? And when and how to approach the other side with a proposal to mediate. So some clients are sensitive or even become suspicious, especially at the start of a dispute. If you as a lawyer say, right, you've had a fallout, let's discuss trying to settle your differences through mediation. So often that's a difficult discussion to have, especially if you have a heated or a belligerent client. So from my experience, timing is everything when it comes to mediation. We sometimes assume that any time is the right time. And from your own experience as lawyers, you will know that in litigation, some conflicts develop in such a way that we have to think strategically about when is the ideal moment to consider or initiate a settlement. Now, to take this a step further, we also know as litigators that broaching mediation with your opponents is easier said than done. I have faced situations where my client has asked, if we suggest settlement at this point, then they will think that we're not confident with our case. So these are some of the reasons why, as lawyers, you might not find it easy to take that first step towards mediation. So before Rule 41A came into force, there was quite a buzz about its formulation and imminent promulgation. And I know some lawyers who said, so I must consider mediation, but I really don't have time for that. We'll simply tick a box to say yay or nay. And my response to that is, as a professional and as an officer of the court, that attitude flies in the face of one's ethical duties to the client and one's professional responsibility. So I know that what many of you as legal practitioners really want to know is, what does the rule actually change? And perhaps you've also thought, well, I'll just indicate that my clients are interested in mediation, even though we are not, because the rule doesn't carry any sanction or immediate obligation. And look, there's always such a risk when a new rule comes into force. And in my opinion, there are safeguards within the rule's construction, which as you learn to implement it, you will come to realize that it's a significant rule that will be a game changer, or already is a game changer in the sphere of civil litigation. So why must lawyers take it seriously? Next slide, please. So Rule 41A's requirements. The rule says that when you initiate litigation, be it in the form of an action or an application, for example, issuing summons in an action, you have to complete a special form, which is called Form 27, to indicate upfront, number one, whether or not you agree to refer the matter to mediation, and secondly, why you adopt that particular stance. So let us unpack these requirements. The first point is simple, to say yes or no to mediation. However, for those of you who have read the rule or who have a copy, and if you cast your eye down to the end of the rule, in clause 9b, you will see that when a court is faced with the allocation of costs, it may take into account what a party stated at the outset about whether or not they agree to mediate. So boom, right there, we see the ingenious persuasion to appreciate the weight of this new rule. I mean, imagine, if you will, when you sue out, if you say that you give favorable consideration to a mediated resolution, it's going to be very difficult for your opponent to say, no, can do. So neither party wants to be seen as an obstacle to potential settlement, more so if it is one that could cause adverse consequences for a costs order. So therefore, in my opinion, just in your statement at the outset, the rule will have an effect by causing the parties to consider mediation seriously. So the second leg is a little more comprehensive. It says that you've actually got to not just indicate your position, but also you must give an explanation. So the rule requires each party to explain the reasons why they believe that the dispute is or is not mediatable. And the rule requires your statement to be clear and concise. And to my mind, this implies a few lines for the reasons. So basically what I'm saying is that in order to mitigate the risks of adverse costs orders at a later stage, parties should think carefully before opposing mediation. And a plaintiff who's opposing mediation will have to explain its stance cogently upfront to anticipate a response from a defendant that it agrees to mediate. So there may also be things that are said in the explanation upfront that trigger further thinking about mediation at a later stage. For example, in the beginning, the plaintiff says, no, I refuse to mediate. He has no defense. He's ignored my demands. Now, that reasoning could sow the seed for the other side to say, well, maybe when you've heard my defense, this matter can be resolved through mediation. So even where parties don't agree initially to mediate, the reasons that they furnish for their position may be a catalyst for mediation later. From my experience as a mediator, there are very few exceptions to the fact that most disputes can be mediated. An example that comes to mind is where one party is pursuing a test case and whose purpose is to set a precedent. Another example of a reason to take a position not to mediate is that it may be that you have, well, both disputants have already tried ad nauseum to settle. So when you lodge your application, you really believe it would be an exercise in futility to explore mediation. So those are the two pillars of the rule. Do you agree to mediate, and why? If the parties agree to refer their dispute to mediation, they must both sign a minute that records their choice. At this point, it must also be emphasized that an agreement to mediate must also be finalized. So the time periods that apply in terms of the court rules are then suspended. And here I'm referring to the delivery of pleadings and notices, the filing of affidavits, all of which is suspended from the date that the joint minute is signed. Obviously, this is not an indefinite suspension. Mediation should take place at least within 30 days of that joint minute being lodged, and the period can be extended on good cause shown. As I've mentioned earlier, the rule does not contain a provision for early enforcement, and this makes sense to me. So, I mean, for example, you definitely don't want any interlocutory arguments, which, mind you, could entail an enforceable or justiciable element, especially not at the outset, about whether or not you should enter into mediation. Next slide, please. So your clients should be expecting you to talk about mediation as soon as possible. Actually, you should, as a lawyer, take clear instructions at the outset on an appropriate stance and strategy for settlement. And some of you may feel uncomfortable initially to raise this with your client or even with the other side. But I would submit that merely by having been promulgated, the rule itself will help you to manage this. Now, especially if you're a large or part of a large firm of attorneys, you may want to think about having a different team to dedicate itself to a settlement. So I usually suggest this when there are more complex matters that have been referred to me for mediation. You see, the rule requires you to consider mediation at an early stage of the dispute. And if you're in the throes of working out an effective litigation strategy, it may seem duplicitous or even almost anathema to be concomitantly focusing on a settlement strategy. So where the costs involved warrant it, and certainly when there is much at stake, I would recommend that a separate team be established with a mandate to consider mediation. In my experience, for example, medical malpractice cases have lent themselves to this approach. On the issue of complex matters, I must also remind you that if some aspects of the dispute are more mediatable than others, then you and your opponent can still agree to just refer those aspects to mediation. And the upside of this is that it will have the positive outcome of reducing the issues that must eventually be decided by the court. So I cannot emphasize it enough, both to you and as lawyers and for your clients, that you must approach mediation in good faith. If not, then you run the risk of derailing any possible settlement. Having it in the rules or anywhere else, having a good understanding of the mediation process, having parties willing to mediate or willing to submit to mediation, it doesn't automatically make the dispute resolvable. So there's no magic wand in mediation. I just think, particularly when one is talking to mediators and sometimes as mediators ourselves, we're inclined to think that the problem is institutional, or the problem is that the courts aren't encouraging mediation, or the problem is that the parties aren't participating properly. And I suppose I throw down a challenge here to say, yes, we need rational and well-prepared parties, but you also need good mediators. So parties and lawyers representing parties their experience of mediation as an effective process, in my view, is going to be possibly the most material factor that is going to result in mediation becoming a normal part of our dispute resolution cycle in South Africa. And perhaps it will play an even bigger role than the possibility of cost sanctions at a later stage if you make the wrong decision. So the mediation process needs to be explained clearly to the client, especially the fact that the mediator's role is facilitative, aimed at helping the disputants to reach a settlement agreement that they will implement. So I usually suggest to my referring attorneys that they should give the clients a memo which they can digest at their leisure on what mediation entails, how is it different from arbitration and litigation, how the process works. You must remember that what is said during a mediation is also treated as without prejudice. It is inadmissible as evidence in any future process or forum. So to your client, you have to underscore that unlike litigation, mediation happens in a safe space of absolute confidentiality. It is aimed purely at resolving the dispute. And even as a mediator, it's not to my advantage that the parties arrive at the mediation feeling apprehensive. So as I've said, you must reiterate to your client in preparation that the mediation is in absolute confidential terms. Nothing can be used in litigation if the mediation fails. As I said, it's a safe space where they can brainstorm any option. And for me, that's the beauty of mediation. With the binary system of litigation that is a win-lose outcome, in mediation, everything is on the table. And of course, litigation remains but one arrow in the quiver, and clients ought to be encouraged to put anything on the table at a mediation. So another caution is that you must encourage your clients not to make mediation conditional on the other party making any upfront concessions, because this too can derail the mediation before it even begins. So they should enter into the mediation with a view to settlement and not try to get points scored early. So many legal practitioners don't have a solid experience of what mediation looks like. And in that sense, the whole experience might be new for them, and which is something that lawyers will have to adapt to. In the first place, I think post Rule 41A, and I'm already seeing this, there are higher volumes of mediation processes coming through. This means that legal practitioners are going to have to get used to participating in mediation processes, and it should become an important part of your legal practice, and something that you must factor into the structures of your practice and how it functions. The other important thing to understand, and in the context of what I'm going to say a little later, is that we must understand that Rule 41A mediations are already happening outside of the courts. And these processes are not being managed through the court processes. So Rule 41A simply asks the parties whether they have mediated, whether they're willing to mediate, and it encourages them to do so through private engagements with mediators. So these processes are not managed or administered in any way by the courts. And especially if we have to see higher volumes of mediation processes coming through, then for you as lawyers, this obviously is an opportunity, but it has some challenges. So lawyers have a very important role to play in the mediation process. I'm aware that many attorneys are concerned that the effect of Rule 41A is that they are going to lose work. And trust me, this is not the case. Lawyers still have an important role to play in, for example, drafting the agreement to mediate, in drafting their clients' opening statements, in drafting settlement agreements. And I also think that lawyers are best positioned to advise their clients on the risks of not reaching agreement through mediation and on what their best and worst alternatives to a mediated agreement are. Some practical tips in terms of Rule 41A. You must, number one, serve your Rule 41A notice and make sure it contains clear and concise reasons for your decision. Number two, choose your mediator that is suitable, especially if an area of specialization is relevant. In KZN, we have a website, which is www.kznmediation.com, which has a list of accredited mediators and their areas of practice. And on this point, I just want to invite you all to our debut conference, which starts tomorrow. You can go to our website to find the link and to register. It's very exciting. We've got our some very high-profile speakers from abroad and locally. And the theme of this conference is taking mediation mainstream. So I think for those of you who are interested, it will be a very exciting conference to attend. So the third tip is to prepare a proper agreement to mediate. And here you would need to address aspects such as the date of the mediation, the venue, the mandate, mediator costs, the issue of confidentiality, and the fact that it is a voluntary process. So as a legal practitioner, I encourage you to show willingness and to engage flexibly in mediation. You must attend the pre-mediation meetings if there are any, all the mediation sessions. Ideally, one should avoid any dilatory conduct, and obviously you must act in good faith. As a lawyer, you must ensure that you have sufficient authority to engage in and to conclude a successful mediation. You must also be fully prepared when you attend a mediation. You must cooperate, you must be constructive. And once this is complete, then the parties need to inform the registrar of the court. If the matter is already in the court process, you need to inform the registrar when the mediation is complete. And the rule requires that within 5 days of concluding the mediation, the parties, along with the mediator, must issue a joint minute indicating, number one, whether or not the mediation was successful, and if so, whether there was full or partial settlement reached. And also you must indicate the issues upon which agreement was reached and which do not require hearing by the court. And so as a lawyer, embracing Rule 41A and implementing it, you will be resolving your client's disputes, if I can steal a line, you'll be resolving them simply, better, and faster. And with such a reputation and a work ethic, you will surely attract more clients in abundance. Thank you. The concluding slide is just an excerpt from a book I have at my bedside, bedside, which resonates very much with me as a mediator. So thank you. That is the end of my presentation.
Thank you very, very much, Ishara. We can just hold questions. Next presenter, we seem to be time. Thank you so much. I appreciate this and very informative. Is coming of the government academic point of view. If I can just make apart from mediation. There is a question that I'm interested to ask colleagues. The question we have, the next present, and then we can open questions together. Is that okay with you, Shara? Ladies and gentlemen, I'd like to invite colleague Mahlodi Mothapo from Senior Lecturer at Unisa College of Law. Mahlodi.
Thank you so much. Even though I struggle to hear your introduction, but I believe I will introduce myself. I don't know if you have given me the presenting rights for me to be able to project my power slide.
I'm battling to, my technological challenges are, taking over here. So you can introduce yourself in the meantime. I'm going to just try and get your slides up and running, if that's okay.
Not a problem. Thank you so much. Good morning, everyone. My name is Mahlodi Mothapo. I'm a lecturer at Unisa in the Department of Criminal and Procedural Law. While they're still trying to give me the presenting right, I'll just quickly give the topic of my session today. Thank you so much.
Mahlodi, if you can just guide me through your slides, and then I'll just move on because
I'm struggling a bit to hear you. Are you able to hear me from your side?
Yes, we can hear you clearly, Mahlodi.
Okay, if you can just repeat for me what you've just said.
I'm going to ask if you can guide me through the slides, and then I'll move them. Alternatively, can you see if you
Not a problem, not a problem. If you can just move to slide 2 for me. As I have mentioned, I will be dealing with court annexed mediation, which I say it's a means to provide access to justice and widen the scope to transform relationship. So mine is to say that this is in an effort to transform our legal system and to incorporate values of the majority of people living in our country. The principle of Ubuntu has been practiced. Okay, he left. The principle of Ubuntu has been practiced in South African culture, and this needs to be included in our legal system. Previously in Ubuntu principles seeking to address dispute or conflict resolution, we will suggest family members who are not involved in conflict or in dunas to mitigate in dispute amongst people in order to get a solution and assist them to elicit favorable condition. So with this, the court recently is also the current trend in our court system to say that the court system conforms to the right of access to justice, as this is considered the fundamental right in many countries, and this is also included in South Africa. And this right that I had just mentioned is enshrined in Section 34 of the Constitution, which provides that everyone has the right to have any dispute that can be resolved by an application of law decided in a fair public hearing before a court, or where appropriate, another independent or an impartial tribunal or forum. And that, as a result of Section 34 of the Constitution, that is where the alternative dispute resolution were introduced into civil court proceedings. I will then make reference to that as ADR moving on. So ADR were introduced to transform the traditional way of litigation and incorporate the indigenous way of solving conflicts amongst parties, as I had already mentioned that in our current, in South Africa, when we look at that tradition, this is what has been happening. So the process traditionally stemmed from the negative sources or dissatisfaction with delays, costs, and inadequacies of litigation process. And this was reflected by the introduction of the short process court and mediation in civil matters act. This act that I just mentioned reference to was promulgated to provide alternative forum for adjudication of certain civil cases and for matters connected therefore. And as such, the principle of ADR were further introduced to our legal system to relieve backlog in the court and furthermore to enhance community involvement in the dispute and facilitate social justice. This is what the two previous speakers have already alluded to. I'm going to give a definition of what litigation is. It is a process as used to solve dispute in court system and is characterized by the element of civil justice. And in most cases, it has been viewed negatively due to parties' displeasures with delays, cost, and inadequacies involved in the process. It means court proceeding that can be commenced either by an action or an application proceedings. Whilst mediation at the other end, it's a process by which a mediator is appointed to assist parties to resolve disputes between themselves by facilitating discussions and identifying issues and exploring priorities that parties can use, and also to look at compromise and generating options in an attempt to resolve the dispute. So mediation in the ADR process, it is a voluntarily process because it also includes a third party, which is a mediator, who must be impartial. So in the ADR process, mediation is not regulated. However, the party are still given control of the process, and it is also a dispute that can be resolved by settlement agreement. You can move to the next slide for me, Prof. Thank you. So the ADR processes are divided into three primary primaries, which is arbitration, conciliation, and mediation. So mediation has been favored amongst the three because of its where parties can just, it's informal but voluntarily. So court annexed mediation, can just go back for me. Court annexed mediation was included or introduced into our court system to promote access to justice, as I had already mentioned, that the litigation process has been received negatively because of the length of the process and the cost involved in that. So the process were introduced into the system to promote access to justice, promote restorative justice, and most importantly, to preserve relationship between litigants and to facilitate an expeditious, this is fast and cost-effective resolution. So the process of CAM was introduced in South Africa in the magistrate court by the initially regulated in terms of Magistrate Court Rule 70 to 79. I will not go further into those rules, but I can just refer them to you. Rule 70 to 79 of the Magistrate Court deals with court annexed mediation in the Magistrate Court. As the previous speaker had already mentioned, that in 2020, the process of court annexed mediation were also introduced into the Superior Court in terms of Rule 41A. So my view is that the CAM were introduced in order to take out the litigation competitive nature in order to ensure less strain to future and advance relationship amongst litigants. So what Rule 41A of the Uniform Rule and the Magistrate Court rules have done is just to say that in any new matters involving civil litigation going forward, parties needs to make I think it's an undertaking of some sort to mention if they will be agreeable to go to such a mediation process or not. So parties are given that option to either agree or disagree. And obviously those that agree and disagree should give reasons. So this is a way of our legal system trying to incorporate what way in which our culture initially were doing when they were handling dispute resolutions. You can move to the next slide for me. I think I didn't say. So with the regulated mediation in both the Magistrate Court and the Superior Court, there can only be accredited mediators that can act as a mediator or a third party in the process. And the attorneys right now are being offered training to be mediators, which I think is a positive, and it will entail that the process of court annexed mediation is seen as a legitimate dispute resolution process, and it makes it a professional process. It also is going to be solved by resolution of settlement agreement. I can move to the next slide for me. And I will look at the benefits of court annexed mediation. What I said is it will save cost of litigation. When I say it will save cost of litigation, I'm saying because with litigation, as I think the previous speaker has already alluded to say that with litigation, there are so many costs that are involved in finalizing the matter. And the process, it's speedy because, like they said, the process of the court procedure becomes suspended for a period where the parties have to engage in the process of mediation, which normally it gives parties 30 days to do that. And also the fact that the parties still have control in the process, it is also a benefit of mediation. And with that, we are saying when the parties are seated down with an independent person, their relationship are more to be restored than with litigation where it's a win-win situation and relationship will never be restored. So with ADR, I mean, parties are given the opportunity to become creative as they will look forward to reaching solutions. It is still has that confidential element in the process, in that parties, whatever is being discussed in the mediation process cannot be used in court should the matter fail, the mediation not succeed. However, there should be discipline and focus. So we are saying the benefit is also that it is mostly effective because with the statistics that has been provided, in almost all cases that parties agree to go for mediation, 80 to 90% of the cases get to be solved. This is when we are looking at the divorce matters and the matters that are related to child law. Can move to the next slide for me. However, with a good thing, there are always disadvantages that are there, that we can always work towards them in making that court annexed mediation become the next best thing in our court system. So because there are no procedure that are prescribed when parties undertakes the mediation process, we are saying there can be a room for parties to abuse the process. As the previous speaker has said, that if a good ground is shown, the court are able to give more extension with regards to suspension of the proceedings in court. So we are saying this should be guarded against. And also with the issue of the process having that confidentiality element in it, is to say that the parties can also still use this mediation process, which is meant to assist them. They can abuse that because they know that whatever is being discussed in the discussion can never be used. It has the without privilege stamp on it, can never be used against them should the matter go for litigation. And we have the duty to bargain. The laws, I mean, of CAM does not really give the parties a duty to say they should bargain in good faith. However, there are those that might bargain in bad faith, but as the previous speaker has already made mention, that parties that maybe would not want to participate in the mediation process, there are cost orders that can be given. And obviously, with the mediation, as it can be sorted by a settlement agreement, it can also go for review at a later stage if parties are not agreeing with the settlement that has been said. With that said, we'll conclude that as the legal fraternity, we should welcome court annexed mediation in South Africa as an alternative dispute to traditional litigation, and also the fact that the settlement agreement of the parties should be in writing, as the previous speaker has said that attorneys or legal practitioner will still have their job because they will be the one contacted to write such a settlement agreement, and this as well improve the process as it will reduce the cost of traditional litigation. Can move to the next slide for me. Obviously, with the new rules that have been effected in the High Court, we are saying it is yet to be seen if the court will penalize the parties for non-compliance with the CAM rules, as it's still a new process. And obviously, with the rules that have been mentioned, there is more and more of parties being made aware of the process to undergo, as if it is not done in the beginning of litigation, it can always be done throughout the course of the litigation, either by the parties being advised to do that and applying to court to have to submit to mediation, or the court, when it has to reach a decision, making that determination before it can make a decision. So we are saying this process will be able to restore or transform the relationship of the litigations. Thank you.
Thank you so much, Mahlodi. Really appreciate your presentation. I just want to open the floor to any questions, ladies and gentlemen. Don't see any hands at present. Thank you again, Mahlodi. I really appreciate your presentation. Ladies and gentlemen, if I may ask your indulgence, perhaps we could take a 5-minute comfort break. According to me now, it's 11:03. Can we be back at 11:10? Okay. We will take a break until 11:10. Thank you very much, colleagues.
Quite lekker. Yeah. Okay.
I didn't even think about that. And chicken bacon, for that matter. Wasn't it that they excluded from food? Van annexed-mediation.
Welcome back, ladies and gentlemen. Our next speaker is Eugene Opperman. He's an attorney for Oppermans Incorporated in Cape Town. I will now give the floor to Eugene. He's going to present from the venue. Thanks, Eugene. Okay. I'm just going to find where you are. I think there we go. Let me just close that. Perfect. The floor is yours, Eugene.
Thank you so much.
Okay.
Right. Thank you so much for hosting this event. It is truly a great pleasure to be in Potch for a change. My topic for today will be mediation skills. Those are tools that we can use after we've completed our mediation training, and specifically focusing on the use of language and the choice of words that we use using the model of neuro-linguistic programming. And I'll explain to you and the online viewers exactly what that means, because it sounds quite daunting, the word of neuro-linguistic programming. Just as a general overview, if I could just move the slide, as a general overview, I'll be giving you a general introduction of an overview of neuro-linguistic programming, where it comes from, what is the origin, how it can be used. Also, a brief understanding of how we process information, not only as mediators, but also as clients. How do we process information, and how do we convey that in language terms to the other person? Also, I'll be giving you some tips and some skills, specifically with regards to NLP, the internal representational system, we'll get into that, the use of presuppositions in mediation, as well as some other tips that I would give throughout. So, to start off with, the difference that makes the difference. So what distinguishes the best from the best of the rest? Why are certain mediators better than other mediators? And that is what they call the difference that makes the difference. Now, the whole basis of neuro-linguistic programming, NLP, focuses on maps and models. Now, maps would mean the blueprint of your brain, how your brain access information, and how we internalize that, how we understand language, and how that creates our behavior at the end. Now, obviously, the blueprint of different people's minds are different. Not all of us have the same frame of reference, experience that we can relate to. So all our maps, how we project and how we see the outside world, might be different. And it is important, especially when it comes to mediation, that we match the way that the other person thinks in order to convey a certain message that we want to get across. And that is where NLP comes in. So the origin of NLP, neuro-linguistic programming, was right in the 1970s, where two people, Bander and Grinder, studied certain people of excellence. They identified a couple of people, and they said, what makes them different? What makes them best that they are in their field of expertise? What do they use to communicate? Why are they best? Why are people always going back to them? What is it what makes them excellent? And they started modeling what these type of behaviors are, and then subsequently they created a whole model based when they investigated and studied specifically two people or three people in order to compile the whole NLP model. And the first one was Fritz Perls, which is the influential founder of the nowadays, the modern day Gestalt therapy. So they looked at him and they tried to model and to see, but what makes him a good mediator, a best and a communicator at least. The other person that they also modeled was Virginia Satir, which worked to a great degree with family therapy. And the last one that they modeled was Dr. Milton Erickson, which was a hypnotherapist, clinical hypnotherapist. So although the origin of NLP, the use of language specifically, was used as a model in psychotherapy, there are also other uses thereof. I'm thinking specifically like sports coaches use NLP for people to visualize the winning, visualize creative visualization, and on how to achieve a certain goal. Politicians use that in order to influence people. Actors use that in order to engage audience participation and so forth. So it's not only in the field of psychotherapy that it's been used, but it could most definitely also be used in the form of conflict resolution. In essence, it's all about the process, and it's not as much about the content, which makes the use of the tools of NLP, and we'll get to the tools right now. It's all about the content. It's not about the process. It's all about the process, sorry, and not as much as the content thereof. So there's a definite need for certain skills in mediation. We all do the 5-day mediation, or the 10-day, or the 15-day, like the proposal and the previous presenter said, 200 hours, and that is good. That is actually plausible. But we need skills in mediation that would distinguish us and make us better than other mediators. And those are the skills that we can form or that we can gain by using techniques, neuro-linguistic programming, listening skills, and so forth. Now, on this slide, for example, you would see that, you know what, we have a certain expectation, and that expectation would not necessarily match the reality. We all have the recipe on how to conduct a mediation, how the process of mediation, the steps that we need to follow. But how we pack that and how we convey that to our clients, that is the icing on the cake. So we have the recipe of a normal mediation process, but at the end of the day, how we present that and how we come forward and being a great mediator is the icing on the cake. And that, if you have the necessary skills, then the expectation would meet the reality. So it's all about the name, neuro-linguistic programming. People are very scared of the name because they do not understand what it is. If they think about neuro-linguistic programming, they think that it might be brainwashing, which it's definitely not. But it speaks to 3 components. Number 1 is the neuro, and that is the thinking process, using your senses. Now, we've got 5 senses. Some of the women have got a 6th sense. But yes, we use our 6 senses in order to understand the world around us and to convey certain communication models or words to other people. That speaks the neuro portion, the thinking process. Then we come to the linguistic part. That is where we use the words that we use in a certain manner that could influence other people and the people around us, and also those words of other people, how that influence us. And then lastly is the portion of the name is the programming portion. That speaks to the behavior, how we organize our ideas, how we organize the ideas, how we unpack those ideas in order to recall those ideas as well. And that is basically in the name, the neuro-linguistic programming. If we make it more practical and we look at, for example, the NLP process and how it could be utilized in a mediation session or mediation setting, the definition that I could gather is that the NLP process involves finding out about how the brain, the neuro, operates by analyzing language patterns, the linguistic part, and as well as non-verbal communication in order to convey certain messages during a mediation process. So we use this surrogate of language. That is what we use as mediators in order to convey thoughts, ideas. And it would be easy if, in the ideal world, we could just plug it in from the one person to the other one, where you can do a lap link between the computers, and you can just exchange ideas without there being any form of misunderstanding. But unfortunately, it does not work like that because, like I said, as part of the basis of the whole NLP model. We have a certain map, a blueprint of our minds. So in a moment, I'd like you to think of a dog. Just where you are there, just think of a dog. Now, some people, usually when we have bigger audiences, people would think, and they would visualize, they would see a picture of a dog. That would be one person sitting next to you. They would see, literally, they would see a picture of a dog. It might be a Cocker Spaniel, it might be an Alsatian or whatever. Other people might actually have the touch. They could imagine how it would feel to touch a dog, or they could hear a dog barking, and that's using all the senses. They could maybe smell the fur of the dog. And that was just by the way of me asking you to think about a dog. And some people, God forbid, might actually have the taste of a dog. Let's not go there, because that might not be culturally, politically correct. But those are the senses that we use in order to convey messages and to other people. And we'll get to the surrogate of language and the workings thereof in a moment. So how do we deal with that? Now, we've got all our senses. We're taking information from the outside world. And at any given stage, they reckon there's about 2 million stimuli that comes to you in different forms and shapes by your 5 senses. Now, obviously, if we had to internalize all those senses, all those 2 million bits of information, we would absolutely go completely crazy. We do not realize that we are being exposed to that. So you would not realize at this stage how your bum touches the chair that you sit in, or you might not realize that your left toe, if you have a left toe, in respect to those that might not have a left toe, how that feels in your shoe. But those are all stimuli that we are exposed to, but we do not use that. Scientists established that we could use, or normal people could use or manage about 5 to 9 chunks of information that we get in from our senses. And then those, because we would go absolutely nuts, we would go crazy, and it would be a total set overload if we had to evaluate and to take in about 2 million bits of information. So that information, although it comes to us, we use a couple of filters in order, as an internal processing unit, how to filter those processes to take only what we need. One of those are the filters that we use are generalization, deletion, and distortion, and I'll give the definitions in a while. So we get the stimuli from outside, and then we filter it. We filter it by using our memories, our past experiences.
Having trouble listening to you, so maybe just use that.
Okay, perfect. So they would use, as the information comes to you, as you process that information that you gather by your senses, you either filter that by using past memories or your experiences, or even your belief system or your value system. And that creates an internal experience for you, an internal representation. Obviously, that would create an inner state for you, that would affect your physiology, and that would, in effect, gather how you would behave in a certain instance. So we use, like I said, we get those information, those sensory overload questions, or the sensory stuff that we get, that the 2 million chunks of information. We either generalize, delete, or distort. So what is meant by generalization? So generalization, as we use as a filter as it comes to us, would mean that we could learn from previous experiences. Like if we had to learn a language every day that we wake up, it would be crazy. So we tap in that part of our brain that deals with generalization, where we could take that and it eliminates the need to relearn a certain concept or behavior every time that we are confronted with a variation of that idea. That is the one that mediators would come across quite often in your mediation practice, generalization. Deletion is the other one. That is where we pay selective attention to certain dimensions of our experience and exclude others. It is also because the mind determines what information is needed. So you do not need the fact that your left toe is touching your shoe in a certain way, or your bum is touching the chair in a certain way. You don't need that information. But specifically when it comes to mediation, It might be that unimportant information or perceivably unimportant information or even hurtful information might not be applicable. And so that would be deleted from what they would tell you, what the client would tell you. The other one is distortion. And that is important, that speaks to the creative side of the whole mediation process, where it allows us to alter or to make shifts in our perceptions, changing our experience of sensory input. Now, that is, like I said, that is the creative process, and it allows us to plan for the future and dream and to fantasize. Most people, for example, architects use that quite often. They use the filter of distortion because they would see a picture and they could visualize that. A lady that makes dresses could take a piece of fabric and they could visualize what the dress would look like. For me, I cannot do that for the life of me. I would probably generalize just by a previous experience of what it looks like in the shop. Turning back to the sensory overload, all the stuff that we get in, the 2 million pieces and 5 to 9 pieces of information that we could actually manage. In a mediation setting, there are usually 2 primary things that we hear. This is a couple of examples that when I co-mediate, I make notes. And these are some of the things that we quite often hear in mediation. And those are words, because we work with a program and the neuro-linguistic programming portion, but we're going to focus now for this session on the linguistics, the words. So you would hear something like, I don't see what you're saying. It doesn't sound right. You know what? I cannot handle it. You do not see my point. I do not see the benefits of negotiation. You know what? He just rubs me up the wrong way. No one understands me, or the idea just doesn't sit right with me. So when a person uses that type of language, as a mediator, we need to step back and we have to listen what the people are saying, what the clients are telling us. Because when a person tends to use one of these internal senses of the 5 senses, if they use that habitually, often, then it becomes their preferred system of operating, how they communicate, the way that they organize their ideas in their mind, and how they convey that to other person. In NLP, we call that a type of a sub-language. Now, there's a number of ways where you can identify this sub-language. The one could be eye accessing cues, which we can address later, probably, non-verbal communication, and as well as speech patterns and the words that we use. So why is this important? Why would it be important for us as mediators to understand this model of representational systems? If one person in a mediation setting, the party A and party B, if they operate in different representational systems, the way that they process ideas, the way that they internalize it, the way that they verbalize that, if those parties are not in agreement, if they are not congruent, then the mediation would be dragged out. It would be a communication nightmare for people to understand each other. And as we go through the examples, it will become more clear. So number one, we've identified the 5 senses that we use to communicate. Now, obviously, we do not communicate by way of taste. I mean, as a mediator, you don't go and lick your client. That would just be ridiculous. But we use visuals, we use audio, we use kinesthetics, and we go through all those type of modalities in order to explain the preferred representational systems. So turning to the first one, because most of you, when I ask you to visualize or to think about a dog, you visualized a dog. So approximately 50% of the population is made up of visuals. They will tend to use the words that depict a picture or an image in their mind. So if they come to you and they tell you that is the picture that they see, then for you as a mediator, in order to bring the parties together, would be best to operate or to convey your message back to the client, also in terms of a visual perception. For example, if a client would say to you, I don't see what you are saying, you as a mediator should use the visual representational system and say something like, let me see if I can find a way to illustrate that better. Why is this important? Because that speaks directly to the way that they perceive and how they get the information and how they process the information in their head. So then you would be on the same level of thinking. Another example, I don't see the benefit of negotiating further. Again, that's visual. Then you could say as a mediator, you know what, let me paint you a picture so that you can see this from another view. That speaks directly to their representational, their preferred representational system. Now, visual people tend to use words like I see, focus, appear, reflect, look, viewpoint, and so forth. And they would use phrases like, you know what, look at this, or you know what, paint me a picture, or focus on this, or preview this, or draw to conclusions. And those are, if a client comes to you and they operate in the visual realm, the visual representational system, then you as a mediator throw that back to them. It's also important to note that, you know what, you would have two parties in a mediation. You would have two usually opposing parties because that's why they're there. You would have two parties and they might operate in different representational systems for you. So your task as a mediator would be in order to make those two representational systems congruent with each other so that they could actually hear and understand what the one person is saying to the other person. The next one would be auditories. Remember, we spoke about the visuals, now we talk about the auditories. Now, auditories habitually talk to themselves, especially when they are concentrating really hard, and they would use auditory phrases like, and we all heard this in mediation sessions, you know what, they say, it doesn't sound right. Or, you know what, I echo what you're saying, but I don't agree. Or an amplification of your point that I raised earlier, and so forth. And then you as a mediator using listening and realizing that, that the auditory system, representational system is being used, would feed back to them and say, but you know, yeah, you know what, if they say to you, it doesn't sound right. You as a mediator could say, you know what, I hear you. Listen, let's talk through this in a different way. Immediately you speak to their representational system, which allows them to analyze, to construct and formulate better ideas, how they unpack that and give you the correct answer based on the representational system. This also helps quite a lot for rapport, because if you are congruent with the other person, then the ideas might flow and the ideas might be better for you to understand the questions and the answers as well. Auditories would typically use words like hear, speak, listen, talk, narrate, or resonate. And they would use phrases like, you know what, I echo your sentiments, or that rings true, or let's debate the issue. Or they would very often, especially in family mediations, as they talk about the silent treatment. That all speaks about the auditory representation that they might be operating from. The last one, or the ultimate last one, is kinesthetics. Now, kinesthetics make up about 20% of the population, and they receive and organize the information primarily based on the basis of the body sense and feeling. They would say something like, you know what, this doesn't feel right. You know what, I don't think I can handle the manipulation, or I'm not comfortable with a suggestion and I need time to absorb that. So if they come to you with that type of language, then your responses to that would be, because they think they work from a kinesthetic point of view, you would feed back to them, you know what, we just haven't connected with this matter in a way that allows you to grasp this issue fully, and so forth. So these are all the languages that you could use and feed back to your clients. So typically kinesthetics would use words like feel, pressure, absorb, and they would use phrases like, yeah, let's make it more tangible, get a grip on things, laying a firm foundation, or he rubs me up the wrong way. So listen to those type of words that is being fed to you as the mediator, and reply and respond to that in the similar way, using the similar words. The last one, probably the most difficult one, is the audio digitals. Those represent about 5% of the portion of the population. Now, those are individuals who often have conversations with themselves within their own heads. Now, these are the most difficult people to mediate with, because they analyze, they ask the question and they answer their own question in their own minds. So those are usually the more difficult people to mediate. They would say something like, you know what, I don't know what you mean. They would just point blank say, I don't know what you mean. Or, yeah, no, I cannot comprehend his logic. We all hear these words, but they operate from an audio digital point of view. So they would typically use words like accommodate, contemplate, deliberate, comprehend, convey, principle. They would ponder on an idea. Again, speaking to, you know what, they have their own little conversation in their head. They would use phrases like, with regards to your concern, very typical to attorneys. With regards to your letter, with regards to your concerns, we'll address this. Considering the possibilities, a viable solution, consider the options, to take a balanced approach. Those are all the words that the audio digitals would use. To make it more practical in a mediation sense, just to give you some more clarity on how that is being used, I had clients come to me for a divorce mediation a while ago, probably a year or two ago, and the main issue when they came to me was that the husband didn't want any children. That was just point blank. He just said, there's no way he does not want any children. The wife said, you know what, I want children. So they came to me and I had to mediate that matter. Number one, the words that came to me from the husband was, you know what, she does not understand why I feel this way. She puts pressure on me to have a child. Our relationship is shattered because she is not coming to grips with my decision. So immediately as a mediator, you would realize, wow, he's using the kinesthetic representational system, the sense of feeling. The wife, on the other hand, said words like, you know what, he doesn't hear my longing for a child, or he doesn't listen to me if I try to explain my view. He just shuts down, again, auditory. The silent treatment after our arguments are just unbearable. So we have two representational systems. The one is kinesthetic and one is auditory. And the task for you as a mediator is to try and to make those two congruent so that those two could actually link in together. So typically, in order to match those, you would address the issue of the one party, of the one representational system, and also include the other party's one. For example, you could speak to the husband to say, you know what, because remember the husband is kinesthetic and the wife is auditory. To the husband, you can say, you know what, I can sense what you're feeling right now, and maybe this is not the right time, or this might be the right time to bounce ideas, some ideas of your thoughts and voice. Now you're speaking to the auditory system of the wife, and voice your opinion so that you can clearly hear and understand how you feel, why is it important to you of not wanting children, and what it means to you. For the wife, you could say, you know what, because remember, she's auditory, so she's all about hearing. It is appreciated that you are in tune with strong feelings, speaking to the husband about having children and why it is important, and maybe now is the right time to talk and to discuss the reasons for your decision, speaking to the husband, that resonates with you in such a tone that your husband can grasp and absorb your thoughts on this whole process. So during this whole process, you link these two representational systems, and it works quite well in practice. Following this is one of the NLP techniques. These are just some of the techniques that I'm giving and sharing with you. One of the other techniques is the process of the hierarchy of ideas. It's chunking up and chunking down. Now, the hierarchy of ideas is basically based on the understanding that language or concepts or ideas fall within a range of communication that ranges from something very specific to big picture abstraction, something that might be quite big. If we want something bigger, we want to get a better understanding of what the problem might be, we would chunk up. We would use the direction of abstraction and look at the bigger picture and also the interrelationship between things, ideas, and concepts. You would typically, as a mediator, ask questions like, what is this an example of? Thinking about my mediation that I had, what is this an example of? What is the purpose? What is the intent? Why is it important for you? What it will do for you if you would have a child, and so forth. The opposite thereof is the direction where you go into specifics, where you ask, that is chunking down, where you ask specifically certain questions. Why is this important to you? And what are these examples of? Coming back to our example of the divorce mediation, I realized there that they were at an impasse. They were just headstrong and they would not budge because the one party, the husband did not want a child, and the wife wanted a child, and that was the reason why they came for mediation. And I started the process of chunking up the ideas of getting a bigger picture, and I asked them certain questions. Why is that important to you? And the realization was, at the end of the day, which came out, was not having from the husband's side. He said, but not having children is a way to get the most of my present relationship. And I do not want to share the love that I have for my wife with anyone other. So that was chunking up. So that was completely different from just point blank, I do not want a child. On the wife's side, after chunking up and asking specific questions to get a bigger picture, she said, having children is a way of accessing the full range of the experiences of the relationship that the relationship has to offer, that I would love to share with my husband. So now immediately you brought those two parties out from absolute impasse to say, but you know what, there's no way that we are congruent, there's no way that we can see eye to eye, we're using two different representational systems, auditory and kinesthetic, and by asking the right questions, you chunked up, and at the end of the day, the realization came that the problem was not having a child or having a child or not having a child, but it was actually the sacred necessity of the relationship that they wanted to protect. And for a skilled mediator, you would then proceed using language of both representational systems in order to address the relationship issues with regards to the divorce mediation. After this divorce mediation, the parties reconciled for a while, and they decided not to divorce. In my eyes, that was a successful mediation. Subsequently, the parties did divorce because the secretary had bigger assets than his wife did. So, subsequently the parties divorced, but it was not based on the fact that the one party wanted children or the other party did not. Just the last point that I would like to raise, and that's just another tip that we use as that you could use in a mediation setting. That is the opening statements that we use and the use of presuppositions. Now, like I said, I sat in with so many people do co-mediate, and I listened to the words that mediators use for the client sitting in front of them. And they would say things like, you know what, the both of you have been experiencing conflict that brought you here today that needs to be resolved, which is very negative. You never say that. This is dispute. You're focusing on dispute. Has created some problems between you, and it is good that you've chosen to resolve the dispute through mediation, and so forth, and so forth. We use that. Not only does that break rapport because you're not congruent, you're not in sync with that client of yours, but words like this, which seems okay, is actually not okay, because the opening statement is basically your way of introducing yourself and creating rapport with the parties. So in order for you, using presuppositions now, is in order for you to understand, let me just go back before everybody reads that. How the mind works is, if I tell you to not think of a pink elephant, what do you need to do? You have to think about a pink elephant, not to think of that. That is the way that the brain operates. It's very similar goes with presuppositions, because in order for you to understand what I'm saying, you have to subconsciously accept that idea. And if that idea is so general and there is no way that you can just point blank refuse that idea, your subconscious mind would accept that idea. So my recommendation is to change, you as mediators, change your opening statement to say, you know what, I don't know if you know, but most people aren't aware that the settlement rate of mediation is 70 to 75% on average. So is there any way that anyone can reject that statement? No. But in order for you to accept that statement, to accept that, you need to realize that in order to understand what the sentence is meant, I'm mixing up my own words, you have to subconsciously accept the presupposition. So it presupposes that the success rate of mediation would be 70 to 75%. Continuing on, I cannot agree that we will come to a settlement immediately. There may be a number of obstacles which we have to overcome while working together before we can agree on a solution to move forward. So if you say something like that as a general for your client, what does that mean? There's a couple of things that is presupposed. It is presupposed that you are in support of the mediation outcome, that there would be a 70 to 75% chance that mediation will not fail, that it would be successful. That is a presupposition. It is also presupposed that you will come to an agreement. It might not be immediate, but you will come to an agreement. That you also preempt that there would be obstacles, but it would be overcome. And that you would work together and you could also agree on a solution which might be a long-term solution. Those are all the presuppositions, the words that we use in our mediation sessions to make it easiest for us to communicate with with our clients. Now, I just addressed a couple, one or two, and I just touched the tip of the iceberg with regards to some skills that NLP offers, because there's a range. It's about 180 techniques that I could probably share with you, and we would probably take a week to do that. But how to reframe, how to chunk up, the use of eye accessing cues, to realize if you look in your client's eyes to see where their eyes go when they talk to you, to realize, what are they lying? Are they constructing an idea? Are they creating the cues, visual, kinesthetic, and so forth? Also, the use of metaphors, building rapport, mirroring, and pacing, and so forth. Those are all techniques, but I urge you guys to read up on NLP, and it helped me. I am a NLP practitioner and business coach as well, and it surely does help me in my mediation practice by using some of these techniques. And only now, once I started realizing that these are the techniques, now that I needed to present a paper on NLP and mediation skills, I actually realized that I've been using these skills for quite a number of years, subconsciously, because it comes so naturally and it actually makes sense to use those type of skills. If you want the presentation or the slides, it is available on the QR code. And that basically brings me to the end of my presentation.
Thanks very much. Needs to learn. And, I mean, for me, this has been especially teaching these interesting tools that we can adapt to our curriculum, because evidently, the vital additional skills.
Correct.
To go out into the workplace. Thank you.
Most welcome. Most welcome.
By says that learning and applying higher mediation skills are highly important and undoubtedly enhance the quality of mediation. However, it is not so extremely important to avoid the techniques applied by mediators do not lead to unequal communication parties within the party. How to avoid what is a special problem is be affected by other parties. It's actually interesting.
It's a very valid comment, because people might think because you have a different skill set that you try and manipulate people or coerce people into a certain idea, but it's not true. Milton Erickson, who was a clinical hypnotherapist, explained that in quite depth. We perceive that to be a form of manipulation, which it is definitely not. We as mediators are just the facilitators of this whole process. And we understand how the other party, one of the parties or the other party, how they think, how they process information. And if we use that skill in order to better communicate with them, to get the idea across, or to chunk up to get to a certain portion to say, but you know what, this is the real problem. How could that be seen as manipulation? I mean, if I do that in my mediation practice and I get to a resolution at the end using the skills of NLP, obviously not putting the people in hypnosis, that would be absolutely brilliant. But yes, then surely if they want to call it manipulation, then so be it. But I don't see it as manipulation, rather than a process where you facilitate the whole communication between the parties. Thank you.
One more question, and then someone asks that the QR codes be shared. So just go one slide.
Okay.
They ask if Eugene can recommend any good book on NLP which can be used in mediation.
I am busy with a whole program. It's probably going to be a 5-day program on the skills of NLP, neuro-linguistic programming, specifically for mediators. So I'm busy with a program, developing a program with regards to that. I try to make it shorter, but like I said, there's about 180 different techniques that one could use. And we have to adapt it specifically for a mediation setting. Obviously, NLP could be useful for a number of things. So there are quite a number of coaching books or books on NLP that are available, some good, some better. But yes, they can send me an email. I'll gladly recommend a couple of books to them as well. Thank you.
Thanks. Colleagues, you're welcome to send an email to Juliet, and then she'll forward it to me, and well, we can get you into contact with Eugene. Thanks again, Eugene. Much appreciated. Ladies and gentlemen, our next presenter is Advocate Lisa Thomas, and she's going to speak to us on hybrid law practices, incorporating mediation into everyday practice. Lisa?
Hello.
Hi, how are you, Lisa? Do you want to just introduce yourself while I get your slide up and running here?
Oh, sure. Good day, everyone. Good afternoon. My name is Lisa Thomas. I'm a recovering litigator, quite enamored with ADR, but I am an advocate by profession. And currently I'm in the legal education space. And I'm very, very privileged to be presenting my thoughts. I'm very keen on making mediation work in South Africa. And I think all of us putting our ideas together, and especially the ones that are dedicated towards practical implementation, I am very much pleased to be part of that group. And hopefully I can inspire and get the ball rolling in terms of how can we introduce mediation to lawyers who are sometimes a hard bunch to crack. But I think it can be done. And of course, we can raise up mediation to the space or the position that it needs to be at. So thank you very much for the opportunity, and I hope you enjoy my presentation.
Thanks, Lisa. Just getting your slide up and running. Lisa, I guess you can just tell me when to move on to the next slide. And
Okay, will do. Okay, so without further ado, my presentation is entitled Hybrid Law Practices, Incorporating Mediation into Everyday Practice. So I'm very, like I said, I'm very keen to try to, as they would say, broker a solution between how we're going to introduce it to law firms, because currently I think law firms are very much in the majority, and we need to find a way to incorporate mediation into the daily offering of a law practice. So I think one of my learned colleagues came up with their own, a form of ADR, or calling it appropriate dispute resolution. So for me, I feel it should become mainstream dispute resolution, hence the title of my first slide. I think the alternative label needs to fall away, because it seems to have relegated it to a lesser form, and I think unfairly prejudiced form of dispute resolution. So, and of course, we have the proliferation of mediation firms and independent mediators. And so everyone existing side by side, in my humble opinion, it tends to isolate the forms of dispute resolution from each other. And like I said, because we have a lot more law firms, or law firms get more of the exposure because of our litigious society, all the forms of dispute resolution are sort of side by side, and maybe some are not at the same level as litigation, right? So I'm all for merging forms of dispute resolution. So not unfairly at the same time exalting mediation as a silver bullet, because as my learned colleagues would know, there are times it does not work and litigation is necessary. And I believe that litigation should be a last resort in some cases. But we need to bring together mediation and the law firm practice. So we need to merge or incorporate mediation into the offering of a law firm. Yeah? And of course, mediate a solution to introduce compliance with amendments to the rules of court. So Rule 41A, even the Magistrates Court rules have come into effect, the former being some time now. And the uptake is slow, right? So we have to come up with a way to use existing law firm structures to introduce and to enforce compliance with the amendments to the rules of court. Because we know that from previous or other jurisdictions and even within our own country, cost orders have been the punishment for non-compliance. So we need to mediate a solution, right? You can change the slide. So hybrid firms, so hybrid law practices are the firms that are going to incorporate mediation as part of their dispute resolution offering. So, and of course, with the prominence and the status of law firms, like I said, the incorporation of mediation into the law firm practice, it must elevate from alternative to mainstream, where it's side by side with litigation, right? Where it places mediation. A law firm has the power to place mediation on the same level as litigation, right? And of course, it removes the superiority, I think unjustified superiority, because we know that litigation tends to hold up matters at least 60-70% of the time, right? Litigation doesn't resolve quickly. So we remove the superiority from litigation and we attach the due weight to mediation. So law firms incorporating mediation into their practices will give it the prominence that it needs. You can change it. Okay, so obviously the way our law firms are structured and the ethos behind it, it needs to shift, right? So if we're going to incorporate mediation into a firm's dispute resolution offering, a structural reform is necessary to shift from a single track litigation focus. And I think to a large extent, as lawyers, we have made litigation to be the only form, right? To the point where a client will walk in and that's all they will think about in terms of what forum are we going to use, with the exception of a labor matter, which everyone knows or clients know that it's CTMA. For every other matter, they come in and they know that it's a law firm and a law firm equals litigation. So we need a structural reform, obviously with law firms to shift from that one track focus. And of course, the new structure of the firm, right, will not only include litigators, right? It will include mediators as well. Okay, so we're going to have these two professionals side by side. So it's going to be part of the organogram, part of the organizational structure. And of course, you are going to get people that are in between, where lawyers might turn mediators, or there might be former mediators who also can do a bit of lawyering, right? So you're going to have that in-between group as well. And then, of course, an ethos reform is necessary to shift from fees or revenue focus, billable hours, right? The dreaded billable hours, to client satisfaction and fast results. So this is probably be something that is the hardest to change. But I think that, just go back a bit to the previous one. But I think if the ethos, if we are going to place mediation on the same footing as litigation within a law firm, as the management, the other lawyers, the the support staff, we have to start thinking differently. So it won't be so much about bringing in fees, right? But it's going to be client focused in the sense that the client must be satisfied with the result, and of course you can achieve that result very quickly. You can change over. Okay, so this is probably the relationship between mediators and lawyers, right? It's something that has to, I feel it has to be brokered, right? Because you're going to have in-house lawyers and in-house mediators, but they are not competitors, right? We are not, like we said, litigation, or the lawyers aren't supposed to be superior to the mediators, right? So we're gonna, I think that will also fall under ethos, where even as the management tier of the law firm, we do not pit lawyers and mediators against each other, especially where they are in-house and part of the same firm, right? Because litigation and mediation are both valid forms of dispute resolution. Arguably, mediation, and I think there's a lot of research to back this up, mediation is not a more valid form, but it is more resolutive, right? You get answers faster. And like I mentioned, mediation is not a silver bullet. At the same time, litigation is not superior to mediation, simply because, everyone's, using certain kinds of language, and we're exchanging papers, and we're having trial, and we're having, it's very, very sort of affluent, and it presents very sophisticatedly. It's not superior. So in that sense as well, the mediators and lawyers need to relate to each other as weapons in the client's arsenal. I think, again, this comes down to the ethos of being client-focused, where you want the client to be satisfied. So you're going to effectively tell the client, we have to mediate first. So here are our mediators. And then if this doesn't work, then we may have to litigate. So you become I guess you can say, fighters in the same army for the client, and you get to present, both of you get to present as options to the client, right? Now, a colleague of mine raised an ethical objection. I did a post about this recently on LinkedIn, and so I do understand, and of course, there will be ethical issues with a firm mediating and litigating in the same matter. But I don't think it's a bar, or it's a prohibition on a firm having these two people in-house. And of course, in my opinion, the primary ethical consideration should pivot, firstly, on the practitioners involved and the information or the documents that are generated in each dispute resolution process. So mediation and litigation, right? So obviously the first issue being that you're not going to get the same people. So if you have a lawyer mediator who may be taking on the mediation side of things, you're not going to get that same person to be part of the litigation should it go to litigation. And of course, the documents in litigation and the documents in the mediation process should be kept separate from each other, right? Next slide. Okay, so like I said, the practitioners involved should act in one process only. This is the obvious way to avoid a conflict of interest, right? And of course, all of us know that mediation is confidential, and necessarily mediation will precede litigation. So whatever has been done in the mediation, if there's been an agreement, then of course that will get taken into the litigation process, right? But the notes and all of this, whatever was involved in the mediation, will necessarily have to be destroyed. Any recordings that were made would have to be erased. So that's the ethics of the mediation process, right? And of course, like I said, the only document relevant to the litigation, should it go that way, after the mediation, it may be the mediation agreement, which will show an evidence of a substantial attempt at mediation, or if there's no mediation agreement, then perhaps the document that would be relevant there would be the maybe the mediator's report to say that, this sort of proved that there was a good attempt, the parties were sat down to mediate, right? And of course, the administration of information or documents in each process must be kept separate to prevent accidental overlap, right? So ideally, you're not going to have the same staff members in the litigation department working in the mediation department and vice versa. So you don't have that sort of accidental cross-pollination or overlap, or where documents find itself on the lawyer's table that actually pertain to the mediation and vice versa, right? Next slide. Another way to avoid conflict of interest, of course, is to set up, or mixture is to set up an alternate location for the mediation proceedings, right? Or if the firm is so, is large enough and can afford it, you set up a separate business entity by itself for the in-house mediators. So it would fall under the same firm, but they would have their own separate entity under which they can function, right? And of course, this probably isn't currently in our landscape here, mediation or ADR landscape, but we're going to have a code of good practice, at least within the firm. So if you have in-house lawyers and in-house mediators, you're going to have a code of good practice for the mediators and for the lawyers, especially in regard to the, transferring from one to the other, where you're going to have to set out the sort of best practices in a document so that everyone is aware of what they should and shouldn't be doing ethically, right? And of course, there is this will probably be the go-to option would be to outsource the mediation and bring in mediation firms, or bring in even freelance mediators who operate for their own account. So the marketing strategies will clearly have to change, right? Like I said, the ethos must move from, if you're going to incorporate mediation into law firm practices, we have to move the ethos to client satisfaction and fast results. So it follows that the marketing strategies of law firms will have to change. It won't be about the cases that we win in court, right? It's going to be increased case turnover at affordable prices. So this marketing strategy will reflect the ethos of being client-centered and resolution-focused. And I think this is a bit of a rebuttal to lawyers who see mediation, as one of my colleagues has said, as less lucrative, because it's not an ongoing cost. With litigation, you can have ongoing billing, right? Even though there may not be a result. So it is a bitter pill to swallow in that regard, because lawyers feel like they're going to make less money, or we're going to be taking away from the litigation department. We're going to be sending most of our stuff. If most of our matters are resolved at mediation, then our lawyers aren't going to earn as much money. But of course, you've got to market from a client perspective, and that's what I love about mediation. Even within the litigation space, you see things from the client's perspective. You see how it's going to affect their relationships going forward, and whether whatever dispute resolution process you choose is going to affect them ultimately as people. So you're going to have to market from a client perspective that the results justify payments. Because one of the downsides or the cons of billing is that a client will say, why is the bill so high? Because you haven't done anything, or you just went to adjourn, or it's been set down only for next year. So why are you charging me, or why are you billing me, right? So we have to look at it from the client's perspective with marketing, so that we see that the results actually matter to the client, and the results might even bring in more payment as opposed to continuous billing without without a result in the litigation. Next slide, please. Okay, Okay, thank you guys. That was a bullet chain, but I hope I was able to drop some seed thoughts. And thank you for the opportunity to present.
Lisa, thank you very, very much for your presentation. Yes, you know, we need to look at the way forward, and you know, as academics, all we can think of at the moment is the reluctance of our, you know, our colleagues in practice to actually acknowledge that you know, mediation is the way forward. You know, our court systems inundated with case rolls. It's ridiculous, you know, where we're going. But yes, if only our colleagues in practice can think, you know, the way you've just presented, you know, different hybrid approaches or opportunities on expanding their business, well, not businesses, not business, their practices. Yeah, thank you so much.
Thank you.
Are there any questions, colleagues, friends? Jan, do you see anything? No. All right. Lisa, thank you so much. We're going to invite our next presenter, Sandra Hitchcock, who is an accredited mediator from Hitchcock Mediation, to join us. Sandra?
I'm here.
Okay, thanks. I'm going to just give me a second. I'm just going to get presentation.
Okay. So while you're getting that, I'll start by introducing myself. Is that okay? Because I know that we have time constraints. Yeah, thanks, Lisa. I really smiled at your introduction, the way you introduced yourself by saying recovering legal practitioner or something like that. I want to say that I have wonderful legal colleagues in Cape Town who are all converted already. So thank you for that. I'm a mental health practitioner, so I'm not from your legal fraternity. I have been practicing as a family mediator for 18 years, and you know, just to talk about some statistics, I would say currently I look at my client, my list of clients, and 75% of my practice is mediation, and probably 25% is therapy. So that is a good thing to know, that people are really choosing mediation as a way to deal with disputes and family and divorce. So I also train in mediation, and I also teach at the University of Stellenbosch in the master's program in ABR. So I teach the mediation section in that. I was also so glad to hear that, to follow Eugene Opperman's talk just now, and he has almost laid opened the floor for me, because I'm going to be talking about family mediation, and just some of the ideas, the neuro-linguistic programming. Families are programmed to be in certain ways. There are patterns in families, and belief systems and values, and we need to hear that when we do family mediation, because otherwise we can't help those people. We complain about compliance to parenting plans and agreements, but if people feel that they were not part of those discussions, and if we didn't get to the root of what they're really talking about, there will not be compliance. So in family mediation, it's important to realize that we have to bring about some kind of transformation, and often the success lies in that there is some kind of transformation taking place, that people can communicate differently. So if I go to my first slide, I'm just gonna keep that slide there, or can I do my own slides now?
Sandra, just tell me when to change the slides.
Okay, you can stay there for now. I have a lot to say about the topic of family mediation, as I'm passionate about what I do. But I will definitely not have time to share all of what I would like to, but I'm going to touch on the main concept of ecosystemic family mediation. So family mediation has come a long way since the Promise of Mediation by Folger. And I read the other day that children are not even mentioned in that book once. So with a change in the look of a family, I'm always trying to find new ways of assisting families to undergoing the changes that divorce and separation brings about. We must remember that no family is the same, although there are similarities. It should be the same with the mediation process we follow. The process should be flexible, tailor-made, designed to fit, and taking into account the uniqueness of the specific family. Just yesterday, I again used this kind of framework with a family, and one of the important things that came up for the child was she has a tortoise and she has a dog, and you know what's going to happen to those. So we shouldn't be thinking about a family only as a nuclear family, because it doesn't look like that anymore. So maybe we can learn from Zonia, who says, she's 9 years old, she says, her description of a family is, in my family I have 5 parents. My mom and my stepmom, and then my dad and my other stepmom, and then my half-sister, then my half-sister's dad, and my brothers and my sisters, and then there's, of course, all the pets. Another example is Hope. She's 14 years old. She says, my family is just so different from other people's families, but I don't mind, because who says what a family should look like? As a family mediator, I work from a child's rights-based approach, where when parents talk about, you know, what are my rights, that's often one of the first things that they ask. I immediately change that to what are the child's rights. I believe that there's a place for all different approaches to hearing the voice of the child in particular. I try to steer away from care and contact assessments. We don't have time to go into that, but they become expensive. But not only that, they are indicated in specific cases, but should never be the norm. Because let me not talk about that. I've heard a forensic colleague say the other day, I'm tired of playing God. So parents are the experts on their children. We need to listen to parents. Immediately when you say that, you are the experts of your child. Tell me about your child. You empower that person so much in the mediation process. So we have to listen to the parents. Children are part of a unique set of relationships and people, social settings, amongst others. Sorry, Sikandar, I needed the second slide already. As a family mediator, I need to understand more of the workings of their family system in order to assist them to divide into 2 functioning family units, keeping the relationships and the social systems in place. Children should not grow up with a loss of these important relationships. They should not grow up experiencing that they live with one parent and visit the other. How can a family mediator help this to happen? I often use the example of 2 containers. That you live from one container with the belief systems and the patterns and everything that's going on in that system. Now we have to divide it into 2. What of these values and norms and whatever do you want to take over to the other, to the new system on this side and the new system on that side? Again, if you think about what Eugene has been saying, it's a visual kind of representation of that people can identify with doing something like that. Okay, so separating. So why is a wider perspective needed? I think we are on 2 different slides now. I want the previous one, please. Separating one system into 2 is more than just containing conflict and dividing time. Ecosystemic mediation is an overarching framework, not an alternative model. It puts emphasis on the connections between the needs of individual family members, the family as a whole, and families in wider social systems. The mediator works at an interface, avoiding unnecessary involvement of statutory systems, but understands the boundaries and complements the role of the legal system. There's a flexibility in the tailor-made models that fits the needs of the participants instead of the peg model of mediation. From a systemic perspective, the mediator's understanding of the impact of legal, economical, political, social, gender, culture, ethnic, family, psychological environment of any dispute between individuals, particularly involving children, is fundamental to any discussion in mediation. If you don't have a clue of what's happening for this family, you can't really assist them. When a two-parent household is divided into two one-parent households, multiple changes for children and partners take place, and arrangements are to be designed by the family members rather than imposed on them for long-term success. Remember, though there are similarities, there's no one-size-fits-all agreement or parenting plan. Okay, you can go on to the next slide. So when we talk about a good fit, family mediation has to be a good fit for, because the standard model does not apply for everyone. Family mediation needs to also be fit for purpose with national standards for training and practice, which we do. Mediation meetings may be arranged with different constellations of family members. It doesn't only have to be mom and dad, and then a child maybe, or everybody that we have involved in that system that we've heard about could be involved in different constellations. Mediation meetings may be arranged with different constellations of family members. Children and young people should be included in carefully planned ways designed to suit the individual children and their families. Special attention should be given to children's experience of parental and family systems separation, major changes in their lives. Listening sensitively to children and young people and sharing their message with their parents facilitates family communication in the long and short term. If an ecosystemic framework is applied, the mediator will know who are the important role players: grandma, au pair, nanny, whatever, whoever. How can children and young people be included? It's always a tough one, and again, we don't have time to really talk about that, but this framework encourages the inclusion of children in protective ways. Again, depending on the family, how they function, what works for them, and we fall in with that. The mediator has to listen sensitively to the children and help the parents to hear them. All right, next one. So how does screening take place? One has to spend some time with each individual family member to hear what is happening for them and how they find themselves in that family system. What are the constraints, the risks, their abuse, is there aggression, power imbalances that might interfere with them participating in a process like that. And because participants have to be able to participate without fear or harm. And then confidentiality, of course, always. The whole system has to buy in that the mediation space will be confidential, with a few exceptions, of course. If dangerous things come about, we have to have a policy as to how to deal with that. Mediation space will be closed and private. As far as the containing of conflict is concerned, conflict in divorce destroys energy and it creates drag, as we all know. Just as turbulent airflow over the wing of an aircraft creates drag and destroys lift, the mediator needs to help the family to produce positive change and not destruction from the conflict. Understanding the system and the root causes of the conflict through the systems framework will be helpful. The mediator must be able to contain these intense emotions. And dialogue should not be inhibited by rigid ground rules, because you learn so much about the dynamic of the family if the communication, is allowed to happen in the way that it happens. Okay, then the principles of ecosystemic mediation. Ecosystemic mediation follows a holistic view of our families in transition. One of the key elements is facilitating communication between family members. The aim is to help family members manage change during turbulent times, and the family needs to understand that they will be separated but still interrelated. If they have a space where they can quietly talk about that, they get to understand that they will still be connected in a different kind of way. The mediator has to provide assistance with practical and workable arrangement, and the mediator needs interdisciplinary knowledge or the involvement of other disciplines collaboratively, like social, cultural, legal professionals. Relationship with family justice system must be maintained, while at the same time the mediation space must remain independent and confidential. Agreements made must fall under the shadow of the law. Children are individuals and have the right to maintain family relationships, which will continue to be nurturing and sustaining. Children need to understand the changes and share their feelings. Ecosystems theory offers a means of conceptualization and understanding individual experiences and life events in the context of social and family experiences. It offers a helpful way of understanding family structures, relationships, patterns of behavior, often fragmented and dysfunctional communication can become coherent and have a positive function if they are understood in the context with which they occur. You know, people that we say, oh, this was a very difficult mediation, the clients were so difficult. You must always remember what they are going through. They are probably not difficult all the time, they're difficult because they're going through trauma. Looking at the interactions and patterns of communication help mediators to move away from linear cause and effect explanations, which often encourage blaming and tunnel vision. Participants in mediation should be seen as interconnected and interacting rather than detached individuals moving in different directions. The approach is particularly helpful in cross-cultural, cross-border, and intergenerational mediation. Ecosystemic mediation, how is that different from family therapy? The systems perspective in mediation is a conceptual tool, not a form of treatment involving family members. Next slide, please. So, Eugene earlier also spoke about the visual representation, which helps people to understand. So if you follow, years ago when we were trained, we used a genogram. Now we can talk about an ecogram, where we have the family in the middle and all the things that are important to them, the activities, the relationships, who are involved, what is involved. And as they talk, you are mapping what they're sharing. And when they see that for themselves, it helps them as well. It helps them to see what children have to go through. But they also can see how the family parents that relationship is now broken. And you move down a line and you can then start a new ecogram saying, no, it's going to look like this, and you separate it so they can visually see how this family system is separating. Next slide, please. So we have to focus on each child as an individual. Each child's needs has to be heard separately about the important relationships. As I said, grandparents, pets, sport, whatever else, we have to hear what's going on for them. I just remember, a 9-year-old boy with a parent said to me, he's actually fine. And as soon as the door closed, he started crying and he said, who's going to take me to sport? Who's going to do it? So Nobody ever spoke to him about what his concerns were, which could have easily been shared in a family meeting with his parents present, because these were loving parents who said, we want what is best for our children. We don't want to fight. We want to do this amicably. So if he was never given the opportunity, people would have thought, oh, he's actually fine, while he was not. So we learn about the activity with each parent and family activities. It's important in your mediation session that you ask each parent to describe the child separately. Now we hear how the father sees the child, or the one partner sees the child, same thing from the other partner. Each parent to describe their relationship with each child and the collective, how he or she, or he or whoever interacts with the child, and how they interact with the child collectively. Often that they hear each other for the first time as well, if they listen to what the other one is describing to you as the mediator. Each parent to describe how they see the other parent's relationship with the individual children and collective. Again, now they hear, oh, this is how he or she or they are experiencing me. Each parent to describe the others and their own parenting style, the relationships in the family and with outside parties or activities. Just on the slide there, we talk about Smythe. He says that time is a container of social activities and emotional bonds. A lot of people have to, when we do family mediation, scarce resources are always time and money and children. And 2 children, so much money, so much time that can be divided. So those are things that people really fight for. And one has to hear what that is. What does each child or each parent do with the child? How do we help them to contain, to have enough time for what is called the different type of times: bonding time, reading time, fun time, activity time, so will each parent be available for the child to have all of that with that parent as much as possible. Next slide, please. So the mediator focuses on the future, understanding the patterns, the dynamics, and the needs of the family and its individual parts. By now, we hope that the mediator is aware of that, has asked enough questions, has given enough time, have listened enough, and heard everybody. Mediator must now focus on problem solving, in a closely structured way, and focusing on the way that they think it should be happening. If the mediator understands change in social systems, it will be very helpful, because we talk about first order and second order change. So first order change is consistent with prevailing values of the family system and norms which can be implemented using people's existing knowledge and skills. This is first order change. Second order change, now we move away from the known. Now it becomes very slippery slide for people, because this is new. We all know that change is difficult. They're moving away from the known routes and calls for system 2 thinking. It requires reflection, analysis, and reappraisal, tasks that the mediator can help with, if you understand how they're functioning. Orderly, orderly and creative change depends on a capacity and willingness to change assumptions. There's a system theorist called Lapoppie. He says the critical issue of peace and the need to convert conflict to cooperation demand incorporation of second-order learning in social systems. And the most effective way to produce social learning is through a participative design process. So again, link that to compliance to agreements, compliance to parenting plans. Does this family feel that they have been part of designing that agreement? Think about a care and contact assessment, the outcome of that. think about a maintenance order, you know, how that affects people because they don't feel that as if they've been part of, if they feel that they haven't been part of that. So some of the things that we can say and do as a mediator to help parents think about are they taking into account what the children are experiencing? What would Olivia say when she's 12 about the decision you make today? Looking forward, what can happen? Is this are these good decisions now for the future? What will Noah say when asked when he's older than what it was like while you were getting divorced, or what happened after that? What would you like Olivia and Noah to say? Next slide. So if the mediator has some understanding of the threats of the past conflict that binds them together, you can help them to change that and to move towards a different future for them. Ask questions like, how did they care for the children before? What happened before? Tap into what worked for them previously. Help them design a plan according to that. Who else was involved? What was involved? What was useful? What were moderators? What was aggravators? The disputes that they are in, that they're experiencing, polarize them. So one has to move away from that and try and let them see that they both want the same thing. Or, you know, the old idea of mutuality. And to keep on, if the conflict is ongoing, to keep on thinking, where does the roots lie, and really focus on the needs and the interests instead of the possessions. Yeah, so then again, I come back to what Voss is a mediator and negotiator who works with hostage and terrorist kind of negotiations, and he says that if we focus on the false edifice of rationality based on logic, rational notions of values and morals of what is fair fails to address the underlying emotions, looking at leaves and trees and missing the roots and the undergrowth. So we have to hear what is going on for a family to be able to assist them to come to a good plan and good outcomes. Yeah, and I don't have time for more. My time is up. Thank you for listening to me.
Thank you very much.
Yes.
Really, really inspiring presentation. One of the most sensitive areas of our practice is family mediation, specifically when it concerns kids and parenting plans and just a personal opinion. Mediators that deal with family mediation should be more mature mediators that actually engage in family mediation. Just a personal opinion, but yes, thank you very, very much for your presentation. There is a question, Trudeau Lizelle, you're welcome to ask your question.
Thank you very much, Chair. I just want to confirm that you can hear me.
Okay.
Yeah, yes, thank you.
Oh, wonderful. Thank you. Thank you very much for that insightful presentation. I've not been in the courts recently, in fact, for almost 20 years now, but previously in my youth, I did a lot of family law prior to the changes to the Children's Act and all the recent, incorporation of family plans and so on. So I just want to inquire, is it now compulsory to engage in mediation prior to the settlement agreement being made in order of court? Because I know of many divorces where there are no family plans, there is no mediation, or didn't take place, even in recent times. By recent, I mean 6-7 years ago. So excuse my outdated knowledge there. But I would just like to ask, is it not possible to enforce this ideal that you've created in your presentation? Because that to me is the ideal. Sadly, it's not the reality in most divorces. Most divorces are rife with conflict. The children hardly have a voice because the parties are too traumatized at the time of going through that divorce. And it would be very beneficial if all those or things that you've mentioned in your presentation could actually become mandatory and in a way funded. I don't know, I suppose funding is always a problem, because it seems as if it's not improving. Even amongst colleagues and friends, I've heard of so many extremely toxic and conflict-ridden divorces, which cause long-term damage, not only to the children, but also to the parties involved. So my first question would be whether that's a possibility. I know law's not your background, but I also think that perhaps it is time to force LLB students to take a course in psychology. Because in essence, in law, and whether you litigate or mediate or whatever it is that one is dealing with, I think psychology is an essential skill, which we as an academic, not compulsory at most universities. We don't teach students those skills. And I myself, as a junior advocate, was oblivious to the emotional impact that a divorce has on the client. And I think I would have been better equipped had I had psychological training. So my question is actually, can one change the system? Because what I keep hearing also from the other presentations about mediation is that a mind shift is required from a rights enforcement mind shift to a solution mind shift. And I know most attorneys have a fee-based mind shift, and I suppose money is what's important out there. So those two issues, can one bring psychology into the spotlight more? And, obviously the second one being an educational issue, which I think would be beneficial, because, so much hurt and pain and trauma can be reduced if this is done. I'd just like to hear your views on that. Thank you.
Thanks for the question. Sikandar, maybe you can say more about the legal aspects of the question, but I would like to say, maybe just briefly, because I know we pressed for time. What I in my practice I find, because I've been doing this for so long, that I find that people with that kind of approach, people that want to settle, that don't want to fight, that want what is best for their children, that want come to me, because your practice is always word of mouth. So just for you to know that there are people that prefer that there are lawyers and attorneys that refer people because they prefer that. As far as the teaching aspect, it took us a very long time. I'm a trainer for FAMAC in family mediation, but I'm also a commercial mediator. It took us a very long time to become part of the master's degree program at the University of Stellenbosch. I would ideally like all people, all social work, psychology, and law students to be trained in mediation, which a part of that would be more the psychological kind of aspect. And in our family mediation, there is training that we do. There is a specific component of how to deal with more of what you call a psychological part of that training. But certainly, I think that you're raising good points. It would just be very difficult to have a brief sort of training in psychology while students are learning law. So it has to be a whole change of what does that course look like, because we're not training lawyers then we're training mediators. So I share your ideals. Sikandar, would you like to say more about people having to go through mediation?
Thanks, Sandra, and thank you, Liesl. You actually make a very valid point. There are quite a few institutions that teach the LLB program, and sadly, many of them do not offer alternative dispute resolution as a part of the LLB curriculum. As time is changing now, I think there should be a strong drive in that regard. At Northwest University, we take it very personally and believe that it is an additional skill that we can offer our LLB graduates to take out into the world of work. But speaking about psychology and that, that's taking it to another level. I can't, contribute much in terms of changing the curriculum in that regard, but it's a skill that, one acquires through practice. You can only get better, through dealing with, from one mediation to the next mediation. And like, the comment I made after Sandra made a presentation, specifically with family mediation, the mediators that actually engage should be more mature mediators dealing with, family mediations. The fight is going on, and hopefully we'll get there to some stage. I think there are other presenters that will come that will follow through later in the day, and you'll get some ideas of where we're heading with respect to dispute resolution. Again, Sandra, thank you so much. I really appreciate your time and presentation. If we can move along, ladies and gentlemen, our next presenter is actually asked to move on to a later slot. So we're going to invite Anneke Whitear-Nel. Please forgive my pronunciation there, Anneke. She is a senior lecturer at the University of KwaZulu-Natal. Anneke?
Hi, good afternoon.
Just give me a second while I get your slide up and running so you can introduce yourself so long. Thanks.
Sure. Well, first of all, thank you to the organizers for inviting me to this event. I'm honored to be here, and I'm certainly learning a lot about aspects of mediation relating to things other than labor law. So yes, my name is Anneke Whitear-Nel. I am a lecturer at the University of KwaZulu-Natal, and I'm also a senior CCMA commissioner. So that's where my practical involvement and practical work with conciliations and arbitrations takes place. So the title of my presentation today is as follows: The Virtual Handshake, Navigating the Challenges and Opportunities of Video Conferencing in Labor Dispute Resolution, Conciliation and Mediation. I changed my title from the one that's showing in the program. I originally had my title as referring to labor settlement negotiations, but given the focus of the conference, I thought I'd rather shift to speaking about conciliation, which in the labor context is pretty similar to mediation, except obviously it's statutory mediation.
Thanks. So the floor is yours.
Thank you very much.
Okay. Just tell me when to move on to the next slide. I'll just do that.
Okay, great. I'm not seeing any slides at present. Is that?
You seeing the slide there? Okay. Okay. Just give me a sec.
Sure.
To go to. Okay. There we go. Okay, I got it. Yeah, thanks.
Okay, thank you. Yes, so the first slide was the title slide, slide number 2. So parties involved in labor disputes, like family disputes, are often in a long-term relationship with each other. And for that reason, labor disputes need to be resolved quickly, and also with a minimum of legal formalities. And that is codified. It's in the Labour Relations Act. And because of that, because of the need for quick, efficient, and non-technical dispute resolution, it's compulsory for all labour disputes to initially be referred to conciliation in an attempt to resolve them, these disputes quickly and informally. The terms conciliation and mediation do have slightly different meanings. If you Google it, you will see different definitions. But in the context of South African labour dispute resolution, the two terms really are used interchangeably. Theoretically, a conciliator gets less involved than a mediator, in a nutshell. But the model for conciliation that the CCMA teaches is a mediation model. So I'm going to be using the terms conciliation and mediation interchangeably. So we're going to hone in on what it is about holding conciliations via video conferencing technology that creates these challenges and opportunities for the negotiating parties as well as for the conciliator or mediator. So prior to COVID, the literature was quite pessimistic about the prospect of successful online mediation, albeit that there was a lot of interest in text-based mediation, e-negotiations they called it, but a lot of that literature is just devoted to text email negotiations, which isn't really on point. But scholars in this area have said that once COVID came along, resistance to the idea of online mediation completely fell away. And one of the scholars in this area, Ebner, states that resistance just disappeared almost overnight because there was no other choice but to go online. And another scholar called Singer said mediators who were skeptical about their ability to connect with parties online were quite frankly wrong. Nevertheless, face-to-face conciliation remains the gold standard. But increasingly, processes are moving online for all the benefits of cost and convenience, amongst other things that it brings. So the CCMA, which is one of the bodies which conduct statutory conciliations, is currently piloting, it's still very new, but they're currently piloting an e-commissioner project where they envisage that there will be a large body of commissioners who sit at home in front of their laptops and conduct processes without any provincial borders. Well, I won't go into detail about the project, but it's an indication that the CCMA conciliation processes are going to be moving online. Not exclusively, there'll always be a hybrid mix, but they're going to be a lot more online processes. So the reason I said that conciliation via video conferencing is not the gold standard still is face-to-face conciliation, is because the online media using video conferencing technology rather, to connect is going to be a less rich medium. And richness refers to the medium's ability to communicate contextual cues like body language, etc., which provide a significant amount of meaning in communication. In a less cue-rich environment, like being online, trust, empathy, and social intuition, which are the things that research has been shown to be key to successfully conciliating a matter, those things are less easy to deploy. Trust, empathy, and social intuition. It's also more difficult to engage those things and to establish those things. We can go to the next slide, thank you. So trust, empathy, and social intuition. We're going to be focusing primarily on trust today, but I will also deal a little bit with empathy and social intuition. Trust refers to one person's assumption that another is benevolent towards them and will not do them harm even if they have an opportunity to do so. Empathy refers to one person's ability to be sensitive to and caring about what another person is feeling or experiencing from their point of view, and then to be able to communicate that to the other person. And social intuitions refers to a person's capacity to harness their self-awareness and other awareness in order to build a bridge between themselves and others. As I said, I'm going to be dealing with trust in more detail, but empathy and social intuition are also important. And Levicki says that the existence of trust between the negotiating parties makes conflict resolution easier and more successful. In a conciliation, especially a statutory conciliation, trust will often be lacking between the parties simply because they are in conflict. But trust between the conciliator and the parties is also important, and a trusted conciliator, together with a trusted conciliation process, can facilitate trust between the parties, which obviously will help to nudge the parties towards successful resolution. So the ability to form rapport with the parties has been found to be the most important skill that a mediator can possess, and a primary element of rapport is trust. The parties' trust in the mediator and in the mediation process is crucial to a successful outcome. So how does one build trust and rapport? There have been a number of research studies involving this. One study surveyed mediators and asked mediators what they thought was important to build trust. And they replied that trust was most effectively built through the mediator's empathetic listening and honesty and ethical behavior. Parties to mediation were also surveyed about what they thought fostered trust in the process. And they stressed the mediator's friendliness, likability, integrity, neutrality, the maintaining of their confidences, and the mediator's preparedness for the process. So what's quite interesting here is that the parties are focusing on issues of professional competence or professionalism, as well as personal factors relating to the mediator. So in addition to the fact that the online environment is less cue-rich, the online environment itself, the internet, is mistrusted by people a great deal. This transfers to the online conciliation process. I am now going to borrow from another prominent scholar in this area, a gentleman called Ebner, and I'm going to proceed by identifying 8 challenges to trust and negotiation. To trust in negotiation and mediation by way of video conferencing. So the first challenge is that the parties will start with low expectations of trust. They have low levels of trust already, simply walking into the statutory conciliation, which is exacerbated by the online environment. Therefore, parties should start building trust right from the outset of the online process and should not be discouraged if the other party is initially mistrustful of them. That is only to be expected. Strategies that mediators could adopt to deal with this challenge would be to start with, say, a technical tour of the platform, showing the parties how the maybe Zoom platform or the Microsoft Teams platform, whatever it is, how it works, and making the necessary assurances. The mediator's skill with the platform will help encourage trust in the process. Additionally, the mediator might preempt the mistrust, helping the parties realize that in an online environment, initial mistrust and misgivings about the process are completely normal. Okay, we can move on to the next slide. The second challenge is the lack of contextual cues or the lack of medium richness, such as the lack of nonverbal cues, which makes it more difficult for the parties to assess trustworthiness. Research shows that most of the meaning we infer from communication actually comes from nonverbal cues. Some studies even put it as high as 80% of meaning comes from not the content of what we say, but how we say it and how we behave when we're saying it. So video conferencing, unlike text-based mediation, does provide audio and visual cues, but their richness is diminished, and factors related to the technology, like lags and glitches, may interfere with or even distort those contextual cues, and this may lead to diminished trust. Strategies that could be used by negotiators include making the most of the video box available to you to enhance and clarify the cues you are sending. For example, if you tend to use your hands while communicating, ensure that the camera is set so that your hands are visible. As far as mediators are concerned, they can try and mitigate the challenge of limited contextual cues by making the parties aware that the cues they receive may be limited or distorted by the technology, and ask them to be aware of it and to make allowances for it. If the mediator is party to a communication that is ambiguous, the mediator can intervene to achieve more clarity. For example, when the mediator notices that the frame has frozen, they might point this out and ask for a repeat of the message. Or the mediator could say something like, I think the screen froze there for a minute, so let me repeat what Tandiwe has said. Okay, we can move to the next slide. This is the third challenge with online mediation or conciliation. And that is an increased attribution and misinterpretation of meaning in the communication. An increased attribution bias. The attribution bias refers to the tendency to interpret another's meaning and behavior through a negative lens. The attribution bias refers to the fact that you will interpret something that, as having arisen as a result of the person's inherent personality qualities rather than as a result of external factors, like the fact that you're online. So this is a human tendency anyway. The attribution bias doesn't only pop up in mediations, but obviously its effect is going to be exacerbated and increased in the online environment, where the meaning of a communication might be unclear and come across as vague and literally coming from a distance. And this would all foster mistrust. In a face-to-face environment, if it becomes apparent that a communication has been misunderstood or the intention behind it misattributed, one can clarify it immediately. The online environment does not really allow for this, with stricter turn-taking due to the dangers of speaking over one another. Tips for negotiators include slowing down and reminding your counterpart that there is a real human being behind the screen. Things like referring to your environment and to the real world behind the screen. So you might say things like, it's really hot today where I am. Also take every opportunity to clarify meaning. For example, by saying, let me see if I've understood you correctly. Also avoid delays. Don't leave your counterpart waiting for you to log in. Waiting causes anxiety, which is not conducive to trust building. For mediators, the same tips apply. The mediator might also refer to misattribution in the leaner queue environment. For example, by saying, I think we're missing out on something that would be much clearer if we were in a room together. Let's recap. This will also serve to slow the process down, which might prevent automatic or knee-jerk reactions by the parties. If we can go back one slide, please. Okay, challenge number 4 is the mutual invisibility inherent in online transactions, which facilitates trust-breaking behavior. The sense of invisibility and anonymity which prevails online leads to a lowering of social inhibitions. This phenomenon is not as extreme in video conferencing encounters as compared to text-based communication, but it still persists to a degree, particularly when the cameras are switched off on the platform. The more one party identifies with the other and the mediator, the greater the trust that will be built. So both the negotiating parties and the mediator should make an effort to unmask themselves, for example, by switching on cameras, at least while they're speaking, but ideally all the time, and they should try and share relatable information about themselves. You might comment on something in the background or introduce some personal information about yourself, like, oh, pardon my fox terrier for barking like this. I'll ask my daughter to take him to a different room. The camera angles used and the lighting can also be consciously used to portray oneself in a closer to real life manner. The mediator can model behavior in this regard and make suggestions regarding camera angles, placement, lighting, etc. Okay, we can move on to the next slide. Thank you. The 5th challenge is the sense of separation from the other, which results in decreased identification with the other. This creates a sense of difference and otherness. Identifying with another fosters trust. Both negotiators and the mediator should strive to dispel this perception and to replace it with a sense of togetherness. The mediator might say something like, I'm sure we're all very tired at this point and need a comfort break. Or we are all here today for the same purpose, to successfully resolve this dispute, for example. When we perceive ourselves as sharing commonalities and experiences with another, a sense of togetherness and being involved in teamwork is fostered. While caucusing can also be useful, too much caucusing with the individual parties can further enhance the perception of the opposing party as different and the other. Okay, next slide, please. Also with online processes, there will be an increase in conflict-driven behavior. This is linked to perceived anonymity and distance on the online environment, and this makes people more contentious and irascible online. This can be attributed also to physical distance, reduced social pressure, and reduced accountability. In one study, parties confessed that when the process became too intense or they were in an uncomfortable situation, they would close their camera or even feign a technical glitch and leave the meeting. This could not happen in a face-to-face meeting. Parties in processes with fewer contextual cues behave more competitively and even feel justified in behaving in this kind of behavior, using these kind of hard tactics in the negotiation or mediation. In a situation where these sort of hard tactics are being used, parties are unlikely to successfully build trust. If a mediator suspects this is happening, it's probably best to take a break and to let things cool off. And the worst thing to do would be to rise to the bait and retaliate in kind. Okay, we can go to the next slide. Another challenge is the privacy concerns that parties will often have in an online environment. When video conferencing, it's difficult to know if others are in the room with the parties. Not only that, but it's very easy for the proceedings to be secretly recorded. In a face-to-face context, anything relayed to a third party from the room will likely be hearsay evidence and doesn't have the same bite as a first-hand trust violation. The danger of leaked information obviously makes people cautious, which doesn't encourage trust building. The mediator should set the ground rules up front, but must be mindful not to promise the impossible. The mediator might promise, I am not recording this, but shouldn't promise this is not being recorded. There is no harm also for the mediator in the labor context in reminding the parties of the CCMA rule, which makes confidentiality proceedings confidential. If the parties do raise privacy concerns, deal with them transparently and honestly, remind them of reciprocity. And as regards covert third parties in the room, parties could be requested to pan the camera around the room if this is suspected. And there are also some platforms that enable the use of a 360-degree camera, which allows the entire space to be seen. The latter is better. Rather have a 360-degree camera than asking your opponent to pan around the room, because asking that suggests that you don't trust them, and that's going to be less conducive to trust building ultimately. But obviously, if it's necessary, it's necessary. You know, it's not only a person in the room that's a concern, but when you're behind a screen, you can minimize the process screen, and you can be having covert communications sent to you digitally on your screen. So that is a concern. Possibly less so in mediation than arbitration, but nevertheless a concern. Okay, and then the eighth and final challenge to trust in an online environment is that the parties will be somewhat diminished online. They'll have less focus, commitment, and investment in the process. Think of how you multitask when hidden behind a screen. Some platforms have built-in technology to detect and report this. For example, WebEx can sense whether users have minimized the meeting window or have opened messaging or browser windows on top of it, and it provides that information to the meeting hosts. A similar feature in Zoom, it was called the attention tracker, was actually, it was invented, it was available, but there was massive user pushback. People, especially the home workers, didn't like being tracked. They're having their attention tracked. And so Zoom withdrew the attention tracker. Even if there is tracking going on, if you're using WebEx or some other software that has a attention tracking facility, people also innovate to avoid being detected detected. So one way of doing that, for example, would to be to play a video on loop. The movements in the video would give whatever the platform is the sense that you're actually paying attention. Multitasking during Zoom meetings or online video conferencing meetings might actually contribute to the phenomenon which has become known as Zoom fatigue. Zoom, by the way, has a massive market share in online processes, and that's why Zoom fatigue has been the term coined to identify the feeling of exhaustion that we experience after looking at a screen all day. Multitasking during face-to-face meetings, like reading messages on a smartphone, has been shown to lead to less successful processes, and this finding will certainly transfer to processes via video conferencing. If anything, the effect will be greater because the opportunities to multitask are much greater. Strategies to defeat this tendency, multitasking tendency, include keeping meetings shorter with more frequent breaks and scheduling meetings for times when the parties are likely to be fresher. Boredom and fatigue often provoke multitasking. Fatigue also contributes to a negative attitude towards the process, which is going to be counterproductive. Okay, we can go to the next slide. We're going to now move on to looking at empathy. Any basic text on negotiation or mediation will say that displaying empathy is a crucial component of a sexual process. But what exactly does showing empathy involve, and how is it done online? It can involve perspective taking, which is where you see things from the other's point of view. You can walk in their shoes. And it also involves accurately identifying what the other is feeling, while not letting that impact on your own feelings. Navigating and employing empathy is challenging in any situation, but more so in a video conference mediated encounter. And this is because of the decreased richness of the medium that we've already discussed. It is particularly difficult to convey empathy in an online process. Techniques that can be engaged, however, include active listening, reflecting and asking relevant, productive, and to-the-point questions, showing interest in the parties and their needs and concerns. An example of empathetic communication from Ebner is as follows. Before we delve into the issues you've raised, I'd like to check whether I understand how you feel about the events you've described and how you see the issues being resolved from your point of view. A distractor from showing empathy is that while video conferencing, you can see yourself in your own video box. It's one of the most unnatural things about video conferencing. It causes self-absorption. We are drawn to our own image, and it triggers social anxiety, which causes one to be more concerned about oneself and less concerned about others. So another thing to increase the chances of empathy developing and being communicated is to diminish or even eliminate your self-view, if that's possible on your platform. And a mediator could recommend to the parties that they switch off their own cameras. Making eye contact is also key to communicating empathy. With most video conferencing platforms, it's not possible to make true eye contact with another party to the meeting. However, research has shown that simulated or perceived eye contact is received as if it were true eye contact. So adjust the video box of the person you are communicating with so that the box is as close as possible to the camera on your computer, ideally directly underneath the camera. And when you focus on the video box, it will appear as if you're making eye contact with the person in the box. An even more direct illusion of eye contact is created by looking directly into the camera. But this is very difficult to do. As I said, we're constantly drawn back to our own image and distracted by cameras. Another tip is to show the upper body in the camera frame, head, torso, and hands, and to lean into the screen. Research has shown this to be perceived as the person having increased focus and attention. And again, this is something that the mediators can suggest to the parties. Okay, we can move to the next slide. We're now going to focus on social intuition. The realm of social intuition is different from the cognitive realm, which involves identifying interests, communicating positions, seeking new information, considering alternatives, assessing offers, crafting counter offers, generating new options, and evaluating the costs and benefits of those. Key negotiation process issues also involve questions of likability, warmth, and whether the parties enjoy each other's company. Where those factors are present, chances are much higher that the dispute will be successfully conciliated or mediated. Schlerer states that that a random exchange or smile at the coffee machine or a courteous word when entering the hearing room are sometimes just as important to ensure a good atmosphere between the parties than anything that is done formally at the hearing. Social intuition is part of emotional intelligence, or EQ. It involves building bridges between the self and the other. Schneider and Ebner identify 8 interactional realms of social intuition: physical proximity, body language and mirroring, eye contact, physical contact, like shaking hands, vocal tone, vocal and conversational pace, humor, and the use of metaphor and analogies. Ebner makes the point that in the video conferencing environment, of the 8 realms, only physical touch is missing. Other than the realm of touch, the other realms can be employed and deployed, but they are somewhat constrained by the online environment. One of the most significantly impacted is eye contact, but as we've mentioned, you can fake eye contact. Video conferences also tend to remain static and also tend to maintain a constant distance from the camera. Leaning in online can be just as effective as leaning in person to highlight an important point. Camera placement is also important and reinforces what was said earlier about maintaining an appropriate distance from the camera so that the upper body is visible on screen. When you show a close-up of the face only, it can literally be perceived as that person being in your space or in your face. Something that can work to simulate touch would be to explicitly refer to it, thus invoking its advantages. For example, the mediator might say, I think that if you were in a room together, that last suggestion would get not only a handshake, but a high five. Or, I wish we could shake hands right now. One last point about social intuition. Generally, all the elements of social intuition are culturally dependent, so tread carefully when using analogies or humor, for example, in a multicultural setting. It may just fall flat and, even worse, trigger concern or confusion. It's also worth constantly reminding yourself that social intuition is diminished in an online setting to reduce the danger of misinterpreting behavior or a lack of it in an online setting. And that, ladies and gentlemen, brings me to the end of my presentation. All that remains is for me to conclude. And I would like to conclude simply by saying that a lot of what I've been saying here would apply to mediation online in any context, not only in the labor dispute resolution context. And while it's true that COVID did sweep away resistance to online processes, as I indicated earlier, there was no option but to go online. There is still a fair amount of resistance amongst quite a large body of practitioners, be they labor dispute resolution practitioners or other conflict resolution practitioners. But I think as long as you know how to use the online setting and as long as you develop appropriate skills to manage an online setting, there really is no reason that online mediation, online conciliation should not be as effective as face-to-face conciliation. I mentioned the pilot e-commissioner project that the CCMA is running currently. One of the things that the CCMA is going to be monitoring closely will be settlement rates in conciliation. And this will be, in South Africa, one of the first pieces of empirical evidence that we have regarding whether conciliation and mediation in an online context works or whether it doesn't. Thank you, ladies and gentlemen.
Thank you very, very much, Nikki. I really appreciate your presentation. I'm just going to open the floor to any questions. My colleague Jan's assisting me here. Is there anything there? Nothing.
I think people are wanting lunch.
I think so. Ladies and gentlemen, for the purpose of time, what we're going to do is at the venue, there are only five colleagues here. We're going to actually take a 15-minute break. And we will resume at 13:40, at 20 to 2. So we're going to take a break now until 13:40, and then we will have Laurie Greyvenstein from the Social Justice Foundation, who will then continue from there. So let's meet at 13:40. Thank you very much. And thank you again, Nikki. We really appreciate your presentation. is Lapoppie Greyvenstein, and
he's going to introduce himself. He's here at the venue, so he's going to continue from here. The floor is yours, Lapoppie.
Thank you. How do I get that black box away there?
I'm going to get it away from you.
There we go. Thank you.
Then we are. Please introduce yourself.
I will. Thank you. Good afternoon, everyone. Thank you for the opportunity to present here today. My name is Lapoppie Greyvenstein. I'm working as a mediator full-time for the last 17 years. I'm the founding member of the Social Justice Foundation, or a co-founding member rather. I have 20 years of experience in formal dispute resolution and 17 years in informal dispute resolution. I've worked with maintenance cases since 1987 as a maintenance officer first, then as a public prosecutor, magistrate, and now as a mediator. Qualification-wise, currently I'm registered as an LLD candidate on the topic of my presentation. The presentation is based on my approved thesis, research, and 37 years of experience with maintenance cases. The outcome of the research is a work in progress, and the relevant stakeholders have already bought into this proposal. I'm presenting on alternative dispute resolution and online dispute resolution. Sorry, let me just go back. My supervisor is Professor Lenkie de Jong. Content-wise, an introduction, the problem, outline of the thesis. 1, the duty of support. 2, the traditional method of resolving maintenance disputes. 3, ADR options to resolve maintenance disputes. 4, the need for a centralized maintenance register. 5, the establishment of a dedicated credit bureau to serve as a central maintenance register. And then on to the conclusion. In an ideal world, children would grow up with both biological parents in one home. The divorce and unemployment rates would be low. Few children would be born out of wedlock. The state would be wealthy. Orphan children would be cared for by the state, and divorced and unwed parents would willingly take care of their children's financial needs until they are fully self-supporting. But the reality is that we do not live in an ideal world. Divorce and family breakup are often complicated by emotional effects, and although parents may love their children, they are frequently struggling with unresolved issues that hinder them from thinking clearly and being open about their finances. Maintenance disputes frequently arise. Some disputes are settled amicably, but many end up in court. Carnally correctly states that there is a culture of non-payment of maintenance in South Africa. Parts of the current maintenance system have become so obsolete that it no longer serves the best interest of children and other vulnerable people who are legally entitled to financial support. A multidisciplinary approach is necessary if we are to create new insights into the pressing societal demands and socio-economic needs that are evident in maintenance cases. Fresh insights are needed to improve law reform processes on various levels, thereby contributing to the development of new legislation and influencing approaches to the centralization and integration of the private maintenance system with other public and private sector systems, as well as to the extension of credit and the keeping of records on persons with maintenance obligations. The proposed approach is technologically advanced. It reduces the discretionary powers of court officials and can fit into the well-established and regulated credit bureau environment. A sophisticated system can significantly reduce
human intervention, thereby reducing costs, time, and preserving relationships. This research is to campaign for the establishment of a national central maintenance register that will record all maintenance orders and keep a record of persons who do not honor their maintenance obligations. The register should function as a dedicated maintenance credit bureau for maintenance orders only and interact with the financial sector and the credit industry. When credit consumers apply for credit, the credit providers will have access to such consumers' maintenance obligations. Credit consumers who evade or conceal their financial responsibilities to their family will be prevented from obtaining further credit until their maintenance obligations have been paid in full. The national credit regulations provide for the consideration of maintenance obligations when someone applies for credit, but there is no easy point of access to such information. Although the Maintenance Amendment Act provides for information on maintenance defaulters to be handed over to credit providers and credit bureaus, this information is not readily accessible. Credit bureaus are positioned to process data of a financial and private nature from various public and private sector platforms where such data is crucial in dealing with maintenance cases. The Central Maintenance Register should encourage alternative dispute resolution before escalating cases to litigation. A Central Maintenance Register offering online services could provide access to justice by first funneling cases through online dispute resolution, and when disputants cannot settle through online dispute resolution, referring them to suitable ADR mechanisms such as private or community-based mediation. Only when ADR is unsuccessful should disputants be referred to litigation as a last resort. This would encourage biological parents to take care of their children's financial needs, enhance the role of the courts by reducing their administrative functions, and encourage disputing parties to settle disputes amicably. A maintenance inquiry is first and foremost a financial inquiry. Many disputed maintenance cases that end up in court are argued based on the availability of financial resources. The problem: it is acknowledged that the maintenance system needs rigorous changes if it is to be effective. This study does not, however, focus on previously identified problems with the maintenance system. A major problem identified by existing research relates to the lack of capacity and infrastructure of the maintenance court system to deal with the workload, which is created in part by insufficient maintenance legislation. This study focuses on a system that emphasizes the responsibility of non-residential parents to provide for their dependent children and on methods of dealing with maintenance defaulters, the reporting of all maintenance orders and defaulters to credit bureaus, and the handling of disputes pertaining to maintenance matters. Private maintenance orders are granted in different courts. Unfortunately, there is no clear indication of the number of maintenance orders in operation in South Africa. More than 60% of registered births in South Africa in 2021 reflected no information on the biological fathers on the birth certificates. Courts receive more than 200,000 new applications for maintenance annually, but these figures fall far short of the need for maintenance orders. A mere 34% of children live with both biological parents, and 42% live with their mothers but not their fathers. Only 4% of children do live with their fathers but not with their mothers. South Africa's total population is estimated at 60 million people, of whom 20 million are children under 18 years. Children make up 34% of the total population. The 66% of children in need of maintenance represent 13.2 million children. The divorces and 200,000 maintenance cases finalized annually are a drop in the ocean in relation to the actual need. There were 1,265,753 live births in South Africa in 2022, while the need is for 835,397 new maintenance orders per year for new births. On new births alone, there is a deficit of 1,065,753 maintenance orders annually, excluding the need of 13.2 million for the substitution of current maintenance orders. In fact, if 13.2 million maintenance orders are reviewed biannually, then on average, every magisterial district must review 74 cases every single working day. The maintenance court system does not have the capacity to deal with the sheer volume of cases, and drastic alternative measures are necessary to address the need. The vital need for an efficient maintenance system is emphasized by the alarming statistics on the numbers who are dependent on the state for survival. 29 million people in South Africa receive monthly grants. 18 million South Africans receive the state welfare grant, with another 11 million relying on the state's 350 Rand grant. South Africa only has 7.4 million individuals with taxable income, a quarter of the number of people who receive grants. 50% of credit-active consumers are over-indebted. Over-indebtedness is a common excuse used by respondents during maintenance inquiries in court. Maintenance obligations are considered as part of a person's credit profile, which must be considered when they apply for credit. But 8 years after the amendment of the National Credit Regulations, there is still no system to provide for the implementation of this amendment. Maintenance defaulters can be listed with credit bureaus, but there is no dedicated credit bureau processing maintenance orders. If there were a dedicated credit bureau, credit providers would be denied an opportunity to provide further lending, and persons with maintenance obligations would be able to provide for their dependents. Government must fix this problem. In the case of Bannatyne versus Bannatyne and others, the Constitutional Court found, while the obligation to ensure that all children are properly cared for is an obligation that the Constitution imposes in the first instance on their parents, there is an obligation on the state to create the necessary environment for person to do so, or parents rather, to do so. The duty of support. Section 28(1) of the Constitution grants every child the right to family care or parental care or to appropriate alternative care. Although the study focuses on the private maintenance system, it includes an evaluation of both private and state maintenance systems. Primarily, parents must take financial responsibility for their children, and the study investigates various possible ways of achieving this requirement. It is in the best interest of children to gather as much information as possible to be cared for. 2. The traditional method of resolving maintenance disputes. This study analyzes the provisions of the Maintenance Act, identifies its limitations, and makes suggestions. The South African Law Commission is investigating, in addition to the recovery of maintenance for children, the reform of the entire South African maintenance system. The formal approach through the maintenance court system is based on an argumentative and litigious approach by family members who are not necessarily in disagreement. Parents are formally drawn into litigation proceedings against one another. They must attend court, prepare their cases, and produce evidence. The process is not conducive to the preservation of relationships, and it does not promote the principle of the best interest of children. 3. The need for a centralized maintenance register. The study investigates the use of a centralized maintenance system with a strong internet presence to process the relevant data and documents of all parties with maintenance files electronically at a central location. The central maintenance register will serve as a conduit that receives and feeds information between all relevant stakeholders, including the dedicated Maintenance Credit Bureau, the courts, and maintenance clients. The processing of personal information of maintenance clients and minor children may be foreseen as a weakness or concern for the Department of Justice, which hosts the information in maintenance matters. But this is the motivation for having a dedicated credit bureau. The department can share the information conditionally with a single niche credit bureau that specializes in maintenance orders only, instead of sharing the information with all 52 registered credit bureaus. The financial sector and credit industry have already taken precautions in their codes of conduct to align the processing of personal information with the provisions of Section 39 and the requirements for complaints, checklists, and guidelines of the Office of the Information Regulator. 4. ADR options to resolve maintenance disputes. The study introduces ADR mechanisms as possible informal options available to find solutions for dealing with maintenance disputes. The Family Dispute Resolution Bill of 2020 under Project 100D provides for mandatory mediation for all family law disputes, and it makes provision for certified mediators. Different ADR options are analyzed, including dialogue, conciliation, collaborative law, private and statutory mediation, arbitration, and parenting coordination. Mediation has evolved over time and has become the main alternative for resolving family disputes out of court. In the event of settlement, the agreement of the parties can be made in order of court. The use of forms of ADR and ODR, online dispute resolution, is entrenched in resolving credit bureau disputes, and existing processes can be adapted and integrated into a centralized maintenance system. Artificial intelligence and algorithms are synonymous with ODR in credit bureaus and other disputes, and offer opportunities for resolving maintenance disputes. Family mediators already utilize program calculators successfully during maintenance mediations. Artificial intelligence and mediation have become increasingly intertwined. By combining the two, users can benefit from the advantages of both and achieve more effective outcomes. The use of an internet-based centralized system has the potential to give marginalized persons and communities access to justice, which many South Africans are currently deprived of. ODR is a web-based system in which minor differences can be resolved by the proverbial press of a button, and more complicated disputes can be funneled to other appropriate dispute resolution mechanisms, either online or face-to-face. In the credit bureau industry, automated decision-making and information matching programs are already in use. 5. The establishment of a dedicated credit bureau to serve as a centralized maintenance register. The point of departure for this study is the establishment of a dedicated bureau. Although international instruments support the concept for arrears maintenance to be listed on credit bureaus, it is argued that the concept should be extended to all maintenance orders. An analysis of the financial services sector is provided before focusing on the role and function of credit bureaus, the credit industry, credit granting, credit rating, and reckless credit. SACRA draws all qualifying companies in the credit industry together to share information on their clients' payment and risk profiles with the credit bureaus. It safeguards that identical data is shared among all SACRA members. The dedicated bureau would become a member of SACRA. The National Credit Regulator plays an important role in the formal credit industry, regulating the 8 ADR agents, 52 credit bureaus, 6,675 credit providers, 1,699 debt counselors, and 4 payment distribution agents. Credit bureaus play a vital role in the industry, in the credit industry, and the South African economy. Credit providers must consult credit bureau records to ascertain consumers' monthly obligations, to establish affordability before taking any decision to grant credit. Dispute resolution systems utilized in the credit industry are well developed, and a dedicated credit bureau for maintenance disputes could benefit from existing systems that are mainly processed online. Many South Africans have access to smartphones and the internet. Statistics indicate that there are 26.3 million smartphone users, 41.19 million active internet users, and 28 million social media users in South Africa. The World Economic Forum suggests that governments change their current approach to public engagement and policy making to rely on sources which are made possible by new technologies. In conclusion, the Maintenance Act has not kept pace with the modern world. Access to justice in maintenance cases can be achieved and delivered by using technology. The credit industry has a responsibility to limit over-indebtedness and stop extending reckless credit. Maintenance defaulters will be minimized and prevented from hiding assets and finances. The implementation of the proposed system shall: 1. Bring speedy relief to many vulnerable women and children. 2. Give government control over a problem that is out of hand. 3. Bring irresponsible parents to book. 4. Hold the credit industry accountable to limit the extension of credit qualifying applicants only. 5. Offer practical solutions to a massive socio-economic problem. 6. Create job opportunities for ADR practitioners. 7. Change social behavior for the better. And 8. Create a culture of parental responsibility. The Constitutional Court found in the Grootboom case that it is a function of the state not only to provide a good legal framework, but to put in place systems that will enable these frameworks to operate effectively. I thank you.
Morei, thank you very much, Morei. I think this mic is not working. Oh. Okay. Morei, thank you very much for your presentation. Very, very, very informative presentation. I think, it just shows that there's so much that still needs to be done. Well, the board is growing, and I think, with us engaging with the social foundation, social justice foundation, and the activities we have going forward will set us in good standing. Hopefully we can change the world eventually.
I thank you so much.
Thank you very much. Are there any questions, ladies and gentlemen? Nothing at the moment.
Yeah, there's one question.
Yeah.
Why do you suggest a dedicated credit bureau into an existing system?
Can I?
Thank you. A dedicated bureau will receive the necessary information and then filter it through SACRA, which is an organization that all credit providers, the banking industry, etc., belong to. to make sure that they share identical data. If they make use of different credit bureaus, that might cause confusion. So it's practical, it's simple. Yeah.
Is there any follow-up question? Okay, excellent. Thank you very much, Lori. Much appreciated. Ladies and gentlemen, our next presenter is Dr. Arda Spijker. She's a senior lecturer at the Faculty of Law, University of Limpopo. Arda.
I'm not sure whether I'm audible and visible.
You're audible. While I get your slide up and running, would you mind introducing yourself and then we can take it from there?
Okay, thank you very much. Yeah, greetings from Polokwane. It's hot here. And thank you for the opportunity to present. My name is Arda Spijker and I am working at the University of Limpopo School of Law. This presentation is actually about the approach followed in the Netherlands with regard to family conferencing. And what I'm going to try is to emphasize the importance of family group conferencing as it also has been mentioned in the Children's Act. But as far as I know, it's not really used often, which is a great pity. Right, there we go. Hey, there I see some familiar pictures.
Arda, you can just guide me and then tell me when to move on to the next slide.
Okay.
The floor is
All
yours,
right.
ma'am. Thank you.
I will do so. Thank you very much. Yeah, some of the aspects that I'm going to mention have already been touched upon by the previous speakers. But yeah, that only then indicates how important those aspects are. I assume that everybody actually is aware of the concept family conferencing or family group conferencing. You know, those words are used interchangeably. It's a concept that actually originates from New Zealand. Can we have the next slide, please? Sorry. Yeah, there are something like 16 slides, so I don't know.
There we go, ma'am.
Okay, thank you very much. And as mentioned in the Children's Act, reference is made to this form of problem solution. The children's courts may cause a family group conference to be set up, and then the role of the children's court is that it must be a suitably qualified person or organization be appointed to facilitate the process and prescribe the manner in which the record is kept of any agreement or settlement reached between the parties. And then the court also considers the report and you know, when the matter has been heard. In the regulations, there are certain specific guidelines as well. The thing is, and I don't know, perhaps some of the participants have got different experiences, and it really would be great to interact a bit in that respect. But you know, the kind of system as such, the concept as what people would approach a family group conflict, as far as I know, is not really functional. It's not often heard. I spoke to magistrates whether they use it, and they've heard about it, but that is more or less it. So that is really, you know, a pity. And it also actually is in line with the general principle in section 6, subsection 4 of the Act, that in any matter concerning a child, an approach should be followed which is conducive to conciliation and problem solving. Yeah, one could then ask why the Netherlands? Next slide, please. Oh, thank you. Yeah, I think that I thought I was going to deal with the slides myself. So yeah, so there are a couple of subsections. Thank you. Yeah, so why the Netherlands? Well, the reason is actually threefold. In the Netherlands, there is an established practice. A few years ago, I actually had a privilege to attend the training, which is quite involved. And I have been involved with the NGO Eigen Kracht in the Netherlands for more or less 20, 21 years. So they actually have gone quite a long way and refined things and so on. And through lobbying by the organization, by the NGO, legislative amendments were made. So it is now actually part of the act in the Netherlands. The thing is that whilst in the Netherlands there is an established practice which is successful, family group conferencing in South Africa has not yet reached its potential. Well, that is my opinion. And then most importantly, it empowers actually families to find solutions for their own problems. Which of course is really important. Okay, background. It stems, as I mentioned, thank you for that. It stems from the Maori culture. In the 80s, there were certain problems with regards to the Maori people that they encountered certain problems. Which actually then resulted in the removal of children. And people found that certain cultural aspects, customs and so on, were not taken into consideration. That then led to certain legislative reforms, which then in the end kind of resulted into an act, the Children, Young Persons and Their Families Act of 1989. And that actually act provided for certain customs, and indigenous knowledge being part of the act. That approach in New Zealand has been an inspiration for many countries actually across the world. Various initiatives started pertaining to family group conferencing. And let's face it, it is not unfamiliar to the African setting. Now, Skelton and Frank actually mentioned in 2001 already that conferencing is like returning to our future. Even if you think in terms of Ubuntu, it's definitely not kind of a foreign concept. Some people might think, well, all these things from overseas, we don't need that, we have to do our own thing. Well, there are always lessons to be learned, but also to reflect a bit on what is actually part of our heritage. And talking, trying to resolve disputes and so on is definitely part of the approaches that I have seen around here. And in the Netherlands, as I mentioned, the organization is called Eigen Kracht, Own Strength. It is an independent organization and it actually facilitates family group conferences. It provides for training and workshops. training of independent facilitators, which is an important part of which I kind of get back in a moment. And then since 2000, there have been over 13,500 of those conferences already financed by the local governments. I'm not going to get into too many details with regard to that. I just want to focus on the main aspect. Where can it be used? Well, it's actually widely applicable. If people choose to offer families, family context, individuals, you know, even in labor issues, it's widely applicable. After wrongdoings and crime, with child offenders, domestic violence, some people don't agree with that, but research has shown that it can work. And then for groups, neighborhoods, and schools, we all know that bullying is a serious problem. So school circles, you know, have got a similar approach to the family group conferencing idea. So it is really widely usable, actually. In the Netherlands, for example, we have an issue with regard to, we call them hangjongeren. Those are youth that are actually in the streets, sometimes armed and so on. Similarities to what we kind of see here sometimes. And research has shown that the approach of family group conference could be used finding solutions to deal with that and to stop the harassing of people in the neighborhood. Getting started. Next slide, please. Thank you. Right, that is a photo of the independent coordinator that is meeting with the family. And that is actually the start. Well, people actually connect with eigen kracht, that they express the need to get a conference. Sometimes it's a professional social worker that connects with eigen kracht. But anyone actually can ask for a family group conference. So it starts with a request. And the preparation phase is really important, and that is where a big difference is with the South African way of how it is stated in the Act. The independent coordinator is trained and supervised in the first few conferences, and is actually the main focus of the independent coordinator is that he or she or they prepare people for the conference. So what does that then entail? Well, in the first place, they help the people concerned that have asked for that conference to who should be invited. And sometimes you will see that people will say, well, we only know the neighbors or something like that. Well, the thing is that the coordinator is trained to help to think, to brainstorm with the people, like who else could come to the conference, to widen the circle. So it could be teachers, it could be neighbors, it could be family, but sometimes people don't have family in the country. It could be anybody that you have been dealing with. So sometimes a GP would attend, or a teacher from school, or a social worker that is involved. So they try to widen the circle, and then the individual, independent coordinator will visit these people and then also ask them, like, who do you think, who else should be invited? So it really is focused on making the circle as wide, as big as possible. Now, the average at the moment is more or less 10 to 12 people, but in the past we had groups of 25. Yeah, the meetings with individual people that can be done often happens. It's also an indication by the persons that ask for the conference. Sometimes it could be a certain family member that could play a crucial role in the process if there are certain family dynamics where people don't see eye to eye or something like that, or where people could be scared, then the coordinator would ask, like, you know, what is needed to make you attend the family group conference? What is needed to make sure that you feel safe? Yeah, now that I leave the venue and the catering. The conference as such, this photo actually provides an example of shows how it can work. People are kind of getting together, and the process consists of 3 phases. Obviously, the coordinator explains why everybody is here, although everybody already knows that. But then the issue is highlighted. Like, for example, what can we as a group do to prevent the removal of little Charlie? There are certain issues at home, etc., etc. That is something very important. There are certain rules that people kind of agree upon, and everybody contributes to that to make sure that everybody is heard, and that it is actually the process of the group as such. A social worker, psychologist, teacher, probation officer, they sometimes also attend, but only in the phase of information sharing. And sometimes these professionals also make clear that there are certain minimum aspects that need to be covered in the plan. For example, a child should sleep in its own bed, or when, for example, the stepfather is around or something like that, that there are certain requirements and so on. So it's very focused on the specific issue. Oh, here we go. Yeah, sorry. So that last aspect is then that a professional can set a non-negotiable demand. That can be included in the plan, otherwise the plan will not be. And then also assistance is available, and what kind of assistance is available or applicable in a certain case will then also be explained. Next slide, please. Right, the second phase is the family time. The interesting thing is that during this session, it's a closed session where the professional and the independent coordinator leave the venue. They are still on standby, but they leave the venue, and it's totally up to the family to deal with the issue. So they brainstorm on how to address the problem, who would like to, or who can do what kind of actions are required to address the problem, and who's going to take responsibility. So the action will be put on the flip chart, name will be put on the flip chart, time frames where relevant will be mentioned. So everything is put in writing, and that is then presented to the independent coordinator and the professional if that person is involved. So the professional, if there is such a person involved, needs to accept the plan as such. And then after 1 month there is a follow-up. So the next slide, why is it so powerful? well, as some people say, the family or the people concerned, they own the problem and they own the solution. It widens the cycle or circle. The problem is actually centralized. It's explained. Everybody is prepared beforehand, knows what is actually the situation, and so on. So it's really focused on problem saving by the network. What I really like is the fact that the participants are able to express feelings and ideas. The psychological effects of this kind of approach cannot be underestimated. Everybody needs to be heard, including children. And children are also part of the family conferences in the Netherlands. And then, Peter Hilhorst, he actually referred to the wonder of FGC, or conferencing, that it brings an end to the so-called life boy tragedy, where previously a social worker would throw out a live boy and people actually would grab it and try to save themselves. In this instance, people would actually learn to swim instead of just grabbing the live boy that is provided by a professional. So in 85% of the cases, a plan is made so that agreement is then made, and the independence is really, I want to stress that the independence of the, of course, the independent coordinator is really important in the sense that the person doesn't have any influence in the contents of the plan, but also there is no interest at all by this person, and the satisfaction rate, the report mark, so to say, is generally between 7.3 and 8.2, and that is then established by the participants afterwards. Now, returning to South Africa, I don't know how much time I still have, so I'm going to speak slightly faster. In the Children's Act, reference is made to a number of sections that provide for involvement of the child, and the child to be or heard, or that at least the views are taken into consideration, as sections 10, 61, and 31. And it's not my intention to say we should copy and paste the system as used in the Netherlands, not at all. In fact, the Netherlands can also learn certain things from South Africa, because it is wonderful in a way that the court here in South Africa has to approve the plan, which does not exist in the Netherlands. But the thing is, what I actually would like to say here, that, and it was mentioned earlier on by some others as well, that whole change of frame of reference by professionals, whether we are talking about legal practitioners or magistrates or judges, or, that across the board, as social workers, that roles change. Roles have to change. I mean, change is the only constant factor, as we know. So, so we really have to try to make that happen and to think about it. So my recommendations for South Africa, thank you for the hints. I have to wrap up. I would like to see that a committee would be set up to organize a seminar with relevant stakeholders in order to come up with an action plan to really take this approach forward, to fine-tune the system that is mentioned in the Act, and to also provide for the training of independent coordinators and other professionals, the social workers, the magistrates, etc. Job descriptions might change, But that's not that you will be without work. It was touched on earlier on as well. But the thing is that the change of your frame of reference, perceptions and so on, that requires training and communication. I'm convinced that we could learn from the experiences in the Netherlands to further develop family group conferencing in South Africa and to realize a consistent implementation of high quality in that the model can be fully utilized, which ultimately will enhance the rights of children, and that's what I'm passionate about. Next slide, please. So nothing is as strong as your own strength, hence the fact that the organization, the NGO, was called Eigen Kracht, own strength. Making a plan together, deciding together about a child's future or the person that is central in this family group conference. And then allowing children and others to participate in a decision-making process that affects them. And then lastly, for more information, we did publish a paper 2 years ago in PUR. And if there's anyone that could kind of or would like to, brainstorm a bit on how this can be taken further, then please send me an email. And thank you very much for your time. It was a privilege to be able to share this with you. Thank you.
Thank you very much, Sandra. A very interesting, presentation, comparing the Netherlands with South Africa. I know that Prof. Yunki de Jong will also be here tomorrow. And she's featuring quite a bit here at our faculty. She is the supervisor of our previous presenter also. Thanks again. We really appreciate your presentation. Our next speaker, before we go on, just let me just check if there's any questions or any comments. Nothing at the moment. All right. Thank you again, Ada. We really appreciate your presentation.
Thank you.
Ladies and gentlemen, our next presenter is Prof. Whitear-Nel. Prof, are you online?
I am. Can you hear me and can you see me?
Just give me 1 second, Prof. Like I said, I've got some serious technological challenges, so in a personal capacity. All right, ma'am. I know you don't have slides, and I know that you're going to. The floor is yours, ma'am.
Thank you very much. So thank you firstly to the West University and to Sikandar and Riet for the invitation to present here today. One of the reasons that I don't have a PowerPoint presentation is because the area that I'm going to be talking about is something that I've started thinking about. I've been thinking about it for a while, but I'm applying my mind a little bit more seriously to it now. And so what I have at this stage is not a paper as much as some thoughts that I've jotted down that I want to share with you. And I'm hoping to be able to get some feedback that will help me think through some of the issues. So I am a professor of law at the University of Cape Town. My specialization is in the area of legal pluralism and religious family laws and human rights. So I especially look at the relationship between freedom of religion and women's rights in the context of religious family laws, and most of my focus so far has been on Muslim family law, but I have also been thinking through issues around Jewish family law and Hindu family law. So today I want to talk about the issue of arbitration in religious family laws. Now, we know that historically arbitration has not been a medium that has been recognized legally in the context of family law in South Africa. I'm not sure if that is going to change at any point. But the reality is that arbitration is being practiced within particular communities in our country, within the Muslim community and within the Jewish community. The Forum of the Beth Din facilitates such arbitrations. And in the Muslim communities, within various structures across the country, in Cape Town, for example, arbitrations are conducted through the Muslim Judicial Council. And then, of course, whichever ulama structure is applicable within a particular area or province across the country. So, I suppose some of the questions that I'm trying to think through is, well, should these religious arbitrations be given legal recognition, especially in light of our recent Constitutional Court judgment that basically rendered the common law definition of Muslim marriages the common law definition of marriage unconstitutional to the extent that it doesn't recognize Muslim marriages, and then also finding specific provisions of the Marriage Act and the Divorce Act unconstitutional to the extent that they do not include Muslim marriages. And of course, the Constitutional Court judgment has in effect rendered Muslim marriages, in my opinion, legal. They just now have to be regulated. So what does this mean then for the arbitrations that happen within these Muslim communities? I'm going to focus on Muslim communities, given especially that our Constitutional Court has made the finding that it has. And within the context of Muslim communities, and if one considers the MJC, the forums are referred to in different ways. The MJC conducts what is commonly referred to as a talaq forum. Now, talaq is actually a form of repudiation by the husband of the wife. And if it is rendered thrice, then it renders the divorce irrevocable. And the parties then cannot reconcile unless the wife goes through a process called hilala, which means that she needs to marry another man, they need to consummate that marriage, and then that marriage needs to dissolve either through death or divorce before she may remarry her first husband. But the talaq forums actually function a lot wider than what the name actually suggests. And so typically a woman will bring an application for fasakh. Fasakh is also a form of, it's a judicial form of dissolving a Muslim marriage. In a Muslim majority country, the application would be brought to a court, and if Islamic law grounds that are recognized for the dissolution of the Muslim marriage exist, then the court may grant the fasakh. In a Muslim minority country as ours, a wife would bring the application to the ulama or to an imam, and in this case, the MJC. And she would stipulate the grounds for wanting to dissolve the marriage, and the ulama would then conduct a hearing. But the hearing usually is preceded by some form of arbitration, where they try to see if they can bring the parties together to reconcile. Now, a master's student of mine did some research on the talaq forums that were conducted by the MJC a while ago. And what she found was that where the fasakh applications were not attended by the husband, that is when the MJC would be more inclined to grant the fasakh applications. But if the husband appeared at the hearing and he objected, then even if Islamic law grounds existed for the dissolution of the marriage, the fasakh application would not be granted. I mean, even in the context of abuse, where the grounds, where she was alleging abuse by the husband against her, the ulama would be more inclined to try and, to basically send them back home, see if they can work things out, and ask her to be patient. It appears the impetus for arbitration comes from a Quranic verse. I think it is 2:29, where the Quran is basically saying to married couples that in the event that there are issues, she should bring one to act as an arbiter, and he should bring one to act as an arbiter. In other words, bring along a representative, and the word arbiter is used. And so the assumption has always been that we're talking about an arbitration process, but actually, if you unpack the Islamic verse, it talks about bringing these arbiters to help address the issues and to help the parties reconcile. And if they cannot reconcile, then they must part in kindness. So to my mind, the verse is actually speaking to some form of mediation. But it has been interpreted by members of the ulama as an arbitration process where the ulama makes a finding. So it is, it is a bit complex. It's not simply an arbitration. It also acts as an adjudication forum. And so the question is, these forums, these methods of adjudication of dispute resolution are happening within our communities, often with women having adverse findings against them, and often with women being subjected to very androcentric, male-centered interpretations of Islamic law, even when progressive interpretations exist that could come to their aid. So what do we do? Do we simply ignore what's happening in our communities? Do we require the state to provide some form of intervention? And if so, what would that intervention be? And so some guidance could probably be sought in jurisdictions like Canada, for example. Well, not guidance, but I mean, if one, where similar questions were asked, around about, I think it was 2003 in Ontario, there was a controversy around the establishment of Sharia arbitration tribunals. And many of the women's organizations challenged the awards arising out of those tribunals being legally recognized. Now, of course, Canada, the difference in Canada is that the arbitration acts do make provision for arbitration within or religious arbitrations. And actually up until that point, and because of that, up until that point, any awards coming out of those religious arbitration forums was in fact legally recognized and enforceable, but they were not subject to appeal. They were only reviewable. And of course, as a result of the controversy, the arbitration acts were then amended, and so religious arbitrations are no longer, or awards arising out of those arbitrations are no longer legally enforceable, but they do continue within the communities. I interviewed one of the imams at the time who said to me that the changing of the law didn't make a difference in the community. They continue. One of the suggestions during that process was, well, if we do make them legally enforceable, we should actually then subject the process and the findings to some kind of regulation. Now, Farah Ahmed, who is a professor at Melbourne University in Australia, has done some work on arbitration, or has been thinking through some arbitration in the context of India. And so she is of the view that you can't ignore the existence of these forums. Of course, India, again, is a different context because their religious personal law systems and religious family laws are recognized. And her argument is they should not simply be recognized and left to the devices of the communities, the religious communities. They need to be subjected to some form of regulation. And so, and we see that to a certain extent in the now shelved Muslim marriages bill. One of the selling points of the bill at the time that it was drafted and submitted to the Ministry of Justice. This was in about 2000, I think. Was the Muslim community agreeing to the bill if a space was carved out for them? Well, when I say Muslim community, I'm talking about the ulama, the religious leaders. And one of the selling points for them was a carving out of a space prior to court intervention where they could arbitrate the dispute. And what the bill at the time encompassed was a provision that said whatever agreement came out of that arbitration process, unless it affected the interests of minors, would simply be rubber stamped by the court. Judicial oversight would only happen in the case where the interests of minor children were affected. Of course, in 2010, the Department of Justice and the 2003 bill made that process compulsory. In 2010, the Department of Justice amended the Muslim Marriages Bill and changed the requirement of compulsory arbitration to voluntary arbitration. And that, of course, set the cat among the pigeons, because the Muslim community wanted control over that space. So that's an important space for members of the ulama. Given the fact that our constitution, through section 15(3)(a), creates that enabling space for legislation that will recognize religious marriages. And of course, the Department of Home Affairs is in the process of drafting that legislation, which of course is also generating a lot of controversy. But the Constitutional Court's judgment also makes it possible for existing legislation to be amended to recognize and regulate the consequences of Muslim marriages. And so we also have a process where the Law Reform Commission, at the moment through an advisory committee, is looking at amending the Matrimonial Property Act. And I'm a member of that committee as well. And we're looking at how we can regulate the matrimonial property consequences of various types of marriages and intimate partnerships, including Muslim marriages and other religious marriages. So the question of arbitration, I think there's room to argue within the Constitution through section 15(3) and through section 31(1). That makes provision for communities, religious communities, to manifest their religious beliefs in association with others, to argue that religious arbitrations can in fact be brought within which is very much a private function, can be brought within a public domain for public oversight. And so I am still thinking through the options and where we stand, but I'm sort of inclining towards, yes, the space should be given some recognition, but not without regulation, not without some kind of judicial oversight. And certainly if awards come out of that process, they can't just be subject to review. There needs to be some form of appeal. At the same time, I anticipate backlash and challenges against that, how can a secular process assume the authority to oversee religious rulings? But if it is legislated in some way or the other, it brings it within the purview of the judiciary to be able to grant that oversight. yeah, so I'm just checking to see if there are any other points that I have left out or need to still mention. I think I want to just end off by saying that it's my position in relation to religious family laws, and we have an enabling constitutional environment for this. That because of the way in which religious laws are interpreted and applied within communities, there is a discriminatory adverse effect on women, especially, right? And so recognition and also regulation of those processes becomes important. And they have to be subjected to the Constitution to ensure that when in the process of trying to balance freedom of religion and women's rights, that we don't end up with a situation where women's rights continue to be undermined. Thank you.
Thanks very much, Prof. Quite interesting, that we speak about this, and specifically, with the new Muslim marriages bill being, out there, and in my personal experience, there's a lot of ulama, a lot of the mulanas, the priests, whatever you want to call them, making a big hurrah about their rights in terms of officiating the marriages, and there's a lot of issues around that going on at the moment. I think we still got a long way to to get to the ideal position we'd like to be in. So in addition, I think when we speak of impartial third party arbiters, are they actually impartial third party arbiters, or do they have and I don't want to sound as if out of ignorance on the subject, but I'm not a fundamentalist, but we need to obviously view these situations, from a proper impartial third party perspective. But yes, it's interesting times, and I think it's very important, that we open up the floor, and people, start appreciating these alternative, dispute resolution fora and methods. I mean, litigation costs. Brownlee versus Brownlee is a very good example of what litigation costs could incur, and also the time it takes to deal with disputes, especially family disputes. And from this, from your presentation, from different not religious, but different cultural perspectives also. Let's just see if there are any questions or comments. There's nothing at the moment. Prof, thank you very, very much. It's been a pleasure to have you, with us today. We're going to take a break for 10 minutes, and then Faith Leburu will do a presentation, and thereafter Natalie will follow. We're going to take a break. Thanks so much, Prof. Take care.
Thank you.
Be in touch, man. Okay. The time now, ladies and gentlemen, it's 5 to 3. We will be back at 3:05. Thank you. Yes. Can I suggest you present from your end?
For some reason, I can't share my side. I've just looked.
Okay, you should be able to do that now. Okay, that's excellent.
Can you see?
Okay, I'm going to just close that screen, and I think you can go to presentation mode. Natalie, please would you introduce yourself, and then the floor is yours, ma'am.
Thank you, Advocate Kola.
Thank you.
Good afternoon to all the colleagues online. What an absolute honor to share my heart on a topic I am passionate about, the rights of an unborn child. Again, thank you, Advocate Kola and Northwest University, for the opportunity and the organization of this colloquium. Just to introduce myself and some of the work that I do, I am an accredited mediator, mediating in full spectrum family matters, harassment, and domestic violence matters in both private practice and court-referred matters at Wynberg Court. I am an amplifier for the NSP and currently running the 100-day challenge at Wynberg Court, where we are mediating cases in the domestic violence court for 100 days. We have just passed the halfway mark, and I just want to say what an exciting time to be doing this kind of research. I also sit on the EXCO board for Social Justice Association of Mediators, and I am an advocate fighting against human trafficking and passion, restoring families and healing communities. I'd like to say from the onset, I am not a legal persona, but having an inquisitive mind and aware that mediation operates in the shadow of the law, I will be discussing my thoughts around pieces of legislation with regards to unborn children and maintenance. I'll be sharing from experience with such a matter I mediated, and I'm hoping to highlight the benefits of mediation and show how mediation can bring about beautiful solutions in moments that are uncertain for all parties involved in an unplanned pregnancy.
Natalie, can I just interrupt you a second?
Yes.
Where my cursor is at the bottom, can you just click on that, and then that will open your presentation as a...
Where your cursor is?
There, that button there, so that will just go to presentation mode on your screen. Where my mouse, where my cursor is at the bottom, just above your Teams, that button there.
This one. Sorry, I don't see it.
Okay, just open up your slide again. Sorry.
Sure.
Okay, the bottom of your screen, just above your Outlook, go more right. Some more. No. Yeah, that one. Yeah, perfect.
Okay, you got it.
No, it's in presentation mode now. Now you can just scroll up and down. Thanks.
Fantastic, thank you. So I'm hoping to highlight the benefits of mediation and show how it can bring about beautiful solutions in moments that are uncertain for all parties involved in unplanned pregnancies. I'm hoping to share the psychological and traumatic impact pieces of legislation can have on parties, and hopefully impart my absolute belief and passion for mediation as a form of ADR to facilitate disputes where the law does not provide or it curbs the rights of parties. I have changed my topic from the one you see on the program. The key focus of this talk was accepted in an article for publication by De Rebus shortly after I had agreed to speak at this colloquium. My topic, therefore, will be mediation as a tool to uphold the rights of all involved in an unplanned pregnancy securing the future of an unborn child to maintenance where local and international legislation does not make provision. This notion stems from a recent mediation I did, and I realized this reality is far more prevalent than we want to admit. This is what I love about mediation and being a mediator, is that I'm forever impacted by my clients and their stories. I haven't stopped thinking about the sentiments that came out of the pre-mediation sessions with both parties. And I felt convicted to delve more into the dynamics that presented, such as the father not wanting the child for his own valid reasons, and the mother wanting to keep the child and her fear of the child's future. Once again, I am impassioned by the beauty of raw feelings when parties feel safe and brave enough to go there by having conversations around the very things that bring them great turmoil, with the hope for an outcome. Now, this is exactly the space mediation created for these parties, and the resolve was the most amazing transformation and still is for them, as they keep me updated in how they have evolved in communication, yet they still remain at the positions they held prior to mediation, being he not wanting to be a present father and she wanting the baby with security of financial support for the baby. But they chose to do things amicable and with respect for each other, upholding the rights of the unborn child. I love what Sandra Hitchcock said earlier, that we need to get to the bottom of the conflict for parties to comply with the agreement and for the transformation to take place. Now, this story I'm about to share with you is the story of many other women, and they're often at an economic disadvantage when they fall pregnant, specifically in South Africa, as well as some countries around the world, such as East Asia. I mediated a case that was in South Korea, where a woman had lost her job when her employer found out she was pregnant. Being a South African with no family for support, she was in a compromised situation in a foreign country, and she was referred to me for mediation by her therapist. The unfortunate truth is that in South Korea and South Africa, this woman would have to wait for the baby to be born in order to apply for maintenance for her child or for some kind of financial support during her pregnancy. Mediation unpacked the complexities of her situation. Number one, it recognized she lost her job. She was no longer able to support herself and her other minor child. This further exacerbated her financial position in that she could not further afford medical insurance in a foreign land and pay her creditors in a foreign country. It also unpacked the fact that because she couldn't afford to pay rent and live, she also didn't have money to pay for school fees for her other minor child. And this all put her and her minor child in a compromised financial position. And I ask you to track with me because I want to paint the picture for many women in this predicament. We know that in South Africa's labor market, pregnant mothers have no realistic goal of attaining meaningful employment during pregnancy and post for a period of time due to their bodies recovering from birth. Internationally, we also see, like in the case that I did, it can be an uphill struggle where women or pregnant mothers face dismissal and other challenges during pregnancy that is mercilessly rejected by national and international maintenance courts. This causes emotional and psychological distress for the woman, from which the research has shown us has a negative impact on the unborn child and could result in a high-risk pregnancy. Bringing all of this back home to South Africa, when a woman falls pregnant, she is not allowed, in terms of our domestic legislation stipulated in the Maintenance Act 99 of 1998, to claim maintenance from the moment of conception until the birth of the child. Meaning, for 9 months from conception to the period of birth, the mother is left compromised financially and has to make ends meet on her own, or has to depend on the goodwill of family and friends for 9 months of pregnancy before she has a statutory right to claim maintenance. This has stripped women of their dignity, their self-esteem, and it often puts her career on the back foot. Let's look at our Maintenance Act to understand what provision it makes for pregnant women. In Section 16, subsection 1A, Roman numerals 2 of the Maintenance Act 99 of 1998, it provides, after consideration of the evidence adduced at the inquiry, the maintenance court may, in the case where there's no maintenance order, where there's no maintenance order is in force, make an order against such person. If such other person is a child, for the payment to the mother of the child or of such sum of money, together with any interest thereon, as the mother is in the opinion of the maintenance court entitled to recover from such person in respect of expenses incurred by the mother in connection with the birth of the child and of expenditure incurred by the mother in connection with the maintenance of the child from the date of the child's birth to the date of inquiry. This essentially translates that the mother has no other option but to keep account of all her expenses, such as pregnancy checkups, tests, scans, and any medical attention she might need from the date of conception up until the date of inquiry in the maintenance court, or the day that the court decides on a quantum for her maintenance claim. This is known as laying in expenses. Without an income, it does further compromise her well-being, and this can be a tedious exercise for a mom and can also experience it as a traumatic experience while dealing with her other emotional battles. We know this can be delayed by the father denying paternity and the expenses because they're often in a space of hurt emotions such as anger, rejection, and resentment. These are all prevalent to the outcome and the fight the parties often put up. Whereas in mediation, we can deal with these underpinning issues and feelings. Another principle in law presented, the nasciturus fiction. It originates from the Roman law, which was first applied in South Africa in 1909. You can read more about this in the Durabus article that I have written, but let's look at the definition of nasciturus fiction. It says, a natural person's legal personality begins at birth. Before birth, a fetus is not a legal subject and therefore not the bearer of rights, duties, and capacities. Legal personality begins if the following requirements are complied with. 1, the birth must be completed. 2, there must be a complete separation between the body of the mother and the fetus. 2, the child must have lived after such separation, even if it's for a short period, as shared by Morei and Ettian in the South African Law of Persons. Under normal circumstances, a fetus will only then become a legal subject. A situation may arise before the fetus acquires legal personality, which is in favor and for the benefit of a fetus, but which he can openly enforce once he becomes a legal subject. The law has to protect the potential interests of a fetus who may, under normal circumstances, be born alive and has done so by means of the nasciturus fiction. The nasciturus fiction operates if the nasciturus was conceived at the time of the benefit, would have occurred to him, and the child must subsequently be born alive. If the child is not born alive, he is considered as never being conceived for the purposes of this benefit. In the matter that I mediated, it became apparent that the father has a high-risk job, and in considering this, they both began thinking how best to make provision for the unborn child in the event of his death, taking into account that the mother was not working in the interim and will most likely take a while after birth for her to return to her job in East Asia. In supervision and reflection, I realized in terms of our law, mothers can only claim maintenance once the child is born. In the unfortunate event of the father passing away during pregnancy, mothers will face a formidable battle trying to claim maintenance from the deceased estate of the father and have to negotiate her maintenance claim with the executor and further claim her rights via the master of the High Court's guardian fund, which we know can take up to a couple of months. And so with all consideration, I strongly believe we should be applying the Niscatorius fiction from the moment of conception in cases where both parties agree on paternity. This is not possible in the maintenance legislation, but it definitely is possible in mediation. Another consideration in this particular case is that if a mother is not able to return to her job in East Asia and decides going the court route to claim maintenance, the problem that arises with the international REMO Acts is that some countries in Africa are limited to the reciprocating countries who signed the treaties. And in this instance, in the case that I mediated, South Africa and South Korea do not have a treaty between them. But mediation can transcend these limitations and conclude mediation agreements and parenting plans beyond the scope of the UN conventions, treaties, domestic and international legislation. Colleagues, I share this with much passion, and I think that we are all wanting the best for humanity and seeking ways to assist parties for a place of fairness and equality. And I am not always convinced that our current legislation acts in the best interest of all parties, particularly mothers and her existing children that she might have, fathers that for their own very valid reasons don't want children. I am therefore convinced that mediation can surpass local and international laws by an agreement of parties who choose to enforce the agreement because a common understanding is reached and security that was needed has been sought and undertaken by the parties. I cannot go into much detail, but I, however, do want to share the beauty of when parties become so raw and vulnerable about their needs, fears, and uncertainties. These parties undertook to make decisions that unfolded in the best interests of all parties and the unborn child. In my opinion, the contract signed was worded in a way that paternity cannot be questioned in future. It saved lots of court time for both parties if they were to wait for the child to be born and for the mom to do the line in expense exercise. Mediation ultimately resolved any need for legal costs. Towards a baby once the baby is born, with a yearly increase and open to amendments should the mother decide to go live in East Asia, where the cost of living is far more expensive. I believe they're in further communication about the future and the security of the baby. If there's anything I can highlight, listening, and I hope that I have stirred some thoughts for consideration in how mediation restores the dignity and sets the way forward for those in dispute. Thank you.
Thanks very much, Natalie. It will be interesting to read your paper once it's in the rebus. We understand why you had to cut it short. Obviously, we needed to get some permission from them first. But noted, and we appreciate your presentation. Thank you so much for your patience. And I know it's the last stretch of the day, so let's just keep it on for another hour or so. I'd like to introduce our next presenter, Anneke Greyvenstein. She is going to present from the venue. Anneke is from the Social Justice Foundation. She's the chairperson of the Social Justice Foundation. I stand to correction. Anneke, the floor is yours. I'm just going to open up your presentation quickly. You're going to have to use this mic, right?
Fatih, is it now? Is it not? Oh, that APP
Last one, no.
Is it done? Okay. You can just use this mouse to scroll up and down. Oh, this one, yeah, up and down. Okay, sure. Just stay. Perfect.
Okay, well, thank you very much for the opportunity. My topic is parenting plans are challenging to manage between parties and as a consequence. But
Let's take it, Michael, a little higher. Yeah. Thanks, Anne.
okay, is that a little bit better?
Here, presentations on the screen. Okay. Presentations on the teams. It's yeah. Share.
So yeah. So I'm a little technologically stupid, so just bear with me.
No.
Okay. Azijn. Is het daarin?
Is daarin.
Oké, dan zijn. Perfect.
Okay, seeing that is the great shift and I get a second chance to start over. Let's try again. Parenting plans are challenging to manage between parties and as a consequence. We developed our parenting. It was a process for mediators, and being in the industry since 2006, this process took almost 4 years. The mediators that developed this co-parenting app has been in the industry and has been running pro bono projects in the courts in Gauteng. So there was a lot of experience that went into this app that we developed, and I hope you're going to see the value in this, that it's not only for the well-being of our children, but it's also a tool for our professional environment, our family practitioners and mediators to use as a tool when they do mediation and when they manage the parties afterwards, once the parenting plan has been drafted or the divorce settlement agreement has been handed over to the attorney. In the maintenance work session that we had in June with the Department of Justice, we actually said that we would like to see a transdisciplinary approach. In other words, we would like to work multi-sectorial. Now, that is the big picture. The co-parenting app is the one step closer to the parent, where we interconnect the parent with various services that's available in the market. This is not being done previously in South Africa, and the co-parenting app going forward in our presentation, I will show you that it's linking straight to the credit industry, and eventually I would like to see that we also have a link to the Department of Justice so that we can help our parents a lot sooner going forward. Now, why do we want a co-parenting app? The main reason for me as a mediator to get a co-parenting app is to see what we can do to get co-parents to avoid disputes. The second reason why I would prefer to have a co-parenting app is we will not have the situation in a mediation room where it's he said, she said scenario. A further reason is to also create a systems directory to help parents. A lot of parents that we do see struggle to get help from various sources, and they don't always know where to go and look for the assistance that's necessary. Even after the mediation, we need to look at restorative practices when it comes to restoration and healing. Why a multifactorial approach? I won't labor this issue because that's not the reason why I'm here. I would just like to leave the idea with you, and the idea is that this ecosystem where we digitalize family services will close the gap we currently have between the maintenance courts, the Department of Justice, the services that they render, and then also the credit industry on the other side that's been operating for decades in a silo approach. And that is the entry point for parents is the co-parenting app. There's various co-parenting apps available on the market. Our co-parenting app is not the first in South Africa, but I would definitely like to say that it's the first app that's going to link our parents directly to the credit industries through the cooperation with CPB, the Consumer Profile Bureau. Our app is multifunctional. Other apps that's available on the market, you get your scheduling of calendars where you look at contact and care arrangements, and then there's other apps available where you can have expense trackers, but the co-parenting app that we've developed are actually incorporating both parental rights and responsibilities. We would like to simplify communication between parents. We would like to make sure that parents are always informed. We would like parents to be able to communicate about the well-being of their children. But the most important thing for me is the fact that this is a neutral communication platform, but it's also an electronic parenting plan, and it's access to justice. The mediator in the pre-mediation meeting, what we do at Social Justice is to say, there's the co-parenting app. Go and have a look at the various options available for contact and care arrangements, and go and think about what is probable, what is going to work in your circumstances, so that when you do come in for your mediation, you are prepared and you had an opportunity to consider the various options, and you can go forward and finalize a lot quicker. The app is available in Google Play and Huawei, and currently it's in the Apple iStore in final review. I can't tell you, I'm not an IT specialist. I've learned a lot about IT in the last 3 years, but when that process is going to be finalized, I have got no idea. We would like to say it's going to be the end of the month, but it's been the end of the month now for quite a while. So we will definitely have a big celebration when it's live in Apple as well. But currently, you can go to our website and you can even download it from there. There's our website, co-parent.co.za. It's a very simple, straightforward process. The one parent will download the app, register with a cell phone number, set a password, and invite the other parent to also become part of this platform. The cost per annum is actually, in my opinion, very cost effective. It's 50 Rand per annum per parent. So it's very affordable, even in the South African context. The electronic parenting plan creator, this is your first screen that you're going to see. Only after 30 days, you're going to get a notification where you're going to pay your 50 Rand to register. And then you have your various options deductions. So it's very simple, it's very straightforward. You can start tracking your expenses. If it's necessary to go to CPP to do your maintenance listing, you can do that. Typically, in the shared parenting calendar, we have preloaded from our experience as mediators what is possible solutions for age-appropriate contact schedules. It doesn't mean that the parent has to work with one of these schedules. Obviously, you can look at it and you can customize the parenting plan that you have in your specific settlement agreement or parenting plan that you do for the children. The one thing that's different in our parenting plan, we did quite extensive research on the color schemes that's available. And none of the color schemes that you can choose, because each child can have a different color, has got any the high conflict colors has been blocked. That's the long and the short of it. So you won't be able to use any high conflict colors like red and things like that. Typically, each child can have a different color. We've seen previously that maybe there's a teenager and there's a 6-year-old. They have different contact schedules. We'd like to see that they both go at the same time every alternative weekend. It's not always practical to do that. You can even go on your calendar and should there be an ad hoc change that you need to make. You can send a request. There's an SMS and a notification that's going to go to other parents immediately, and you can add the event and the parent can approve it without any communication going forward. And it's just a lot easier, especially when you have customized changes that you would like to do. It's just very practical to do this. It's a clear messaging. The one thing that I like about the app is the fact that you can't use emojis. And the language filter, I don't think it's perfect. I have learned a new language in the last 3 years when it comes to harsh words and cruel words and amicable communication. So if you do use the app and you use a swear word that's not been blocked, will you please be so kind to tell us? We would really like to keep the communication as neutral as possible. You can't delete any of the messages. And if it's necessary, we will be able to transcript the messages. Obviously, with the parents' consent, should they have to go to court. So the he said, she said scenario in the mediation room will be, I think, a lot easier going forward if you use the co-parenting app and if you communicate through it. Once you've done your mediation, even prior to the mediation, the mediator or the family professional can be added to the case. So you will have a transcript, or you'll be able to see the communication and what's happening there. And if it's necessary, you will be able to intervene. If it's not necessary, the parties will contact you when you need to actually talk to them. You can share special moments. There's a lot of special moments that we would like to share as parents when the other parent is not available. The first fish, or maybe a tennis match that you've won. And we don't always get the time, or parents forget, or this can be done instantly and it's available. Something that we need to say, it's not available at this stage. We would like to make it available. The next version that's going to come out, your minor is not part of this act. And the main reason for that is we need to find a way to mask the expenses. We don't want the minor children to be part of that communication. We want them to be part of sharing the special moments, maybe adding a rugby match so that mum and dad both get the communication so that they can go to the rugby match. But it's not in this version. So the minor children will not be part of the communication and working with this app. We would like them not to be part of this communication. Now we come to the financial commitments. The financial commitments, let's take the scenario that you've already got a court order, whether it's a divorce order or a maintenance order or a parenting plan. You've agreed on an 80-20 split. Mom will pay 80% of the expenses and dad will pay 20% of the expenses. You will be able to set a calculator. Either parent that's got a medical expenses or educational expenses, they can upload the source document. The calculator later will calculate the other parent's portion, and a notification will go through to the other parent. The one thing that we've seen over the years, especially when we work with rear maintenance, is that parents will come to you or they will say to you, my maintenance is in arrears. It didn't pay school fees, or is behind on the medical expenses, and because there were shortfalls and I paid the shortfalls and didn't share it. Now, record. It's very difficult to try and calculate rear maintenance or even interest on the rear maintenance if you don't have a proper record of what has happened. And I appreciate the fact that as a single parent, time is very limited, and this is very easy to do. So you've got a full history of expenses. You will be able to confirm payment once you've received payment, and it's possible to extract this information should you have a rear maintenance and you need to calculate anything. We will be able to do that for you. We would like to prevent maintenance defaulters to continue to any further credit if their maintenance are in arrears. This is something that we've been doing. It's not something new. Just very quickly, I know I'm almost done when it comes to time. This is typically the process that we're going to follow. We have additional security, specifically because there's minus details that's in the co-parenting app. You will go to the maintenance orders website. The minus details will never be shared with any of the credit bureaus. That's the main thing that you need to know. It's never going to go to any of the credit bureaus. There's 44 credit bureaus. The details will be uploaded. We will communicate through the process of verification with both parents. So nobody's details is going to be submitted to Consumer Profile Bureau without a notification or communication to both parents. We will verify the details, the accuracy of the details, and then the information will be submitted to the Consumer Profile Bureau, which will then do the distribution, as Laurie explained earlier. Typically, this is what your loan process looks like. Any consumer, mom and dad, will go and apply for a Truworths account, cell phone, or home loan, or whatever the case may be. The credit provider will get consent. He will get a credit score. And now the difference is going to be that we will check to actually see if your maintenance is up to date or not. This can be positive and negative. If maintenance is not up to date, I would like to believe that the credit provider is not going to grant you any further credit. But in the end of the day, it's up to the credit provider whether they're going to grant the credit or not. If the maintenance is not in arrears and you are the receiver of the maintenance, it will just put you in another bracket where you will be able to afford that home loan. So that's just something that we also need to keep in mind when we look at this process. The assistance directly, specifically there for not only our parents, but for our professional environment, working specifically with family issues, family mediators, legal matters, and the list goes on when it comes to resources that's necessary for our families to be effective parents. Thank you very much.
Anneke, thank you so much. I think this is such an interesting, piece of technology that, that will change what's going on at the moment. I mean, many parents disappear, and I mean, the courts are looking for them. And yeah, hopefully we wish you the best of success with this project and the Social Justice Foundation at the same time.
Thank you.
Thank you so much, Anneke. Thank you, colleagues. It's amazing what technology has done for us, Ladies and gentlemen, we've now come to our last presentation. And Katherine, this is the graveyard shift, I know. I see in hand before we continue, just give me a second.
Johannes, you have the floor. You can put your mic on.
Yeah, sorry, this was if there's still an opportunity to ask a question for the previous presenter, if you do allow that.
Just hold on. With pleasure. Katherine, you want to give us a second? Well,
Yes, a second, love.
Let me keep the mic to Anneke. Just a second. You can go ahead.
Yeah, it is Johan. Thank you. It's quite plausible, the notion of credit providers being encouraged, or in whatever way
I'm just listening to the question. Wait.
avoiding to give credit to those whose maintenance are behind. One just wonders, should there be a few exceptions to that? For example, credit that is directly related to studies for the independents, for example, especially if it is maybe paid directly to the university or directly to the dependent. Just examples. One can assume that it's, as I'm saying, it's plausible to restrict credit, try to get credit restricted through credit providers to those whose maintenance orders would be behind. It's quite one believes that is something that can go far, but would there be exceptions to the notion, like some types of credit, which is actually to the benefit of the very dependents, to not be restricted by that thing? Thank you.
Okay, as far as I know, at this stage, there's no exceptions. The maintenance, the National Credit Regulations has been amended, and it only says maintenance obligations must form part of your credit profile so that the credit provider can include it when affordability assessment has been done. The reckless credit part is open for discussion, but no, at this stage, there is no exceptions when it comes to rear maintenance.
Good with that, Johan?
Maybe just an opinion on whether it should not perhaps try, what the view is, whether it should actually make provision for a few exceptions, such as those that I'm indicating is to the benefit of the very dependents.
Well, if I can have an opinion, I would say that maintenance should be a preferential claim. And we should pay our maintenance before we pay our car or our home loan.
I agree with you, actually, Anneke. Yes, I think it should be a preferred. What the correct term is? A preferred beneficiary. So, like, I mean, if you don't pay your bond, the bank's the first in line to get their money. In this case, yeah, I think the right thing or should be that the maintenance need to be paid first. It's just my personal opinion. Anneke can...
I absolutely agree with you. It's not been handled like that at this stage. What we see on a regular basis is that we will have people, for example, in a mediation setting, and there will be an increase in maintenance, application for an increase in maintenance. And then the applicant or the receiver, the mom, will receive 2,000 Rand worth of maintenance. Dad can't afford to pay more maintenance because he's got a credit installment with West Bank for his new Ford Ranger for 12,000 Rand. That just doesn't make sense. And that is something that needs to change.
Sorry, just for one quick follow-up. I was exactly not referring to those type of situations where, you know, for a Ford Ranger for himself, so to speak, but for credit that is made directly and clearly and without a doubt to the benefit of the dependent. There are examples where, despite not being up to date with your maintenance, the need, for example, a vehicle for a student child, or for that matter, the study fees, you know, in terms of a student loan, those type of things I was referring to as potential exceptions. So definitely not anything that is for the benefit of either party to the divorce, but specifically for the dependents. Thank you.
Well, I definitely think that you've got a point when it comes to specifically for the dependent, but that's probably going to be on a case-by-case basis. And your credit providers still have discretion if they're going to grant the credit or not.
Thanks, Anneke. Thank you, Jan, for that question. Ladies and gentlemen, it's my pleasure to introduce our next presenter. Her name is Katherine Butler. She's from the Faculty of Law, University of Stellenbosch. Katherine, the floor is yours while I open the slides, and I hope you don't mind. I'll help you scroll through, unless if you've got it available there, I can give you.
No. I would be very happy for you to assist with the slides.
All right.
Yes. So I am from Stellenbosch, and I'm currently an LLD candidate registered in our private law department. And this presentation relates to aspects of my doctoral research, and I'm also an admitted legal practitioner. So my presentation is on the role mediation can play in addressing domestic violence in South Africa. So if you would mind going to slide 3, just to give a brief introduction for the sake of context. So it's now been 30 years since the first piece of legislation aimed at addressing domestic violence in the private sphere took effect. And I therefore think it's quite fitting to examine South Africa's current impetus and renewed vigor with which issues such as gender-based violence, femicide, intimate partner violence, and specifically for the purpose of this presentation, domestic violence are being addressed. So just to quickly touch on the distinction between these related yet distinct terms. Femicide reflects or refers to a specific and more extreme form of gender-based violence, and it is recognized as a hate crime. Gender-based violence is the broadest of the 4 concepts, and it encompasses both femicide and intimate partner violence as specified forms of GBV. Simply put, it can be defined as violence that targets individuals or groups of individuals on the basis of their gender. Now, importantly, domestic violence is less easy to define, and this is, of course, very clear from the Domestic Violence Amendment Act 14 of 2021, which is a very broad definition and includes many different types or forms of violence. Importantly, though, it can be distinguished from GBV and femicide in that it occurs in the private sphere. And it is also distinguishable from intimate partner violence, as if one just looks at the nature of the relationship between parties. Domestic violence, of course, includes violence between family members, whereas intimate partner violence is focused on violence between intimate partners. So the prioritization of addressing the issue of domestic violence at national level is due to several compelling reasons. This would, of course, include the fundamental constitutional rights that are infringed by domestic violence, then also South Africa's international and regional commitments, and then the complex and unique nature of the issue of domestic violence itself, which, as we know, has far-reaching consequences and can permeate society at multiple levels. Then, of course, the increasing incidence of domestic violence. And as we know, this got worse during the COVID-19 pandemic. And then the heightened awareness and activism from civil society in relation to incidents of GBV and femicide, and then the government's national strategic plan in response thereto. In addition to the above reasons, we also have in recent years seen the South African Law Reform Commission that's been conducting research on both ADR in the context of family disputes and on domestic violence, which will hopefully lead to further legislative reform. As recently as August of this year, the Commission released a discussion paper, and it explores various issues pertaining to what South Africa's criminal law response to domestic violence should entail, such as whether or not we should have a standalone offense for domestic violence. And it's also just encouraging to note from the outset that the Commission is in support of a whole of society approach to addressing domestic violence, and they place emphasis on societal and normative change, as well as collaboration between government and civil society. Importantly, this approach acknowledges not only the complex and entrenched nature of domestic violence, but also its far-reaching consequences. And ultimately, in order for victims to have access to justice, they must have means of leaving abusive relationships where necessary, and have the confidence that there will be support structures and laws that will be implemented to ensure their protection where necessary. So moving on to the next slide, slide 5, please. Yes, so just to give a quick contextualization of the two main traditional legal remedies for victims of domestic violence that we have in South Africa, which of course involves the adversarial court system. So the next slide, please. So we have two main legal remedies, and the Law Reform Commission is of the preliminary view that victims of domestic violence should, of course, have a choice of which route that they can follow, whether separately or jointly. And victims may, depending on the particular set of facts, have the option of pursuing both routes, but often, of course, would be unwilling to endure two separate litigation processes, given how time-consuming, emotionally draining, and costly these could be. So just briefly, the first civil remedy is applying for a protection order under the Domestic Violence Act. And as already alluded to, it has recently been amended. The procedure involves an ex parte application for a protection order, and basically, if the magistrate is satisfied that there is prima facie evidence that the requirements have been met, he or she grants an interim protection order. This then remains valid until the return date, on which date the respondent has to show cause why a final protection order should not be granted. In respect of both the interim and final order, the court has broad powers. Then the second route is laying a criminal complaint at your relevant police station, and this could then result in the alleged perpetrator being charged with one or more offences. Now, on to the next slide, please. So both these civil and criminal routes serve different functions. So a protection order, of course, prevents further abuse, and it basically creates a breathing space for the parties, and then a criminal conviction punishes past misconduct. However, both these remedies have fundamental limitations. I think we're on to the next slide. So the fact is they can actually exacerbate conflict between parties rather than actually achieving what they should, which is to protect bona fide victims. So in respect of civil protection orders, the Domestic Violence Act created a system open to abuse. It failed to provide safeguards against vexatious applications being brought, and complainants, often egged on or advised by legal representatives, have brought applications for nefarious reasons, circumventing other legislation, and applying for the respondent to be evicted from shared residence or limiting contact with children. Counter applications by parties have also known to be used as delaying tactics. And other shortcomings, just briefly, include the lack of adequate legal precedents from superior courts, a lack of consistency in different approaches by different magistrates in implementing the Act, and inadequate framework of execution. Then, with the criminal law remedies, problems include the secondary victimization that complainants may experience. Also, of course, the high case withdrawal and the low conviction rate in the context of criminal cases. And this really just adds to the perception of impunity. Cases can't be successfully prosecuted without a witness, and usually then this falls on the victim of domestic violence to actually have to testify in court, which in a formal court proceeding can be quite traumatic. So on to the next slide, slide number 8. We then get to the mediation of domestic violence matters. So a lot of research has been done on mediation in the commercial context and in family law. But even in the latter context, the issue of domestic violence has often been deliberately avoided or downplayed. More recently, and as alluded to in the South African Law Reform Commission, mediation practitioners and researchers recognize that due to the prevalence of domestic violence and the shortcomings of the adversarial litigation process, the issue of domestic violence needs to be addressed further in the context of family mediation. So just for the purposes of this paper, we've of course already heard quite a few definitions of mediation, but I define it as a process in which parties to a dispute, with the assistance of a mediator who facilitates communication and negotiation between the parties, endeavors to reach a voluntary resolution regarding their dispute. So when it comes to suitable styles of mediation, the two main styles which are generally regarded as most appropriate for matters involving domestic violence are facilitative and transformative mediation. Both these styles have elements which could prove advantageous in the context of cases involving domestic violence. Facilitative mediation, of course, is your more classic form of mediation, typically taught to aspiring mediators when they attend a training course on mediation in the context of civil or commercial disputes. Facilitative mediation is focused on the process. The mediator asks questions, validates each party's responses within reason, and facilitates discussion. Control of the solution is maintained by the parties and focuses on the parties' interests rather than focusing solely on their rights. The mediator controls the mediation process while the parties retain control of the outcome. Then with transformative mediation, this focuses more on the relationship between the parties. It aims to transform, reconcile, and improve, or at least to some extent sustain a relationship between disputing parties when appropriate to do so, my addition. The mediator focuses on communication and uses an assortment of skills to persuade parties to communicate, transforming their perspectives and promoting recognition and understanding between the parties and their positions. The parties are in control of any solution and outcome that may be reached, and they also control the process to a somewhat greater extent. This style of mediation emphasizes the process and that the mediator's role should be to create a safe space within which the parties are able to be empowered and communicate. And typically it's also used in victim offender programs. So as evident from these descriptions of styles of mediation, the role of the mediator will differ and depend on their control of the process. The extent of influence also depends on factors including the nature of the dispute and the personality of the mediator and their particular skills and expertise. So this then brings me to the question, I think we're on the next slide, but anyway, yes, sorry. So how important is the style of mediation, and is the mediator able to be truly neutral, which I know was alluded to earlier in the context of arbitrators. So styles and models of mediation create awareness and they enhance our understanding of the process of mediation. But I don't think they should be regarded as set in stone. Most mediators, particularly those who have been practicing for some time and are relatively experienced, tend to adopt more than one style, which is referred to as a mixed process. And I also then refer to a recent unpublished article by Prof. Barney Jordan, The Myth of Mediator Neutrality and Its Implications. And he makes the argument, much in line with the theme of this colloquium, that the ultimate promise of mediation is improving access to justice. Disputes shouldn't be fitted into a straitjacket of a particular model, and instead of fitting the problem to the process, they can be scoped to fit the process to the problem. And as much as mediators need to be perceived as neutral and not taking sides, they should be able to play a role in respect of all dimensions of a dispute if this helps bring the dispute to finality in order for justice to be delivered. So instead of confining their role to merely facilitating the process and overcoming communication barriers while not engaging in substantive issues. So he says instead of fixating on the mediator as a neutral participant, they should have party self-determination as being promoted and central to the mediator's role. So onto the next slide, please, slide 9. To get to the benefits and concerns of mediating matters with elements of domestic violence. So just as a standpoint in South Africa, from a legal perspective, there is no reason why domestic violence matters can't be mediated. However, it does remain controversial amongst some academics and practitioners due to certain concerns, and I would also add sometimes misperceptions. Common arguments against mediating domestic violence matters include that mediation is typically used to resolve conflicts, and domestic violence cannot be merely regarded as conflict between parties. In its truest form, it's understood to involve the need to control and dominate, and there is typically a pattern of abuse, rather than it just being a once-off incident like an assault. Mediation also has a future focus of how to resolve a matter, rather than looking back at the past and what has gone wrong. And this can therefore result in the abusive party being absolved and not taking responsibility for their behavior. Parties also may have unequal bargaining power, and this can create imbalance and cause upset in the relationship dynamic. Then it is also possible for abuse to actually feature during the mediation process itself, And this would involve the abusive partner attempting to continue to uphold control over the victim by making certain conditions. And in this way, the victim could actually become responsible for whether or not further domestic abuse occurs. And then also many argue that mediation is insufficient as it is too much of a short-term process to actually address ongoing abuse. Now we get to the benefits. And the arguments in favor of mediating domestic violence matters include, of course, the relative flexibility and informality of the mediation process, which provides a scope to design the process in a way to protect and support a victim of domestic violence. And this wouldn't necessarily be possible in the adversarial court process. Relationships, as we know, are complex and each one unique, as opposed to being the same. And this is why it's also necessary to evaluate matters on a case-by-case basis. The alternatives to mediation, the adversarial court system, is not geared towards offering support for the victim always. Many victims of abuse are unwilling and unable to testify, as I mentioned, during a criminal trial, and the cross-examination itself can be daunting, disempowering, and they might experience further disempowerment and be dominated still further during this process. Now, another argument in favor of mediation is that, of course, as we know, it's regarded as faster generally, and it should ultimately be less expensive in comparison to the adversarial court process. And linked to this point, mediation, of course, is also regarded as more holistic. There should be the potential to involve additional role players in the process. And the need for a more holistic approach is based on the premise that there is no quick fix for victims of domestic violence, and often mediation may be mutually beneficial when combined with other interventions or programs, such as couples counseling, for example. Now, just to get to the next slide, we are wrapping up. Conditions that need to be met and practical considerations that should be taken into account when mediating such matters. Sorry, the next slide. So firstly, of course, mediation should be voluntary. Mandatory mediation is widely acknowledged as inappropriate in the context of domestic violence, and therefore it should always be voluntary, but also it must be kept in mind that a victim of domestic violence will be particularly vulnerable. They've been in a relationship involving coercion, and they therefore may require additional support and in order to make their own choices and decisions. Any pressure to mediate, no matter how subtle, and whether from the other party or a prosecutor, for example, would be regarded as inappropriate. The victim should freely request to participate in the mediation and provide their consent. It's also ideal if they could provide reasons why they would prefer this option, and the parties must be able to state what they are hoping to achieve through the mediation. They should also be advised to consult with a legal practitioner or a domestic violence services provider. And ultimately, the parties have to be able to reach an uncoerced voluntary agreement. Linked to this is the need to evaluate each case on a case-by-case basis. Not all matters are, of course, suitable for mediation. And such examples I would give is cases involving allegations of sexual abuse, or where safety is potentially a concern, and where the power imbalance is too severe. Then also where abuse has formed an entrenched pattern for several years, and therefore would be very difficult to rectify. So therefore, it becomes necessary to assess the power dynamic between the parties and consider factors such as the duration of the abuse, the severity of it, its frequency, whether substance abuse is a contributing factor, and any other concerns such as mental health disorders or family dysfunctions. Then the mediator has to have a necessary skill set. And basically, they should have received training and expertise where domestic violence has been identified. It is also very important that they have a level of self-awareness to know their own triggers and traumas as mediator, and it's crucial to be able to pick up subtle signs of abuse and what behaviors can be considered appropriate in a relationship. Then, just to touch on the risk assessment screening tools, these are, of course, to ensure the victim's safety throughout the process, my emphasis being on throughout the process. It's important to note that this is not just for the initial pre-mediation phase to assess whether the matter would be suitable for mediation, but it must be conducted on an ongoing basis. And participants in the mediation must be able to assert what they believe is best for them and children, if applicable. So also a pre-screening checklist for assessing the risk, which many mediation services providers would make use of. Measures can also be put in place which enables parties to speak and negotiate for themselves, feel safe and comfortable during and after the proceedings, and they should also be provided with referrals to shelters, legal services, and other organizations where appropriate. Then just the final 2 points on the practical considerations. There is, of course, a benefit in using co-mediators. And for example, they could be male and female, and also with different professional backgrounds, such as a legal background and then a mental health background. And this would certainly be appropriate in cases where domestic violence is more severe. Then also considering the use of shuttle mediation, and this would be useful and practical dealing with cases where domestic violence allegations and one party would feel more able to communicate freely while not in the presence of the other party. And again, this would be appropriate where it is more a case of severe domestic abuse. And it could also be appropriate, of course, where the mediation is being conducted remotely. And finally, just the last slide, the value of incorporating restorative justice. So restorative justice, general point of departure is that it is attentive to the dynamics of domestic violence and centered on the idea of justice that can be providing healing rather than merely just punishing crimes. And looking through a restorative justice lens would be acknowledging that there are needs for sanctions and consequences, but also that offenders need help in changing their actual behavior. Restorative justice essentially asks who got hurt, what harm has been inflicted, what are the needs, and what can be done to prevent such a thing from happening in future, which in contrast to the criminal justice system, mainly just focuses on who committed the crime and how much punishment should therefore be received. And just to also point out, there are examples of restorative justice programs that have been very effective in the context of domestic violence. And in the South African context, these are being done by the Restorative Justice Center, which in as recently as 2020 to 2021, they've had some successful cases. And then there are other jurisdictions such as America, Austria, and New Zealand that also implement such programs. Thank you very much for staying until the graveyard shift, as it was stated. I appreciate everyone's attention and the opportunity to present on a snapshot of my research. Thank you.
Thank you very much, Katherine. I know, things are a little slow in the Western Cape, so there's a comment from Leon Clark. Yes, just a matter of interest, Leon Clark is from a representative from the Law Reform Commission, and she's got a comment. Just give me a second, I'm going to try and get there. She says the SALRC discussion paper on domestic violence, the criminal law response is currently open for comment until the 30th of October. And there's a link there, Catherine. And
Thank you very much.
awesome. I see there's two hands up. You give me a second. Eddie, you have the floor.
Thanks very much, Advocate. I shall just be very brief, considering that we're almost at the tail end. It's just a short comment, and in general, just to say, it has been a privilege to be in this platform, and thanks to Professor Molema who ensured that I'm here, and also to the university. Just out of curiosity, this is the third colloquium. Is there perhaps an indication when can there be the fourth colloquium? There are other various factors which one did not want to interject a lot during the presentations with respect to mediation. My specific interests could have been on the cross-cultural mediation, where there could be foreseeable barriers, when there's mediation, and just to be interested in from the practical experience what the cultural differences would have and the impact that it has. So that's why I'm just inquiring, seeing that it's almost 16:30, that perhaps if there could be an indication, then there could also be discussion in that particular respect. Thanks very much for this opportunity. I appreciate it. Thanks, Advocate. Thank you.
Eddie. I'm going to respond to you. I'm going to allow Jan to ask his question, and then I will respond to you with regards to your comment. That's okay. Jan, you have the floor.
Thank you. The question also serves as an illustration that despite being a graveyard session, the paper was nevertheless no less interesting. So the question is really about whether you have any awareness of research that are aimed at determining percentages or numbers of domestic violence that end up in either murder, the more serious crimes, murder, attempted murder, culpable homicide, and assault, which actually did go through mediation on the one hand, and on the other hand, matters that were never brought to mediation because matters that were brought to mediation, despite there being a history of violence and maybe a chance was taken, what type of percentages there might be of that ending up with mediation successfully and no further domestic violence may have occurred later. If there are not such research available, do you agree at least that such research will be highly beneficial for both mediators as well as others in the criminal justice system? Thank you.
Okay, before I allow Katherine to respond, I'd like to just make you aware that at our second colloquium last year, we had a presentation from the National Prosecuting Authority, where the colleagues were busy with a proposal to the powers above to introduce mediation in criminal matters. I don't know how far that has gone, but it's just to give you some background with respect to that. Katherine, would you like to respond to Jan?
Yes. So I can't say that there is, as far as I'm aware, much research done in the context of, it ending in more serious crimes where the matter was attempted to be mediated. I think in many cases such as that, it is also quite possible that the mediator would probably withdraw from the matter. But I know that there is a fair amount of research where it is regarding protection orders that have been either not made final or they were later withdrawn. And then latterly, there has been a murder or a very serious crime. I know, for example, Lisa Fetton has conducted quite a bit of research in that regard. But I do think there's a lot of value in research like that and looking at the statistics. And hopefully also now with the Domestic Violence Amendment Act and their electronic respiratory system that they're planning to eventually implement, this might also help us with, I think, having more accurate statistics regarding protection orders and, trying to sort of make head and tail of where we are at. Because at the moment, I think it's a little bit difficult.
Johanna, are you okay there?
I'm fine, thank you.
Thank you very much. Eddie, just to respond to your comment, yes, this is our third annual ADR colloquium. Like our research director said, when we opened this morning, just to give you a background of why we're hosting this colloquium, we teach alternative dispute resolution as a final year module in our LLB program, and we fully aware of the fact that not all our graduates are going to get articles of clerkship once they complete their degree. And it is a responsibility of academia and academics themselves to provide our students with additional skills, apart from their degree that they leave with, when they complete the LLB. And the fact that ADR is a final year, ADR is a final year LB module. It is an opportune, way for us to provide them with these additional skills and to expose our students to the practice area of alternative dispute resolution. So yeah, we just trying to make them aware of, what different things they could do or what different opportunities they could create for themselves, apart from going to become, a legal practitioner in the sense of going to courts and etc., or even to, give them a stepping stone to build up some kind of experience prior to getting into the legal profession. The intention is to eventually grow this into a full conference. We need to express the fact and remind the powers above, the DOJ, the Constitutional Court. In fact, mediation now falls under the Chief Justice's portfolio and no longer the DOJ. To also get practitioners to realize it's not about the billables, and we need to move away from that idea, and instead of holding on to matters for 3 and 4 years, we can resolve these matters and reduce the court rolls faster. So yes, there's a long fight ahead of us. We're nowhere close to getting where the ideal situation is, but that's why we've invited organizations like the Social Justice Foundation and people from practice like Eugene Opperman and academia and NGOs to come and raise the voice and make ADR feature. I hope I've answered your question, Eddie.
Thanks very much, much appreciated.
100%.
Well explained. Yes, I'm very content. Thanks very much.
No, we're extremely passionate about ADR here. Well, it's, and I must say, in closing, ladies and gentlemen, I'd like to express my sincere appreciation to all of you who have spent the day with us, to our, our presenters who have put in all this effort to come and present at our colloquium today. It would be amiss of me if I don't express, appreciation for the people who made this possible for me today. And I'd like to firstly thank my dean, Dr. Morei, for the opportunity for us as academics to express ourselves and, to create these opportunities for us and expose our students at the same time to what's out there in the our area of practice. I'll also like to express my sincere gratitude to Professor Mitzi, who is our director for research, who's made these platforms available to us, so that we can, we can engage with people from practice, with different organizations, with academics. Yeah. Also, there's two other people that I cannot end this, colloquium without thanking. One is Ms. Greyvenstein. Without her, I think we wouldn't have achieved much today. And Ms. Sarita Morei, who's always there supporting us in whatever way possible. And lastly, my mentor, Prof. Jan Erlang, for his support and guidance always. Thank you very much, ladies and gentlemen. I sincerely appreciate your indulgence today, and we will be in touch. We've got your details. I see a hand up there, Rian. You have the floor.
Wrong button.
Yeah, okay. All right. Yes. I'd like to also just thank Juta and Oxford for always being available to us and supporting us in all our endeavors. Thank you very much, everyone. Stay blessed, and we will be in touch. All the best, ladies and gentlemen. Take care. Bye-bye.
Thanks very much.